Hello, hello. ನೀವು ಬನ್ನಿ ಈ ಕಡೆ. ವೆಯ್ಟ್, ನೀವು ಮಧ್ಯದಲ್ಲಿದ್ದೀರಾ, ಇರಿ. ಎಸ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿಯಲ್ಲ. Whoever it is, fresh matters give.
13 for a framing of charges. That is
ಕೊಡಿ. ಅದು ಟುಮಾರೋ ಆಗಿದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಕಾಂಟ್ ಹೆಲ್ಪ್. ಕೊಡಿ. ಎಸ್,
otherwise it will become instructive.
ಟುಮಾರೋಗೆ ಆಗಲ್ಲ, ಮಂಡೇನೆ ವಿಲ್ ಸಿ. ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಆರ್ ಫ್ರೆಶ್? ನೋ ಟುಮಾರೋ. ಮಂಡೇ, ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ. ಗಿವ್ ಇಟ್.
That's 230.
Monday, Tuesday, Wednesday. Monday it's already full, madam. Tuesday or Wednesday it will come. Give it. Give it.
That's fresh matter 230.
Please. Why are men standing here? Come this side. ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಲ್ವಾ?
My lords, fresh matter 230. My lords, maintenance agreement.
And ನೀವು ಮ್ಯಾನ್ ಅಲ್ವಾ? ಸರ್ ಈ ಕಡೆ ಬನ್ನಿ. ಇನ್ಮೇಲೆ ಬೋರ್ಡ್ ಹಾಕ್ಬಿಟ್ರೆ ತಪ್ಪಾಗುತ್ತೆ ಅಂದ್ರೆ ಇದು ಅನ್ನ ಹಾಕ್ಬೇಕಾಗತ್ತೆ ಈಗ. ಎಸ್,
230.
ಪ್ಲೀಸ್ ಗಿವ್ ಮೇಡಮ್. ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಕಮ್. ಗಿವ್ ಇಟ್. ನೋ ಡೇಟ್. ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಬಿಗ್. ಇವತ್ತು 25. ನೋ ಟುಡೇ ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್ 25. ವಿಲ್ ಯು ಲಿಸನ್? Today no stay matters are listed. 25 matters are there. It will be listed every day. Please give.
That's at 230, my lords. Maintenance agreement, maintenance ilan purely civil dispute or company staff ke there FIR has been lodged.
Tomorrow.
230, my lords.
Tomorrow.
230, my lords.
Tomorrow.
Urgency is this, my lord. A 498A case against the in-laws, my lord. A similar complaint, my lord.
Oh, no problem.
Already stated
No
the matter
urgency.
and
Kodi.
the in-laws are cancer patients, my lord.
ಅಯ್ಯೋ ಅದಕ್ಕೆ ಬೇಲ್ ತಗೊಳ್ಳಿ. ಎಸ್, ಕೊಡಿ. Monday, Tuesday.
My lord,
498 ಅಲ್ಲಿ emergency.
For a news,
ಕೊಡಿ. Yes.
my lord, for a news report on a government doctor, case of molestation has been filed. The reporter is not being allowed to perform his, he's not being allowed to work. May I please request for tomorrow,
Pending
my lord?
fresh?
Fresh matter, my lord, fresh. absolutely.
Monday or Tuesday?
Tomorrow, my
No,
lord, please. I
nothing.
request for tomorrow, my lord.
Nothing. No urgency.
My lord, the reporter is not being, he's being made to sit in the police
No
station
problem.
also.
Case of molestation of a doctor.
No, it is a news report on a government doctor performing his duty and the
We'll
news
see.
report has been made a ground for molestation.
No problem. We'll
My
see.
lord, would please consider tomorrow.
Monday or Tuesday. Yes.
Settle, my lord, for reporting.
When do you want? When do you want it? Fast, fast. Give it. Hand over.
Today.
Retired labor commissioner is arraigned.
Why are you pushing everybody? Wait. Madam, retired labor commissioner. Wait. Yes.
Your lordship, 230, your lordship. There's urgency in the matter. Warrant has been issued.
230.
My lords, 230, my lords, one.
ನಿಮ್ದು
FIR
warrant
comes- No, my lords,
ಮತ್ತೆ?
one FIR comes to be filed, there's a B report filed, my lords. Subsequently, another one is filed, there they file a charge sheet, my lords.
Question in counter case?
No, my lords.
All right, Monday.
My lords, 230.
No 230.
My lords, in this itself, since he that he is a student, the petitioner is a student. So
So?
kindly for 230, my lordship,
Fresh matter.
fresh matter.
My lord's passport, my lord's for job
FR?
purpose.
FR number ಇದ್ರೆ ಬರೋ ಏನು ಎರಡು ಮೆಮೊ ಯಾಕೆ? ಮೂರು ಸ್ಟೂಡೆಂಟ್ಸಾ?
ಹೌದು.
ಒಬ್ಬರು ಸ್ಟೂಡೆಂಟ್ ಕೊಡಿ ಇವತ್ತು, ಮಿಕ್ಕಿದ್ ಕವರ್ಡ್ ಆಗುತ್ತೆ. Yes.
My lord's passport, my lord, for job purpose. He has been selected in from the campus, my lord, for job purpose.
Tuesday ತಗೊಳ್ಳಿ.
My lord, the framing of charges. today.
When?
So next week, my lord.
Next week ತಗೊಳ್ಳಿ.
Your lordship.
Unless you know the date, please don't tell me
Today
this.
itself, my lord.
No.
Your lordship,
Give it next week.
your lordship, retired labor commissioner has
Wait,
been.
you pushed everybody and came. Wait. Yes.
My lords, for 230, the matter is for framing of charges tomorrow before the trial.
230.
My lordship, it is section 21 of.
My lord, it's a pending,
ಏನು? Yes.
my lord, it's a pending matter, my lord. Why I'm troubling your lordships is this, my 44 lakhs of my amount is, my lord, is freeze. The magistrate, my lord, passes a wrong order. I'm the complainant. He records me as the accused. Now, the urgency is, my lord, that.
Complainant is recorded as an accused
Now, my lord, that's what's causing the urgency.
tomorrow.
Grateful.
My lordship, it is section 21 of POCSO, my lordship. Other matters were also stayed before your lordship, my lord.
Give it.
Tomorrow, my lordship.
Monday or Tuesday.
Your lordship, retired labor commissioner has been arraigned as accused for recording settlement in an employer-employee dispute, my lord. Your lordship may kindly have it on Monday.
Monday.
My lordship.
Directed one recall matter to be listed today. Same has got not
Not
listed,
come.
my lord. My lord, we kindly take it up along with that detention matter tomorrow. Lord, same is coming up tomorrow.
Tomorrow ಇದೆಯಾ?
Tomorrow, that is listed for tomorrow. my lord.
You should learn of Kannada now. You are appearing so much here.
Lordship,
Yes, tomorrow.
My lordship,
Give it.
Of like,
vacating stay, my lordship,
Vacating
it
stay,
was
give it.
2016 matter.
ಕೊಟ್ಬಿಡಿ. Now
Your lordship, only
women
submission
stop.
is that, my lordship.
All women stop. tomorrow 2:30. Tomorrow. Sorry, for what? Huh? Oh, ಕೊಡಿ ಅದು ಎಲ್ಲಿ ಮಿಸ್ ಆಗೋಗಿತ್ತು ಕೊಡಿ ಒಂದು ನಿಮಿಷ ಮೇಡಮ್ ಅದು ನಾಳೆ ಹಾಕಿ ಅದು ನಾಳೆಗೆ ಹಾಕಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಕೊಡಿ how many can I take on Monday? How many can I take on Tuesday? I'll take it, give it. No problem, give it. Give all the fresh matters ಕೊಡಿ. All the fresh matters ಕೊಡಿ. All fresh matters ಕೊಡಿ. SC/ST wait, all fresh matters ಕೊಡಿ. Wait, pending I'll come wait. Fresh ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ನಾಳೆ ಒಂದೇ ದಿನ ಇರೋದು ಫ್ರೆಶ್ ಎಲ್ಲ ಕೊಡಿ.
Monday.
ನಾಳೆಗೆ ಯಾವುದು ಆಗಲ್ಲ ಕೊಡಿ.
Monday,
Unless there is grave urgency. Wait. General fresh matters ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
One day account has been freezed by the Lokayukta.
ಕೊಡಿ ಲೋಕಾಯುಕ್ತ ವೆರಿ ಗುಡ್ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್
Against the compensation amount received by the land loser.
ನೋ ಪ್ರಾಬ್ಲಮ್.
Already stay has been granted in that claim. Monday.
ಯಾವುದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಎಲ್ಲ ನಾಳೆ ಕೊಡಿ. ವಿಚ್ ಎವರ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ದೇರ್ ಪ್ಲೀಸ್ ಗಿವ್. ಆಯ್ತು ಎಲ್ಲರಿಗೂ 2:30 ಬೇಕಾ ಈಗ ಮತ್ತೆ ಟುಮಾರೋ ಇಲ್ವೇ ಇಲ್ಲ ಫ್ರೆಶ್ ಎಕ್ಸೆಪ್ಟ್ ಫ್ರೆಶ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಟುಮಾರೋ ನೋ ಅದರ್ ಮ್ಯಾಟರ್ ಗಿವ್ ಇಟ್ ಕೊಡಿ. ಈಗ ಒಂದ್ ನಿಮಿಷ ಒಂದೊಂದು ಲೈನ್ ಆಗಿ ಬರ್ತೀನಿ ಹಿಂಗಾದ್ರೆ ಆಗಲ್ಲ ಹಿಂದೆ ಹೋಗಿ. ಆಲ್ ಆಫ್ ಯು ಗೋ ಬ್ಯಾಕ್. ನಾವು ಫಸ್ಟ್ ಲೈನ್ ತಗೊಳ್ಳಿ. ಕಮ್ ವೈ ನಾನು ಟೈಮ್ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ ಡೆಪಾಸಿಟ್ಗೆ. ಐ ವಿಲ್ ನಾಟ್ ಡೂ ಎನಿಥಿಂಗ್. 2:30 ಗಿವ್ ಇಟ್ ಪ್ಲೀಸ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅದು ಪೆಂಡಿಂಗ್ ತಾನೇ ಅದು ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಹಾಕಿ ನೋ ಸ್ಟೇ ಬರುತ್ತೆ ಕೊಡಿ. ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಆಯ್ತು ಕೊಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಅಟಿಕಾ ಗೋಲ್ಡ್ ವೆರಿ ಗುಡ್. ಏನಾಯ್ತು? ವೈ 2:30 ಅಟಿಕಾ ಗೋಲ್ಡ್ ಅಂತನಾ? ಪೇರೆಂಟ್ಸಾ? ನಾಳೆ ಅಟಿಕಾ ಗೋಲ್ಡ್ ಟುಮಾರೋ. ಎಸ್ ಲೈನಲ್ಲಿ ಇದೆ ಮತ್ತೆ ಹಿಂದೆ ಬಂದಿಲ್ಲ. ವೈಟ್, ಡೋಂಟ್ ಕ್ರಿಯೇಟ್ ಕೇಸ್. ಕೊಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್ ವೇಟ್ ಮಾದೇವ್. ವಾರಂಟಾ? ವೈ? ಬಹಳ ಸಂತೋಷ ಕೊಡಿ. ನೋ 2:30 ಆಯ್ತು ಕೊಡಿ. 2:30 ವೇಟ್ ಹಿಂದ್ಗಡೆಯಿಂದ ಯಾರು ಕೊಡಬೇಡಿ, ತಗೊಳಲ್ಲ ಕೊಡಿ. ಫಸ್ಟ್ 2:30 ತಗೊಳ್ಳಿ.
The predicate offense was not confirmed in Supreme Court. PMLA proceedings are pending. There is no stay.
Give it. Next week we'll fix it.
Officers were their harassment word.
Tomorrow ಆಗಲ್ಲ. Tomorrow for special court. Monday or Tuesday or Wednesday.
Tuesday or Wednesday.
Yes.
That's fresh matter. Civil dispute is pending from 2 years. Now the defendant has given a complaint, my lord.
ಕೊಡಿ.
Monday, my lord, fresh matter.
No,
Petitioner is
Monday
lady.
1000 ತಗೊಳಕ್ ಆಗುತ್ತೆ ನಂಗೆ. ಕೊಡಿ ಇಲ್ಲಿ.
Tuesday at least.
Tuesday 160 ಇದೆ.
Police have issued a notice.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್ ಸುಮ್ನೆ.
My lord, fresh matter.
Wednesday
Error
or
was in the civil dispute.
Wednesday or Thursday ಬರುತ್ತೆ.
Please, fresh matter.
Atrocity Act, my lord. I am for the complainant. Vacating stay application ಹಾಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಯಾವಿದೆ ಕೊಡಿ. ಒಂದು ನಿಮಿಷ ವೇಟ್ ಅದು ರೋ ಅಲ್ಲೇ ಬರೋಣ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಹಾ
2025 matter pending ಇದೆ ಸ್ವಾಮಿ.
ಕೊಡಿ ಸರ್.
Application for stay pending ಇದೆ sir.
ನೋ ಸ್ಟೇ ಇರವೆಲ್ಲ ಹಾಕಿಸ್ತಾ ಇದ್ದೀನಿ ಕೊಡಿ. ನೀವು ಏನು ಕೆಲಸ ಮಾಡಕ್ಕೆ ಬಿಡಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಮೆಮೋ ಮಾಡಿ. ನೋ ಕೈಂಡ್ಲಿ. ಎಸ್
2:30.
ವೈ?
Tomorrow there is defense evidence. The earlier complaint was filed and
ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್?
ಇಲ್ಲ.
ಮತ್ತೆ ಏನದು ನಿಮ್ದು? ಆರ್ ಯು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್? ವೇರ್ ಇಸ್ ಯುವರ್ ಬ್ಯಾಂಡ್? ಗೋ ಔಟ್ ಅಂಡ್ ವೇರ್ ಯುವರ್ ಬ್ಯಾಂಡ್ ಅಂಡ್ ಕಮ್. ಸಿಟಿ ಮಾರ್ಕೆಟ್ ಅಲ್ಲ ಇದು.
My lord.
ಎಸ್ ಆಯ್ತು ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
Hearing before.
ನೆಕ್ಸ್ಟ್ ರೋ ಫುಲ್ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
One matter for 2:30.
ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಯಾವ್ದಿದೆ? ಎಷ್ಟಿದೆ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಇಲ್ಲಿ? ಸುಮ್ನೆ ಹೇಳಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇಯರ್ಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ. ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಯಾವ್ದಿದೆ ಕೊಡಿ. ವೇಟ್ ವೆಲ್ಕಮ್. ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಯಾವ್ದಿದೆ ಕೊಡಿ. ನಿಜವಾಗ್ಲೂ ಇದೆಯಾ? ಎಸ್. ಅಟ್ರಾಸಿಟೀಸ್ ಮೇಡಮ್ ಎಲ್ಲ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕಿ. ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಇಲ್ಲ ಅದರಲ್ಲಿ ಅಂದ್ರೆ 2027ಗೆ ಹಾಕದ್ ನಾನು. Yes.
My lords, the matter for 2:30, my lords. My lords, in the
Why?
main matter, already stay has been
No
granted,
problem.
my lords. It's
Monday
like
or
this.
Tuesday.
My lords,
My lords,
kindly
I
have it at
think,
2:30.
yes.
Please, my lords, Monday,
No
Monday, my
problem.
lords.
No,
please.
no, no.
My
Monday.
lords,
No problem. No. No problem. Monday or Tuesday.
my lords had directed this matter to be listed today.
No direction, give it, sir.
My lords, the matter
My lords.
is listed.
Give it. Ex-girlfriend, ಕೊಡಿ sir, ಪರವಾಗಿಲ್ಲ.
My lords, the matter.
ಎಲ್ಲ next week ಕೊಡಿ. All matters next week. Atrocities ತಗೊಂಡಾಯ್ತಲ್ಲ, settlement ಇನ್ಯಾವಿದೆ ಕೊಡಿ.
My lords,
Settlement and vacating stays, please give.
My lords had directed this matter.
Vacating, ನೀವೇನ್ ಮೆಮೋ ಕೊಟ್ರು vacating stay ನಾನು ಹೆಂಗ್ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ ಹಂಗೆ ಬರೋದು. So no use, give it anyway. ಏನಾರು ಇರ್ಲಿ ಕೊಡಿ sir.
Lords, the vehicle release matter, it was listed.
ಅದು ಕೊಡಿ sir, ಪರವಾಗಿಲ್ಲ.
My
Give.
lords had directed this matter to be listed today.
No problem, give it.
My lords,
My lords had
Give it, sir.
issued notice, my lords had issued notice and directed.
Will you please give the memo? If you want, give the memos or take the memos and go back.
my lords,
All memos ಕೊಡಿ.
my lords.
ಈಗ ಒಂದ್ ನಿಮಿಷ, ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ಒಂದ್ ನಿಮಿಷ, ಏನ್ ಬೇಕು? ಡೇಟ್ ಬೇಕಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಮಂಡೇ ಆಗದೇ ಇಲ್ಲ, ಟ್ಯೂಸ್ಡೇ 160 ಇದೆ ಆಗದೇ ಇಲ್ಲ, ವೆಡ್ನೆಸ್ಡೇ ಥರ್ಸ್ಡೇ ಫ್ರೈಡೇ ಬರುತ್ತೆ, ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಲ್ಲ, ನೋ ಸ್ಟೇ ಇದ್ರು ನಾನು ಹಾಕಿಸ್ತಾ ಇದೀನಿ ಅಷ್ಟೇ. ಇನ್ನೇನ್ ಬೇಕು? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹ್ಯಾವ್ ಟೇಕನ್, ಸೆಟಲ್ಮೆಂಟ್ ಹ್ಯಾವ್ ಟೇಕನ್. ಎನಿ ಅದರ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್? ನೋ 230. ಏನು ಏನ್ ಅರ್ಜೆನ್ಸಿ? 138 ಮ್ಯಾಟರ್ ಅರ್ಜೆನ್ಸಿನಾ? So
them agreeing to withdraw the matter, we made the payments, my lords. Now, on the date of hearing the result from the settlement, due to which NPWs has been issued again.
230.
My lords, my lords.
Why? Yesterday? Where? Where? I will not take coordinate bench dates, please. The next 2 weeks ಬಿಟ್ಟು ಹಾಕಿ. Nothing doing. ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ? ಅವ್ರೇನ್ ಮಾಡ್ಲಿಲ್ಲ, ನೀವ್ ಇವತ್ತಿಗೆ ತಗೊಂಡಿದ್ದೀರಾ. Nothing doing. ಪರವಾಗಿಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಬೇರೆ ಕೋರ್ಟ್ ಕೊಟ್ಟಿರೋ ಡೇಟ್ ನಾನು ತಗೊಳಲ್ಲ. ಇಲ್ಲ ಸರ್. ಹೌದು, ಯಾಕೆ ಮತ್ತೆ ಅಲ್ಲೂ ಮಾಡಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಲ್ಲ, ಮತ್ತೆ ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರಿ? ಕೊಡಿ, ಬರುತ್ತೆ ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ. ನೋ 230. ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ನಾನು ಅದನ್ನ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಸರ್. Go to the Supreme Court. No sir, I will not take it. I will not take. Yes.
My lord, petitioner is.
ಬೇರೆ ಎಲ್ಲ ಮೆಮೊ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ?
My lord, matter is.
ಈಗ ಮೆಮೊಗಳು ಕೊಡ್ತೀರಾ ಇಲ್ವಾ?
My lords, the matter is listed.
My lords.
No 230, no Monday, Tuesday, Wednesday, Thursday, Friday ಅಂತ ಯಾವ ಭಾಷೆಯಲ್ಲಿ ಹೇಳಿ ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಹೇಳಿದೀನಿ. ಇನ್ನೂ ನೀವು ಕೇಸ್ ಮಾಡಿದ್ರೆ ನಾವು ಒಂದ್ ಮೆಮೊನು ತಗೊಳ್ಳಲ್ಲ. ನೋ ವೆಹಿಕಲ್ ರಿಲೀಸ್, ಬೆನ್ಸಾ ಕೊಡಿ. ಮಂಡೇ, ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆನ್ಸ್ಡೇ ಕೊಡಿ. ಏನಾದ್ರೂ ಇದ್ರೆ ಕೊಡಿ. Will you please give the memo? If you want, give the memo, give the memo.
Wednesday date kodi, my lords.
Call the cases, please.
This is for my lords.
Call the cases.
My lords.
Being spoken to other.
My lords, charge sheet.
Entire order sheet ಆಗ್ತಾ ಇದೆ.
Yes, give it.
Entire order sheet ಆಗ್ತಾ ಇದೆ.
Call the cases, madam.
My lords, please.
230, no 230, no Monday, no Tuesday, Wednesday, Thursday, Friday ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರಿ. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್, ಏನ್ ಪರವಾಗಿಲ್ಲ ಸರ್, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಸ್ವಾಮಿ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು
ಏನ್ ಬೇಕಾದ್ರೆ ಹಾಕಿ.
ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ 13 ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ.
ಹಾಕಿ ಸರ್.
Petitioner is a cancer patient.
No problem, give it. Nothing doing. No, give everything. Give all the memos. Call the cases.
Wednesday date on kodi.
Give all the memos, please. No, I'm saying no means no. Give it. No, nothing doing. Yes. All Wednesday ಆದ್ಮೇಲೆ. Vacating stay, please give. Whatever. I'll get no dates on vacating stay. No dates on vacating stay. Yes. No dates on vacating stay. No dates on I told you no dates on vacating stay. Yes.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ.
ರಿಜಿಸ್ಟ್ರಿ ಇಲ್ವಾ?
ಅಲ್ಲ,
ಇದನ್ನ ರಿಜಿಸ್ಟ್ರಿನಾ?
ಹಂಗಲ್ಲ ಸ್ವಾಮಿ,
ಹೋಗ್ ಫೈಲ್ ಮಾಡಿ ಅಲ್ಲಿ.
13ನೇ ತಾರೀಕು ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ.
ಹೋಗ್ ಫೈಲ್ ಮಾಡಿ ಅಲ್ಲಿ.
ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದೀನಿ. 13ನೇ ತಾರೀಕು ಡೇಟ್ ಇದೆ. ಸ್ಟೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಇದು ಕೌಂಟ್ರಾ? ಇದು ಕೌಂಟ್ರಾ?
ಕೌಂಟರ್ ಅಲ್ಲ
ಕೋರ್ಟ್ ಅಲ್ಲ ಕೌಂಟ್ರ ಇದು.
ಅಲ್ಲ ಸ್ವಾಮಿ ನಿಮ್
ಹೋಗ್ ಮಾಡಿ ಅಲ್ಲಿ.
ಪಿಟಿಷನರ್ ಎಲ್ಲ ಕೌಂಟರ್ ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ ಇದು
ನೀವು ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಕೌಂಟರ್ ಅಲ್ಲಿ?
ಕೌಂಟರ್ ಮಾಡ್ತೀನಿ
ಮಾಡ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ 13ನೇ ತಾರೀಕು ಡೇಟ್ ಇದೆ ನೀವು
All the cases will stop taking memo from tomorrow. ಎಲ್ಲ ಅದ್ರ ಪಾಡಿಗೆ ಅದು ಬರುತ್ತೆ. From tomorrow no memos sir. Yes, serial number 1, who is this?
one submission
Come on, I'm nothing doing. Yes, give it. ಯಾವ್ದಾರ ಇರಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ. ನಿಮಗೆ ಯಾವ್ದಕ್ಕೂ ಕನ್ಸಿಡರೇಷನ್ ಇಲ್ಲ, ನೀವು chaos ನಿಲ್ಸಲ್ಲ, ನೀವು ಡಿಸಿಪ್ಲಿನ್ ಇಲ್ಲ, ಇಂಪಾಸಿಬಲ್ ಟು ಫಂಕ್ಷನ್ ಇಫ್ ಯು ಆರ್ ಲೈಕ್ ದಿಸ್. ಸಾಧ್ಯವೇ ಇಲ್ಲ, ಬಿಟ್ಬಿಡಿ. ನಾಳೆಯಿಂದ 3 ಲೈನ್ ಮಾಡಿ ಲೈನ್ ಬೈ ಲೈನ್ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತೀನಿ. ಈ ತರ ಆದ್ರೆ ಆಗೋದೇ ಇಲ್ಲ. ನಾಳೆಯಿಂದ ಮೇಕ್ ಅ ಲೈನ್ 1, 2, 3. ಡೋಂಟ್ ಸ್ಟ್ಯಾಂಡ್ ಲೈಕ್ ದಿಸ್ ಎಟ್ ಆಲ್. ಮೇಕ್ ಅ ಲೈನ್, ಐಲ್ ಟೇಕ್ ಅಂಡ್ ಸೆಂಡ್ ಇಟ್. ಹಿಂಗಿದ್ರೆ ಏನ್ ಮಾರ್ಕೆಟ್ ಆಯ್ತು ಇದಕ್ಕಿಂತ ಹೋಲ್ಸ್. ದಿಸ್ ಇಸ್ ನಾಟ್ ದಿ ವೇ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ತರ ಆಡ್ತಾ ಇದ್ದೀರಾ. ನೋ, ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ಎಸ್, ನೋ ಸರ್, ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ನಾಳೆಯಿಂದ ಯು ಮೇಕ್ ಅ ಲೈನ್. ಇಫ್ ದೇರ್ ಇಸ್ ನೋ ಲೈನ್, ಐ ಆಮ್ ನಾಟ್ ಟೇಕಿಂಗ್ many members. No 230 sir. No urgency. Yes. Nothing doing. Nothing doing. Yes. Call the cases please. ನೀವು ಏನ್ ಹೊಡೆದಾಡ್ದು ತಗೊಳ್ಳಲ್ಲ.
Next matter still number 1.
Memo ಕೊಡೋದು ಕೊಡಿ. Will you please give the memo or not? And stop this now.
Lordship, one submission.
Please move. ಅದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ ಬಿಡಿ. Yes.
I am for the petitioner, Lord.
My lords, FIR is challenged, charge sheet is filed, my lords. First, serial number 1.
ಮೇಡಮ್, ನಾಳೆಯಿಂದ ಲೈನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ಯಾರು ನಿಲ್ಸ್ಬೇಡಿ. ಒಂದ್ ಮೆಮೊನು ತಗೊಳ್ಳಲ್ಲ. ಪ್ಲೀಸ್ ಸ್ಟ್ಯಾಂಡ್ ಇನ್ ದಿ ಲೈನ್. ನಿಮ್ಗೆ ಅದೇ ಸರಿ. This will limit to chaos. ಏನ್ ಫಸ್ಟ್ serial number 1?
Serial number 1, my lords, FIR is challenged. Now the charge sheet is filed.
Charge sheet format, yes. Yes, in terms of the memo.
Lord, for the petitioners in this case, my lord, the daughter-in-law has dragged all the father-in-law, mother-in-law, sister-in-law.
85 in the meantime. Next.
Number 3.
OS number.
My lord, serial number 3, I am appearing for respondent number 2.
I have not yet issued notice. You can't appear like
My lord,
that.
I am
This is not
appearing-
caveat jurisdiction, sir.
No, caveat alla, objection ಆಗ್ತಾ
This is
ಇದೆ.
not caveat jurisdiction. There is no caveat in 482. So if you have notice ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ.
There is a civil dispute pending, my lord, there I am making a submission.
No, I am not going to hear you. Period. Yes.
There is a civil dispute pending between the parties, my lord. OS number 25,358/20. Filed against
One
respondent.
HCGP to emergent notice.
And stay may be.
Next.
Petitioner is case. 311 application, Lordship. 302 offense, PW2 and PW8.
Will allow this.
Lords, 311 application was filed after the completion of 313 statement.
302, sir. Yes. 311 application is a offense 302. The petitioner is before the court calling in question an order dated 20th May 2026 by which an application under section 311 comes to be rejected. Heard so and so. Facts in brief germane are as follows. The petitioner gets embroiled in a crime. In crime number
58 of 2022.
58 of
22.
58 of 2022 for offense punishable under section 302 of the IPC. The issue in the list does not pertain to the merit of the matter. The petitioner files an application seeking recall of PW2 to PW8 for further cross-examination. The same comes to be rejected on the score that long before the opportunity that was granted to the petitioner for further cross-examination is lost. In that light, the learned counsel for the petitioner submits that he is facing charges for offense punishable under section 302 of the IPC and POCSO illa tane?
Illa sir, POCSO. POCSO illa sir.
302 of the IPC and therefore the 302 of the IPC, therefore the application ought to have been allowed as if the petitioner would be held guilty without further cross-examination, it is likely to end up in a punishment which is end up in life imprisonment. The learned HCGP would however refute the submission on the score that the petitioners have filed said application at the fag end of the trial and therefore it should not be permitted. I have given my anxious consideration. Therefore, narrated facts are not in dispute. They lie in a narrow compass. The petitioner is facing allegations for murder. Therefore, it is the ground on which the reason rendered by the concerned court to reject the application is as follows. The reason rendered by the petitioner for seeking further cross-examination would far outweigh what the concerned court has held as quoted herein above. The purport of section 311 Varshagar quote ಮಾಡಿ. In that light, the petition deserves to succeed. The petition is allowed. The application so and so filed by the order quashed. Application filed by the petitioner so and so stands quashed. The petitioner shall be permitted to further cross-examine PW2 to PW8 on the dates fixed by the concerned court. The concerned court shall see to that the allowing of the application would not be taken as a ruse to drag the proceedings. Please ordered according. Next. MMDR 3082, Learned HCGP is directed to accept notice for the respondent, secure instructions and make submissions. Next.
6.
For the petitioners.
One HCGP, 2 emergent notice.
In respect
No.
make one request.
Much
earlier
case and counter case.
Earlier to lodging the complaint on 23/1/2026.
No problem.
One
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಸರ್? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್
ಇದರಲ್ಲಿ ಸ್ಟೇ ಮಾಡೋ ಏನಿದೆ ಸರ್ ಹೇಳಿ ಸ್ವಲ್ಪ ಬನ್ನಿ ಸರ್.
6%
ನೋ ಪ್ರಾಬ್ಲಮ್. ನೋ ಪ್ರಾಬ್ಲಮ್. ಕಮ್ ಟು ಪೇಜ್ 17 and 19. ಸ್ಟೇ ಮಾಡಕ್ಕೆ ಏನಿದೆ ಸ್ವಲ್ಪ ಹೇಳ್ಬಿಡಿ ಸರ್.
ಅದರಲ್ಲೇ ನೋಡಿ ಸರ್.
ಏನು ಅದರಲ್ಲಿ? Offense 118 sir.
Page 17 mala.
Offense is 118 sir.
That is true mala.
Yes sir.
Then mala it is this thing.
No sir, nothing. Yes. Without charge sheet I will not stay 118 306L. Yes, next.
7.
Tag the petition with the criminal petition 4089 of 2026 same order. Next.
8.
Well, I am for the respondent number. Respondent number 2, your lord.
Have I issued notice?
No, your lord.
Yes. Wait sir. The petitioner is before the court calling in question the proceedings in crime number 122 of 2026. The issue revolves around the complaint registered by on a family tree issued by the deputy Tahsildar. The petitioner applies for Khata on the strength of the said family tree. The complainant appears before the Tahsildar and files his objections. The Tahsildar disposes the matter, directing the parties to approach the civil court. The complainant then approaches the deputy Tahsildar again by filing a representation seeking cancellation of the family tree, notwithstanding the earlier order. On conducting an inquiry, it transpires that the Deputy Tahsildar rejected the request and confirmed the earlier order of the parties to approach the civil court by way of an endorsement inter alia, finding that the family tree was correct. It is challenged before the Assistant Commissioner. The Assistant Commissioner then passes an order to direct effect of Khata in the name of the petitioners. Immediately thereafter springs the impugned crime on 26/5/2026, alleging forgery and cheating. In the teeth of the aforesaid facts, if further proceedings are permitted to continue, it would become a classic illustration of the crime being registered as a counterblast or in an issue that was purely civil in nature. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner to the further investigation qua the petitioner till the next date of hearing. Next.
9.
The petitioner is before the court calling in question registration of a crime in crime number 340 of 2025, registered for several offences, including the ones under the Atrocities Act. The second respondent is the complainant. The second respondent was a teacher in the government junior college and high school Pandavapura. She is transferred and on to wreak vengeance on the transfer that is initiated by the present petitioners, by several petitioners. She has drawn accused 1 to 11, even including offences under the Atrocities Act. The present petitioners are accused 10 and 11, finding not even a titter of offences against the petitioner permitting investigation would be putting a premium on misuse of the law by the complainant. Therefore, there shall be an interim order of stay of further investigation qua the petitioner till the next date of hearing.
376, my lord, and now is before the
Sorry?
sessions court. Offense is 376, my lord.
Correct. You are accused number 2.
Yes, my lord. She is the wife of
2016 ಯಾವತ್ತಾಗೆ 2022 complaint.
For the complaint, date mention ಮಾಡಿಲ್ಲ sir. Only in the FIR it is shown as incident took place in the year 2016.
ಅದು ಅವ್ರದ್ದು accused number 1 ನಿಮ್ಮ ಮೇಲೆ ಹೇಳಿ ಈಗ.
ನಮ್ಮೇಲೆ ಇದು only she recorded the video ಅಂತ.
ದೇವರ ಪ್ರಸಾದ ಅಂತ ಪಾನಕ ಕೊಟ್ಟು ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವೇ.
ಅಲ್ಲ I am not.
ಅದು allegation.
Yes,
Page come to page ಏನ್ page number ಸರಿ ಇಲ್ಲ.
Page number
4 page number ಇದೆ.
Page number 31 as per the complaint, my lord.
Complaint ಬಿಡಿ madam. Come to the charge sheet.
Yes, ma'am.
Page 9 of the charge sheet, whatever. ಈ ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ
ಇನ್ನು ಶುರು ಆಗಿಲ್ವಾ?
ಇಲ್ಲ. Discharge I filed before the
discharge
sessions
rejected
court. Yes, ma'am.
Correct ಆಗಿದೆ.
ಅಲ್ಲ,
Clear
yes.
allegation against you.
No.
With her connivance, he has committed the act of rape.
No, is the
Accused
wife
number
of
1.
the A1, my lord. She has not done that. Even the wife won't do that.
No madam.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದು this mobile is seized ಆಗಿದೆ ಸ್ವಾಮಿ, but they have not.
Nothing.
Like one more submission in this 164 statement, original not furnished. And
ಪರವಾಗಿಲ್ಲ. ಅದೆಲ್ಲ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. Argument ಅಲ್ಲಿ
even incidentally ಇದು allegation start ಆಗಿದ್ದು, my lord, Prajwal one engagement with victim jate ಆಗಿತ್ತು. He was informed about the incident.
There is direct allegation against you.
No, against the A1 ಇದೆ, my lord. I admit.
A1 has committed the act with your support ಅಷ್ಟೇ. ನಿಮ್ಮ ಮೇಲೆ ಏನು ರೇಪ್ ಇಲ್ಲ.
Wife, my lord. She is a married. She is a legal validity wife.
Of A1.
Yes, my lord.
Correct.
ಅವರು ಆ ತರ ಮಾಡುತ್ತಾರೆ. And she is having a.
You don't know. Your husband has an affair with whom?
Not affair. Husband is running a herbal life. She is the member. Victim is the member of that. And there is a dispute between them about the finance matter, my lord. Hence she filed a complaint.
Very classic case, madam.
No, she filed a complaint. ಅವಳು
Accused
file ಮಾಡಿಲ್ಲ
one
sir.
minute,
ತಂದೆ
madam.
complaint file ಮಾಡಿರೋದು, my lord.
Accused number 1 has committed the act of rape and you have recorded the incident on the mobile.
So no wife will record such a type of thing.
Identical case have decided.
Once, she has not filed the complaint, my lord. Please consider that. In this complaint, I am
No,
permitted
madam.
to read, my.
No.
ಅಲ್ಲ ಡೇಟೇ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. In the complaint, my lord.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. This we will not permit at all. That 67E is the allegation. ಇಲ್ವಾ? 67A, sorry.
ಇಲ್ಲ ಸ್ವಾಮಿ. As per the charge sheet 66A, E your own. And the medical report also is here furnished, my.
Anyway, nothing. Anything else, madam? The petitioner is before the court calling in question the proceedings in CC 9516 of 2023 arising out of SC 280 of 2023 registered for the following offences. The petitioner is accused number 2. On 22/8/2022, the complainant registers a complaint against one Anandamurthy and the present petitioner who are husband and wife. The allegation against the petitioner is that the petitioner, the wife, has recorded the act of rape of the husband, accused number 1, on a girl by name Pooja. The the complaint results in the police conducting investigation and filing a charge sheet. The charge sheet leads the petitioner to file an application seeking discharge from the array of accused before the concerned court. The concerned court rejects the application for discharge and the petitioner now stands before this court in the subject petition, contending that the petitioner has no role to play at all. All the allegations are against the accused number 1. I decline to accept the said submission of the learned counsel for the petitioner on a sheer perusal at the complaint or at the summary of the charge sheet. The summary of the charge sheet reads as follows. The allegation against the petitioner is that she is the wife of accused number 1 and the accused number 1 has committed the act of rape for which the petitioner has abetted by by making the victim drink some juice after which the act of rape is committed, and the petitioner has recorded the said act of rape on her mobile phone. The learned counsel for the petitioner submits that mobile phone does not contain anything of that sort, all of which should be projected before the concerned court in a full-blown trial. Finding no merit in the petition to entertain the subject, finding no merit to entertain the petition under section 482 of the CRPC, petition stands dismissed. Next.
11.
Legal construction has been questioned by the
One minute,
petitioner.
sir. One nimisha. Go to page 37.
My lord, no, my lord, complaint has been after.
Illegal construction,
Illegal construction, my lord. I have produced the document. I have already filed the writ petition before this court.
Wound certificate.
Wound certificate, simple injury.
Page.
Assault with stone, my lords, grievous injuries, my lords, page 30.
Elli the page.
The charge sheet, that is not pretty.
Wound certificate ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
Page.
That's a page 68.
68.
One ನಿಮಿಷ.
He was inpatient for 2 days.
One HCGP, 2 emergent notice.
Or one submission. With respect to my lord, the petitioner, my lord, 2, 1, there is no allegation against my lord in the charge sheet as well as my lord the complaint.
ಬರ್ಲಿ.
My
ನೀವು
lord,
ಕೇಸ್
there is
ರಿಜಿಸ್ಟರ್
a
ಮಾಡಿಲ್ಲ
medical-
ಅವ್ರ ಮೇಲೆ?
my lord, she is
ಅಲ್ಲ
suffering
ಅವ್ರ
from-
ಮೇಲೆ
ಇಲ್ಲ, ಅವ್ರ ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ. Petition number 1 at least, my lord. ಅಲ್ಲ, there is a medical documents.
ಅದು ಬೇಲ್ ಇಲ್ವಾ?
ಅಲ್ಲ, ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಏನಾಗಿದೆ ಅಂತ 3 ದಿವಸಕ್ಕೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು
ಎಕ್ಸಾಮ್ಷನ್ ಕೇಳಿ.
ಅಲ್ಲ, ಎಕ್ಸಾಮ್ಷನ್ ಕೊಡ್ತಾನಲ್ಲ, ವಾರೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೂ ಓನ್ಲಿ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು
Exemption, I will permit the court to consider exemption.
at least ಯಾಕಂದ್ರೆ
No, sir.
86 years old. ಬಟ್ ಕೌನ್ಸಿಲ್ ಮದರ್ ಅದಕ್ಕೋಸ್ಕರ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಮೈ ಕೊಲೀಗ್ ಮಲಡ್ ಈಸ್
86 years ಯಾರು?
68 years.
ಅದೇ
Sorry,
ಉಲ್ಟಾ
sorry,
ಮಾಡ್ಬಿಟ್ಟಲ್ಲ.
ಅಲ್ಲ, ನಮ್ ಕೊಲೀಗ್ ಆಫ್ ಮದರ್ ಅದಕ್ಕೋಸ್ಕರ. ಅದರ್
ಬಟ್ ಇದ್ಯಾಕೆ ಉಲ್ಟಾ ಯಾಕೆ ಮಾಡಿದ್ರಿ? ಏಜ್
ಇಲ್ಲ, ನೋಡ್ಬೇಕು.
ಹಿಂಗ್ ನೋಡಿದ್ರ ಕೇಸ್ನ?
Petition number 1 at least.
There shall be an interim order of stay only insofar as the first petitioner is
Please,
concerned.
please.
Insofar as the others, the further proceedings shall continue.
Please.
Yes. Next.
12.
The main
I am the
next.
counsel for the petitioner, my lord.
Very good.
My lord.
Straight next.
I am the
Next,
absolute.
next. Yes. First time ಬರ್ತಾ ಇದ್ದೀರಾ ಕೋರ್ಟ್ಗೆ?
Hello, Swami. I'm for the petitioner, my lord.
You want stay bit ಬೇರೆ ಏನಾದ್ರು ಬೇಕಾ?
Hello, Swami. Stay.
ಆಯ್ತು, ಕೊಟ್ಟಾಯ್ತು.
Sure.
Yes. Next.
Case, my lord.
In the meantime, next.
14.
ಅಲ್ಲಿ ಬರೀ ಇದೆ 138 ಮೇಡಮ್ ಅಜಯ್. 13 is 138. Only emergent notice to the respondent. There shall be an interim order stay. Yes.
14.
In this matter, I appear for the petitioner. Accused, my lord, the accused number 1 called the accident to the my lord of the petitioner hearing. My lord, after
The
investigation.
petitioner is drawn as accused number 2. A driver of a Tata Ace vehicle crashes into the bike of the accused. It is the finding that the driver of Tata Ace vehicle was driving in a very rash and negligent manner. Notwithstanding the same, the petitioner, who has himself suffered injuries, is dragged into the web of crime. Therefore, there shall be an interim order of stay of further proceedings square the petitioner to the next date of hearing. EC Act, fertilizer.
Procedure is not followed 223.
In the meantime, yes, 223 on Dina. List the matter on date. 23rd. Yes, next. Fresh matters. Shashidhar.
16 and 18.
Same order.
Yes, same, my lords.
Number 16, 18, 29.
Yes. The other matters, my lords, are directed to SPP to appear and posted
ಹೌದು,
next to.
ಯಾವತ್ತು ಹಾಕಿದೆ ಅದು?
29/7.
Same 29 matter ಅಲ್ಲ, ಸಾರಿ. 16 and 18 ಮಾತ್ರ. List on 29/7. The petitioner is accused number 6 is alleged of offense
These matters
punishable.
may be connected along with.
ಆಯ್ತಲ್ಲ ಅದು. The petitioners are accused number 6. The offence alleged is the one punishable under section 138 of the Negotiable Instruments Act. A perusal at the complaint itself would indicate that the petitioner has no role to play in the transaction between the other accused. Therefore, there shall be your signatory.
No, my lord, I am not.
And he is neither the signatory for the check. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Emergent notice to the respondent. 18 are the same, madam. Yeah, same, 16 and 18.
19.
Petitioner, my lord, the seeking for the extension of the interim order dated 26/2/26, my lord. The offence under section 138 of an act, I could not furnish the surety as directed by the appellate court, my lord. I have deposited 20% amount and executed.
You are seeking 4 weeks time to deposit surety.
Surety and
Will
also
grant.
extension of the interim order, my lord.
I'll grant. Yes. The petitioner is before the court seeking the following prayer. The petitioner is the accused. Convict agidira.
Howದು, sir.
The petitioner is the accused who gets convicted of the offence. On suspension of sentence, it is directed that 20% of the amount be deposited. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that on 10/6/2026, albeit by a delay, an amount of 20% was deposited before the court, and filed a memo was deposited, though it was in part compliance. The petitioner filed a memo dated 26/6/2026, on 11/6/2026, that seeking 4 weeks time to furnish surety kodakagala, complete to deposit the amount. The same comes to be rejected. Therefore, the petitioner is before the court. In the peculiar facts, I deem it appropriate to direct to grant the petitioner 4 more weeks time from today to make good the 20% amount in terms of the order passed by the court. The interim, suspension of sentence shall stand extended for the said period. In the event the petitioner would not comply, the impugned order would get revived automatically. Order recorded. Next.
20.
Split.
319 and 490.
Split.
Splits.
ಯಾರು acquit ಆಗಿದ್ದಾರೆ?
1 to 6 are acquitted.
Page
number 63. Only 2 witnesses were examined. PW2 turned hostile.
Where were you?
Since I was
Summons ಬಂದಿಲ್ಲ.
Summons ಬಂದಿಲ್ಲ.
ಅಯ್ಯೋ. Same song.
I'm
The
residing-
petitioner is before the court. Petitioners yaru?
Accused number 7.
The petitioner accused number 7 is before the court seeking quashment of the continuance of SC 741 of 2024, which is now continued on account of a split charge drawn against the petitioner for offence punishable under section 399 and 402 of the IPC. The petitioner is accused number 7 gets embroiled in a crime along with others for preparation of dacoity as obtaining under section 399 and 402 of the IPC. The 402 of the IPC. The concerned court tries all the other accused who are available for trial and acquits them on the score that the prosecution has miserably failed to bring home the guilt beyond all reasonable doubt in SC 45 of 2017. Therefore, the 2017, the learned counsel for the petitioner submits that the petitioner is also similarly placed and he was not able to participate in the trial as no summons were issued, summons were served upon the petitioner. Be that as it may, I deem it appropriate to accept the submission of the counsel for the petitioner as the reasons rendered by the concerned court would undoubtedly become applicable to the case of the petitioner as well. The reasons so rendered are as follows: 68 to 73. The view of mine is Jai. Next, yes.
21.
FIR challenge now, my lord, the
Charge
charge
sheet
sheet is
ಹಾಕಿದ್ದಾರೆ.
submitted to the court, CC awaited.
Awaited. Position ಯಾರಿದ್ದಾರೆ?
I am the position, man.
I am the position.
Yes, yes.
What you are?
It's my father's property, my lord.
In the meantime.
Great.
Yes.
22.
Yeah, appear for the petition, madam.
In the meantime. Position ಯಾರಿದ್ದಾರೆ?
No, my lord, this is a case where he is a bouncer working at the.
Oh, 126 to 341. Yes, yes. In the meantime, next.
Grateful.
23.
85, husband no, all others yes.
85, my lord.
85.
85.
Except husband, all else. Yes. State.
Lord, I will show one thing, my lord.
One thing.
Yes.
What?
She approached the court of West Bengal near Bhutan, my lord, for.
Bhutan.
Near Bhutan border.
Court of West Bengal near Bhutan.
West Bengal border, my lord.
Right.
Adರಲ್ಲಿ she filed the maintenance case also. And she filed for divorce also. In that, my lord, she stated she is permanent resident of Bangalore. Then, my lord, here in that petition, it is 22/4. She has filed the complaint before the Basavanagudi police station. But here, my lord, it is.
So you have narrated the story from Bhutan to Basavanagudi. No problem. Yes. Husband gilla, ಬೇರೆಯವರಿಗೆಲ್ಲ. Yes. Next.
24.
It's a matter, my lords, where the court may have to view the conduct of the investigating officer very seriously.
We'll do it, sir.
No, my lords, may I just explain, because the interim order which we have sought is now, my lords, the amount which he has seized, we have asked it to be transferred to Canara Bank, my lords, where, my lords, what happens is.
Who has seized the amount?
A police officer who seizes this amount, kindly notice, my lords, just give me 2 minutes on the narration, what has happened
No
here,
problem.
my lords.
You narrate ಮಾಡ್ಬಿಡಿ ಆಮೇಲೆ look into
Yes, my lords. My lords, the petitioner, he has in business, my lords, where he had taken certain loans from Canara Bank at Tavrikere. The property was declared as an NPA. The security which was given was declared as an NPA. My lords, I write to the Canara Bank in Malleshwaram, and this one letter which I have written, my lords, the date may be noticed. 321, page 321, 29/5/2026. I write to Canara Bank that I would like to pay the amount, and I'm going to be coming to Bangalore to settle the amount. This is acknowledged by Canara Bank on 1st June 2026.
What happened?
2nd June, I come from Tavrikere with 3 crores ballots in cash accounted. 3 crores in cash. I come here. I reach here at 5:30 in the evening. Once I reach here, the bank is closed. My friend, I ask him to keep the cash in his factory premises. Cash is kept. 8:30, my lords. The police sub-inspector would register an NCR under section 98 of the KP Act, property which is not being satisfactorily accounted for. Now, my lords.
No. Where did he go and seize it, or where?
After that, my lords, he gets an NCR registered. After.
Who gives the complaint?
No one. No one. No information.
How does he get to know 3 crores ಇದೆ ಅಂತ?
Kindly notice what he says in the NCR. That's the reason I said, my lords, a matter probably. My lords, will have annexure A.
Page?
Annexure A at page 25.
First, two things,
yes, my
Choda
lords.
sir. Now you show me, you said it is accounted 3 crores.
Yes, my
where do
lords.
I get that?
Please, my lords, annexure X. I'll show the entire thing accounted for. My lords, page 80 may be noticed.
80?
Page 80. 20th February 2026, 4 MOUs under which I received the cash to make this payment. Undisputed point of time, my lords. From page 80.
You have received by cash?
Yes, my lords.
All
Please
right.
notice this 4 MOUs. And the dates may be noticed.
Where do I get cash receipt?
My lords, page 80, 20th February is the date of that.
Memorandum
stamp
of
paper.
understanding ಅಂತ ಇದೆ.
That is 12th March 2026.
Correct.
And then I received the amount. Kindly notice at page 82, 1 crore 4 lakhs. My lords should get that at page 82.
Which
loan
clause?
amount.
Which clause?
Clause 1, loan amount.
82 represented, a loan amount.
Yes, my lords. Similarly,
1 crore 4 lakhs
Yes, my lords.
in cash, in
cash.
500 rupee denomination notes.
Similarly, 3 more MOUs. My lords should notice the 3 other MOUs running till page 88.
MOU between whom?
Between, my lords, the lenders who gave me that amount for me to pay the amount to Canara Bank.
Who are
to
they?
Release. My lords, my acquaintances in agriculturists in Tavrikere, but at an undisputed point of time.
Tavrikere.
Tavrikere. So, my lords, 4 MOUs plus cash vouchers, everything accounted for the money that I have withdrawn from the bank. Now you kindly notice how this law is set in motion in annexure.
No,
A.
I'm only surprised. You give it to your friend. Whatever amount you had, you give it to your friend.
Here at
How
Bangalore.
does the police get to know?
That's most interesting, my lords. Annexure A, please notice the NCR with the register. Annexure A.
So moto?
Yeah. My lords, they say, Baptidararinda, this is the information. Kindly notice, my lords, 2/6, and this happens post 8 p.m.
ಓಹೋ ಇದು
And for which one, section 98, possession of property of which no satisfactory account can be given. He registers this.
ಇದು ಪ್ರಾಬ್ಲಮ್ ವಿತ್ ಯುವರ್ ಫ್ರೆಂಡ್. ಆ ಕಡೆ ಈ ಕಡೆ ನೋಡ್ಕೊಂಡು ಗೌಪ್ಯವಾಗಿ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
ಮತ್ತೆ-
ಪೊಲೀಸ್ ಪ್ರಾಬ್ಲಮ್
My
ಆಗಿದೆ.
lords, kindly notice what he does. He goes to the magistrate concerned. Order of the magistrate, please notice at page 27. I'm permitting you to conduct raid.
Seriously.
Order may be noticed. I'm allowing you to conduct raid. All right.
ಅಲ್ಲ ಇನ್ ದಿ NCR.
In the NCR, actually, my lords, for registration of FIR and investigation, that's a permission that has to be granted
Raid-
because
raid
it is a
ಗೆ.
non-cognizable.
Correct.
But permission, conduct raid. All right. He's gone. He seized this amount. After seizing the amount, does not report it, my lords. Sends notices to me for the purpose of negotiation.
Where is that?
My lords, notice, please notice, my lords, on 9th and 12th, two notices given to me. My lords, page 45 and 46 are the notices sent to me. After which, my lords, when I don't agree for negotiation,
One
report,
ನಿಮಿಷ 45 ಏನು?
45 is notice dated 9/6/2026. My lords gets that
ಏನಂತ ಕೊಟ್ಟಿದ್ದಾರೆ?
to come, basically notice to come to the station. 12th ಗೆ ಇನ್ನೊಂದು notice, my lords, page 46. And when I don't agree for negotiation,
ನಿಮಿಷ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯಾ ಅವಾಗ?
second,
offense?
offense second,
What offense? 98.
98. And then, my lords, kindly notice, after this, my lords, when I don't agree,
98 is cognizable?
non-cognizable.
35(3) ನೋಟಿಸ್ ಹೆಂಗೆ ಮತ್ತೆ?
My lord, FIR ಮಾಡಿದ ನಂತರ.
FIR
ಮಾಡಿದ
ಮಾಡಿದ್ಮೇಲೆ
ನಂತರ, he does an FIR, my lords. And then, please notice, my lords, 46 ಅಲ್ಲಿ ಇನ್ನೊಂದು notice.
notice is issued after FIR.
And then, when I don't agree, my lords, this is reported to the magistrate on 12th. So you register FIR on 2nd, seize the property on 2nd.
Reporting is on 12th.
Reporting on 12th. When my lords, the demand made was astronomical. I told them I have to give it to the bank. It's been declared as non, and every day, my lords, we are incurring interest on that.
Surface proceedings are insured. Where is it?
My lords, if my lords would notice in my letter itself, my lords, kindly notice page 321, my lords. 321. My letter to the bank, it explains the whole details when it was declared as NPA and when surface demands are done at paragraph 3, page 321.
ಈಗ ಯಾರ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದೆ ಇದು?
They still have that money, my lords. Money is with them.
Police.
And police, and my property will be brought up to auction by the Canara Bank. I have asked, my lords, as an interim prayer, I don't want the money. Give it to Canara Bank.
Yes, police, give it to Canara Bank. ಇದೆಲ್ಲ ಆಟಗಳು ಆಡ್ಬೇಡಿ ನೀವು. ಈಗ he is 3 crores, he will explain it to the income tax.
My lords, after I filed this petition, paperally about this comes and they say now we have informed income tax authorities, the investigating officers. Now income tax authorities, my lord, sent notices, we have explained to them. They are satisfied with it. Soon probably they will close the proceedings.
No, whatever it is, now this 3 crores will not go to you, it will go to the
Let it
bank.
go to the bank, my lords. I have to save my property. Entire amount was brought to give it to the bank.
ಅಲ್ಲ ಇಲ್ಲಿ MOU ಇದೆ. Satisfactory explanation ಇದೆಯೋ ಇಲ್ಲೋ, income tax will take care. Why is this policeman too much bothered?
Let's say MOU for only a let's 1 crore. The remaining amount, let's say.
4 MOU ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
4 ಇದೆ, my lords. 4 MOUs.
4 MOUs for 1 crore each, is it?
Yes.
My lords, and cash vouchers, both are there, which we withdrew from the bank to give it. And how do you?
ಅಲ್ಲ
register-
ಇವ್ರಿಗೇನು ವಾಪಸ್ ಕೊಡ್ಬೇಡಿ.
Bank
ಅವ್ರ
ಕೊಡಿ,
ಸಾಲಕ್ಕೆ
my
ಬ್ಯಾಂಕ್
lords.
ಹೋಗ್ಲಿ.
And my lords, registering it under 98 satisfactorily account for where will they call
We'll
me?
deal with that later.
My lords, please.
First you save your property.
Please. In the IA, we have sought for it, my lords. We filed an IA.
The
for
petitioner is before the court calling in question the registration of a crime in crime number 122 of 2026. They heard the learned senior counsel Sandesh Chowta appearing for the petitioner along with so and so. The petitioner avails certain working capital OD facility from Canara Bank in the name of his firms. 10 years thereafter, the overdraft accounts runs into becoming a non-performing asset The bank initiates SARFAESI proceedings by issuing a notice under subsection 2 of section 13 of the Act. The notices were taken forward. When the bank was wanting to take possession of the property, it transpires that the petitioner enters into a memorandum of understanding with his acquaintances for lending of 3 crores in all. 2 crore 98 lakhs to be in particular, specific.
Some of it withdrawn from my bank account.
The amount was some withdrawals from the account of the petitioner and of the acquaintances. The petitioner then files an application before the concerned court under 497 and 503, seeking release of the seized cash. The reason for filing the said application was the property of the petitioner would be put to auction if the amount was not paid to the bank. In the interregnum, strange things happen. The petitioner, on the bank being closed on the said date, is said to have handed over the amount to his friend. The police then sense some foul play, register a non-cognizable report, and the magistrate then gives permission to conduct a search in the house of the friend of the petitioner or the petitioner. Then the amount is seized on 2nd June 2026. The seizure is reported 10 days later on 12/6/2026. In all these circumstances, the action of the investigating officer will have to be looked into, for which the objections to be filed by the state would become imperative. The impending circumstance now is the cash of rupees 2,98,000 is seized and
2 crores 98.
2 crores 98 lakhs is seized and kept with the police. The said amount is to be deposited to the Canara Bank to save the property of the petitioner. Therefore, the investigating officer shall now release the said amount not to these petitioners, but deposit directly into the account of the loan account or the overdraft account of Canara Bank. It is made clear that not a rupee should be returned to the present petitioners, but only to the account of the petitioner in the overdraft amount, or whatever amount that the Canara Bank would indicate that they have initiated proceedings under the SARFAESI Act for. The said action shall be taken immediately by the investigating officer, and the compliance be reported to this court on the next date, 17th, fresh matters.
My lord, sir, the two details of the accounts are there. If the account details also
ಅವರೇ
comes, it
ಕೇಳ್ತಾರೆ
comes.
ಬಿಡಿ.
IA ಜೊತೆ ಹಾಕಿದ್ದೀವಿ. Deeply obliged.
ನಿಮಗೆ ಯಾವ ದುಡ್ಡು ಇಲ್ಲ, ಆಮೇಲೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ನೋಡ್ಕೊಳ್ಳೋಣ. ಎಸ್,
It's okay. My lord, main matter is
17th, the further investigation in so and so shall remain state till the next day.
deeply obliged.
25.
In this matter, my lords, accused number 1 has undertaken to settle the matter before the trial court, my lords. He's given post-stated checks also, my lords. Now,
ಏನ್
the
ಮಾಡೋಣ ಈಗ?
petitioners are the wife, my lord. Wife
Hello,
and
what to do
employees.
now?
Stay the matter, my lords.
Oh, where is the settlement?
Settlement, producing a memo, my lords.
The counsel for the petitioner files a memorandum of settlement arrived at before the trial court between accused number 1 and the complainant, who has also undertaken to return all the gold that is alleged in the case at hand. The petitioner, in the light of the said settlement arrived at between the parties, which is pending execution, the wife of the accused number 1 is now before the court calling in question the crime so registered. Subject to the reporting of settlement on the next date by the petitioner, there shall be an interim order of stay of further investigation. In the event no settlement would be arrived at between the parties, the interim order would stand automatically vacated.
Much okay.
Yes.
Admission 26.
Transaction appears to be civil in nature in the sense that.
Appears to be or is?
Is, because your lord, 2018 is the liability dated. 2022 is the date on which the complaint is filed. Your lordship, kindly see page number 21, para 7. During the year 2018, the accused again came and some liability of 7 lakhs is made. Your lordship, kindly see page number 25. Date of filing the complaint is 2022, after 4 years. So it is a time bar that even if that is there, ಚೆಕ್
138
138 ಹಾಕಿದ್ದಾರೆ.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ರ?
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. It was
ಟೈಮ್ ಬಾರ್ ಡೇಟ್ ಎಲ್ಲ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್.
some other transaction. He has offered some site.
ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್. ಇದು ಸ್ಟೇನೂ ಇಲ್ಲ. ಏನಾಗಿದೆ?
Complaint evidence is over, my lord. Defense evidence is yet to be.
Yes. The petitioner is before the court seeking the following prayer. Heard the learned counsel B.V. Pinto appearing for the petitioner and the counsel for the respondent. The petitioner is the accused, the respondent, the complainant. A complaint comes to be registered. The two have a transaction. In furtherance of the transaction, it transpires that the petitioner had issued certain checks in favor of the complainant which get dishonored. The dishonor of the check is complained of by the complainant before the concerned court in concerned court, which is now pending as CC 26569 of 2022. The learned counsel appearing for the petitioner submits that the time bar debt is projected before the concerned court by initiating the proceedings, and therefore the proceedings must be interdicted or obliterated. The learned counsel appearing for the respondent submits that the trial is at its fag end, as trial is at fag end as it is 4 years it has begun now. The learned and would submit that all the matters which the petitioner has projected in the case at hand would be in the realm of evidence, and therefore the petition should not be entertained. I have given my anxious considerations. The aforenarrated facts lie in a narrow compass. The transaction between the two is for a sum of 25 lakhs. Check is admittedly issued by the petitioner and the signature on the check is not disputed. With these two factors being in place, whether it is for a whether it is time bar debt or legally recoverable debt or otherwise, would be a matter of evidence. The learned, as submitted by the learned counsel appearing for the petitioner, the matter is at the fag end of its trial. At this stage, there is no warrant of interference in an exercise of jurisdiction under section 48 of the CRPC. All contentions shall remain open to be urged by the petitioner before the concerned court. Ordered accordingly.
27.
It's in the hearing stage, your lordship.
On 4/11/2024, there was no representation on behalf of the petitioner. The matter was directed to be listed after 4 weeks. Even today, there is no representation on behalf of the petitioner. The learned counsel appearing for the learned HCGP, representing as HCGP, would submit that the matter, the charges are framed, the trial is on, and the trial is concluded, and the matter is at the stage of hearing before the concerned court. In that light, there is no warrant of interference at this stage of the proceedings in exercise of jurisdiction, so on. So petition stands rejected. Next.
28.
Then
Also under investigation, your lordship.
investigation.
Yes,
No stay. ಇನ್ನೂ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
yes, your lordship.
Why?
Some miscommunication.
What miscommunication? 2021 crime, madam?
There was a stay and miscommunication.
There is no
was,
stay
your
also.
lordship. Yes, there is no stay.
Then
We will inform the concern of the petitioner.
the learned HCGP, Deepthi Alva, to secure instructions as to why the investigation is pending in a crime registered in the year 2021, that too for offences under section 465, 68 and 420 of the IPC. Information be sought and submissions be made on the next date. List the matter on 20th in the fresh matters. 21st, yes.
29.
Withdraw the matter.
In terms of withdrawal memo.
30.
Petitioner, my lord. Accused number 3 before this honorable court, my lords, the respondent. 341, 323, 324, and section 31R and 31S of the SCST Act. My lords, facts of the case is
What
that
is the stage of the proceeding?
charges are
Charges framed.
charges frame ಆಗಿದೆ. Evidence commence ಆಗಲಿ FDT ಗೆ.
ಏನ್ ಮಾಡ್ತಾರೆ? ಯಾವಾಗ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು?
43 2026.
ಈಗ? ಓ, ಇದು 2024 ಮ್ಯಾಟರ್. ಪರವಾಗಿಲ್ಲ ಹೇಳಿ. We'll take it on merits, yes.
My lords, initially, my lords,
Stay
accused
ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ಬಿಡುತ್ತೆ, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
number 1 and 2 assaulted the respondent 2 herein and insulted the respondent number 2 at 9:30 PM, my lord. Subsequent to that, at 11:30 AM, respondent 2 made allegations that he is coming out of the government hospital after taking treatment. Petitioner in taking a videograph of his car. He questioned that at that point of time he has insulted the respondent number 2.
What is the relation between you? Strangers, sir?
Illa, only because of I am the relative of accused number 1, he has implicated me as.
You're A3.
A3, my lords. Kindly see the complaint at page number 36. Allegations also same copy paste, my lords. Typed copies at 36. ರಾತ್ರಿ 9 ಗಂಟೆ ಹೋಗಿರುತ್ತೇನೆ. ಆ ಸಮಯ ನನ್ನ ಪರಿಚಯದ ಪ್ರಸಾದ್ is paternal uncle of the petitioner hearing.
More early.
My lords, I may permitted to read the allegation portion, my lords. ನಿಮ್ಮ ಕೇಳಿದಾಗ ಅವರಿಬ್ಬರು ಅಲ್ಲಿಂದ ಹೋದರು. ಬಳಿಕ ನಾನು ವೈನ್ ಶಾಪ್ ನ ಸಿಬ್ಬಂದಿ ಮಾತಾಡುತ್ತಿರುವ ಸಮಯ ರಾತ್ರಿ 9:40 ಗಂಟೆ ಸಮಯಕ್ಕೆ ಅಲ್ಲಿಗೆ ನನಗೆ ಹಲ್ಲೆ ನಡೆಸುವ ಉದ್ದೇಶದಿಂದ ಜೊತೆಯಲ್ಲಿ ಅವರಿಬ್ಬರು ಬಂದು ಪ್ರಸಾದನ ಏಕೆಯಾಗಿ ತುಳುವಿನಲ್ಲಿ ಸೋಯನ್ಸೋ ಎಂದು ಜಾತಿ ನಿಂದನೆ ಮಾಡಿ ಪೊಲೀಸರು ಅದನ್ನ ನಿನ್ನ ನೋಡಿಕೊಳ್ಳು ಗೊತ್ತಿದೆ ಎಂದು ಬೈದನು. ಆಗ ನಾನು ನನ್ನನ್ನು ಯಾಕೆ ಬೈತಿ ಎಂದು ನಾನು ನಿನಗೆ ಏನು ಮಾಡಿದ್ದೇನೆ ಎಂದು ಹೇಳಿದಾಗ ಗಟ್ಟಿಯಾಗಿ ಹಿಂಬದಿ ಹಿಡಿದುಕೊಂಡಿದ್ದು ಪ್ರಸಾದ್ ನನ್ನ ಅಂಗಿಯ ಕಾಲರ್ ಪಟ್ಟಿ ಕೈಯಿಂದ ನನ್ನ ಕಡೆ ಹೊಡೆದನು. That is the allegation against accused number 1 and 2.
My lords, may turn to page number 42, my lords, charge sheet.
I'm there only.
Please.
Your ಮೇಲೆ it begins 8 lines from the bottom.
Please, my lords.
ಚಾಸ ಒಂದನೇ ಅವರು ವಾಹನ ವಿಡಿಯೋ ಮಾಡುತ್ತಿದ್ದಾಗ ಚಾಸ ಒಂದು ಸೋನ್ಸ್ ಏಕೆ ವಿಡಿಯೋ ಮಾಡಿ ಕೇಳಿದಾಗ ಮೂರನೇ ಆರೋಪಿತಿಯು ಅಲ್ಲಿಂದ ಕೆಳಗೆ.
Please.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Please.
In this
Wait, specific allegations are there against him.
Accused 1 and 2 ಮೇಲೆ ಎಲ್ಲ ಇದೆ.
Same allegations on accused number 3 also.
Entire narration.
Because specific governments regarding the caste also, my lords. Same allegations.
ಯಾವ ಊರಲ್ಲಿ ಆಗಿದ್ದು?
ಪುತ್ತೂರು, ದಕ್ಷಿಣ ಕನ್ನಡ.
ಪುತ್ತೂರಲ್ಲಿ ಈ ತರ ಭಾಷೆನೆ ಮಾಡಲ್ವಲ್ಲ?
It's Tulu ಮಾತಾಡಿದ್ದು.
It's a Tulu language.
Tulu language, my lords.
ಓ ತುಳುಲ.
Same allegations ಎಲ್ಲ ಅಲ್ಲೇ ಕೂಡ ಮಾಡಿದ್ದಾರೆ. Medical evidence also there, my lords.
ಏನ್ ಮೆಡಿಕಲ್ ಏನ್ ಅಸಾಲ್ಟ್ ಗ?
Please, my lords.
ಇವ್ರೇನ್ ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ರು? ಇವ್ರ ಮೇಲೆ ಅಸಾಲ್ಟ್ ಇಲ್ಲ.
All 3 of them together, my lords.
Both of you know each other.
He's stating that, my lords.
ಯಾಕೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
Respondent specifically stated in further statement, ಪ್ರಸಾದನ ಸಂಬಂಧಿ accused number 1.
ಸಂಬಂಧಿ ಅಂದ್ರೆ ಅವ್ರು ಯಾವ ಜಾತಿಗೆ ಅಂತ ಗೊತ್ತು ನಿಮ್ಗೆ. And it is of course in the open.
Public view. That is
public view definitely.
Here, my lords. Public view. Kindly see the allegation, my lords.
The allegation ಇದೆ ಅಲ್ಲಿ.
Specific words are there.
ಗಟ್ಟಿಯಾಗಿ ಅಲ್ಲ, ಬೇರೆ 1 and 2 ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿದೆ.
Lords, even 3, my lords, ವಿಡಿಯೋ ಮಾಡುವುದೆಂದು ಕೇಳಿದಾಗ ಮೂರನೇ ಆರೋಪಿ.
ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಇದೆ. ಬೇರೆದಕ್ಕೆ ನೋಡ್ತಾ ಇದೆ. 325
max to max 504 506 ಬರ್ಬೋದು. 325
ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಬಂದೇ ಬರುತ್ತೆ. ಡೆಫಿನೆಟ್. No doubt about it. It's both in public view and public place. And you knew who he was.
That is his case.
Whether intention was there or not.
Intention.
ಏನು intention?
Only because of
325 will not come. 341 will not come. 323, 504, 506. That will restrict.
Please.
Yes. The petitioner is before the court. Petitioner accused number 3 in special case 5026 of 2022 is before the court calling in question the entire proceedings. Heard so and so. The incident that takes place on 4/1/2022 becomes the fulcrum of the crime. The incident was a squabble between the petitioners, between accused number 1 to 3 and the complainant. In the role of the petitioner is that he was shooting the video of the damage done to the vehicle, or the act of accused number 1 and 2 and of the complainant. It is at that time when the complainant questions the accused number, questions the present petitioner accused number 3. He is said to have hurled abuses with regard to the caste of these petitioners and also tried to assault. This leads the complainant to the jurisdictional police to register a crime in crime number 1 of 2022 for several offences. Synopsis. The police conduct investigation and file a charge sheet which is now pending consideration before the concerned court, a special case 5026 of 2022. The petitioner, accused number 3, has approached this court on the score that none of the offences can be none of the ingredients of the offences are even prima facie met against the petitioner. Therefore, would seek quashment of the proceedings. The learned counsel appearing for the respondent complainant submits that all 3 accused number 1, 2, and 3 have indulged in acts which should become the ingredients of all the offences that are now alleged, and therefore would seek therefore would submit that it is for the petitioners to come out clean in a full-blown trial, and the charges are framed on 4/3/2026 and the trial has begun. Therefore, this court must not interfere with the proceedings. The learned HCGP Deepthi Alva would also toe the lines of the counsel appearing for the respondent complainant in seeking dismissal of the petition, again on this court that the charges have been framed and this court should not interfere once the charges are framed. I have given my swords. The aforenarrated facts are not in dispute and lie in a narrow compass. The petitioners lie in a narrow compass. It is an admitted fact that the charges are framed on 4/3/2026, but the present petition was preferred on 4th October 2023, almost 3 years prior to the framing of the charges. In that light, I deem it appropriate to excise jurisdiction and entertain the subject petition qua the plea of the petitioner. The petitioner, as observed herein above, is accused number 3. What drives the petitioner to this court is the pendency of the proceedings therein. The proceedings have commenced on account of a complaint registered by the complainant before the jurisdictional police on an incident that happens on 4/1/2022. Complaint elide?
Page 36, 34, my lord, type to copy 36.
The complaint reads as follows. The police conduct investigation and file a charge sheet. The summary of the charge sheet is obtained in column number 17, reads as follows. A perusal at the complaint and the charge sheet would indicate that the petitioner has undoubtedly hurled abuses, both which is in a public place or in a place of public view. Therefore, there can be no question of quashment of the proceedings under the Atrocities Act. It is for the petitioner to come out clean in a full-blown trial as to there was intention or otherwise. The other offences are the offence under section 341, 325, 325. Both these offences would not get attracted against the petitioner, as what the petitioner is alleged of is shooting a video and wanting to assault the complainant.
Assault is only
Shooting the video and hurling abuses.
Yes.
Therefore, the allegation of assault or wrongful restraint of the complainant cannot be laid against this accused number 3 in particular. The other offences are offences under section 323, 504, and 506 of the IPC, all of which 323 ಅಲ್ಲಿ ಬರುತ್ತೆ ಏನು assault ಮಾಡಿದಾರಾ?
Together, they were all together.
Even otherwise it's all right. Yes. Therefore, the offences under section 323, 504, 506 are the lone offences that can be alleged against the petitioner, inclusive of Atrocities Act. In that light, I deem it appropriate to pass the following order. The offences under section 341 and 325 and 427 of the IPC, qua the petitioner, stands quashed. The offences under 323, 504, 506 and that of the Atrocities Act stands sustained. The criminal petition is thus allowed in part.
Please.
Oblige.
Yes.
31.
Petition, my lord. I request for take up along with our criminal petition 10,019. I request to take up the, along with the,
ಪರವಾಗಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿ ಸರ್?
Lord, I'm from proxy council, my Lord.
ಪ್ರಾಕ್ಸಿಯಾ?
Yes, my Lord.
ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಥ್ರೂ ಔಟ್. ಮೂರ್ ವರ್ಷದಿಂದ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್ ಅಲ್ಲಿ?
There's a stay, your lordship.
ಸ್ಟೇ ಇಲ್ಲ ಮೇಡಮ್.
10,094.
Connected matter stay
connected
ಇದೆಯಾ?
matter. Stay ಇದೆ.
Tag this petition along with so and so, same next Wednesday, same stage.
32.
I may be permitted to withdraw the petition.
In terms of memo ಇಲ್ಲಿ.
I'll file it.
Memo ಕೊಡಿ.
33.
Appeal for the petitioner, my lord. My lord, the respondent have instituted a proceeding under section 138 of NI Act for the repayment of rupees 10 lakh rupees, my lords. My lord, this instance.
It's 2023. What's the stage today, madam? What is your ground?
Lord, the RBI has issued a circular saying the check issued by any person through State Bank of Mysore, my lords, is invalid.
Oh, non-CTC check, that's valid, madam, not a problem. The only that ground andre alle project ಮಾಡಿ. The petitioner is before the court calling in question the proceedings in CC 1043 of 2023. The petitioner is the accused, the respondent, the complainant. The petitioner issues a check on 3/2/2023. Sorry, a transaction between the petitioner and the respondent happened between May 21 to September 21, wherein the complainant is said to have lent an amount of rupees 10 lakhs, in furtherance of which the petitioner had issued a check belonging to State Bank of Mysore. The said check is presented only to be returned for want of sufficient funds. The proceedings under section 138 is taken up by the petitioner. The learned counsel for the petitioner is before submits that the petitioner is before the court on the score that the Reserve Bank of India has issued guidelines that guidelines with regard to the check of a invalid check or stale or invalid check, as the check was issued of State Bank of Mysore long after its amalgamation with the State Bank of India, which would be a non-CTC check. The Reserve Bank of India itself has subsequently clarified that non-CTC checks also could become the subject matter of the proceedings under section 138 of the Negotiable Instruments Act. In that light, all these projections could be made only by the petitioner, by the petitioner before the concerned court at the appropriate time. Reserving such liberty, the petition stands disposed. Next.
34.
Appeal for the petitioner of this case, but the petitioner was the accused number 1 and 2, my lords.
Accused number
1 and 2, my lords. The private complaint. The complaint was referred to investigation officer, my lord. They filed a B report. My lord, the B report, my lord, B report ಅಲ್ಲಿ because the matter was supposed for ಇದು ಯಾವುದು ಇದರಲ್ಲಿ ಇದೆ ಸೋರ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ.
ಆಯ್ತು, ಏನಾಗಿದೆ ಈಗ?
ಸೋರ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬರೋದೇ ಮಲಡ್ ಎವಿಡೆನ್ಸ್ ಗಿಂತ ಹೋಗ್ತಾ ಇದೆ. ಅವಾಗಿನ ದಿ ಮ್ಯಾಟರ್ ವಾಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಲಡ್ ಸರ್.
ಪ್ರೊಟೆಸ್ಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರಾ?
ಅವ್ರು ಹಾಕಿದಾರೆ ಸರ್ ಪ್ರೊಟೆಸ್ಟ್.
ಸರಿ, ನಡೀಲಿ ಬಿಡಿ. ಅಲ್ಲಿ
ಅಲ್ಲ, ಸೋರ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ, ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಇದೆ, ಇನ್ನೂ ಮಾಡಿಲ್ಲ. 2027
ಅವ್ರೇನು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ. ಕಾಗ್ನಿಸೆನ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಈಗ?
ತಗೊಂಡಿಲ್ಲ ಸರ್.
3 ವರ್ಷ ಆಗಿ ಕಾಗ್ನಿಸೆನ್ಸ್ ಆಗಿ ಎಲ್ಲ ಆಗಿರುತ್ತೆ. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್? ದಿ petitioner accused 1 and 2 are at the doors of this court calling in question the protest petition filed and the order directing recording of sworn statement by the concerned court. The concerned court on the B report so filed by the police after investigation. Time has ticked off, as the petitioner is not aware as to what has happened after the protest petition being filed or the sworn statement recorded. In that light, if there is any order adverse to the petitioner reserving such liberty to knock at the doors of the appropriate fora, the petition stands disposed.
35.
Proclamation is pending, your lordship.
Proclamation?
Yes.
Or allu absent to illu absent?
Yeah.
The petition is filed on 23rd August 2023. Calling in question a proclamation issued for non-appearance of the present petitioners before the concerned court. A non-appearance of the present. Challenging the proclamation, the petitioners, on the reason that they have not appeared before the concerned court. They are here but are not appearing before this court as well. They have not inter alia anta ಮಾಡಿ. They are not appearing before this court as well. After filing of the petition, the matter has come up thrice and counsels are absent all the times. The petition is thus dismissed for its non-prosecution. Yes.
36.
No, my lord, the husband and wife are living together. I may be permitted to withdraw.
Withdraw in terms of the memo.
Please.
37.
Appeal for the petitioner, my lords. Offences are 149, 406, 420, my lords. Whereas petitioner has
ಚಾರ್ಜ್
pursued
ಶೀಟ್ ಆಗಿದೆ. ಕ್ರೈಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದ.
crime challenge. my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಬಹಳ ಹಿಂದೆ ಆಗಿರುತ್ತೆ. Challenge the charge sheet if you want.
Ready.
Yes. Liberty charge sheet form.
Great.
38.
For petitioner, Your Lordship. Your Lordship, we don't have any instruction from the client, Your Lordship.
ಕೊಡಿ. Don't worry there. Can't keep these matters pending for ages. ಎಲ್ಲ 2023 ಹಾಕಿರೋದು. Will permit discharge. The petitioners are before this court. '23 registered for the following offences. A perusal at the summary of the charge sheet, a complaint or the summary of the charge sheet would not merit consideration of the case on its merits. Therefore, reserving liberty to the petitioners to avail of the remedy of filing a discharge petition before the concerned court in the event charges have not been framed as on today, the petition stands disposed, leaving open all the contentions. Yes, next.
39.
The matter has been already disposed, my lord, by acquitting.
Good. Yes. Yes, state.
Yes, yes, we had.
Recalling act the trial court.
The state is before the court calling in question the application seeking recall of application under section 300 having become infructuous. Yes, next.
40. Part in person. K. Krishnamurthy.
I'm the petitioner in person, Your Lordships.
Hmm.
Being aggrieved by the order passed in criminal petition 103 of 2023, 820, I have preferred this appeal before, petition before
Appeal.
this honorable court.
One ನಿಮಿಷ ತಾಳಿ. Criminal revision petition.
Being aggrieved by the criminal.
ಆಯ್ತು ಒಂದು ನಿಮಿಷ.
103 of 2000.
Wait, sir. B report is accepted.
First time the B report has been rejected by the court. Second time the B report has been accepted by the court.
You are
And-
challenging that.
And I have challenged that in criminal revision petition 103 of 2000.
That is also rejected.
That is also accepted by the court.
Correct.
But sir, ingredients are there.
What
It is
ingredients,
a
sir?
documentary evidence case.
What ingredients, sir?
Section 341, 403, 405, 406.
Yeah, you were stopped from entering the premises.
Yes, sir.
What?
For that, I have produced the documentary evidence.
Let the, sir, ಯಾವಾಗ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
For all the provisions of law, I have produced it.
Oh, yes. ಇನ್ನೊಂದು 6 ತಿಂಗಳು ಆಗ್ಲಿ ಬಿಡಿ. Service. Yes, let them come.
Okay.
Yes. List after 2 weeks. Yes.
41,
Filing memo for withdrawal.
Thank you.
42,
My lord, appear for petitioners. I need to file a NOC wakalat for petitioners number 123. My lord. I'll file it in
Charge
the
frame
register.
ಆಗಿ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ.
No, my lord. By oversight, it has been shown that evidence anta, but in accused number 4 ಗೆ summons issue ಆಗಿಲ್ಲ.
Offense ಏನು?
447 and 188, my lord. There is a civil dispute between the parties, my lord. There are totally 11 FIRs.
11 FIRs.
Please, my lord. There are series of FIRs where the 9 FIRs, 8 FIRs have been stayed. ಎರಡಕ್ಕೆ ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ.
ಯಾವ್ದು ಎಲ್ಲಿದೆ? ನಂಬರ್ಸ್ ಕೊಡಿ. ಎಲ್ಲ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ಸ್ ಕೊಡಿ.
ತಮ್ಮ ಮುಂದೆನೆ 3 ಸ್ಟೇ ಆಗಿದೆ.
ಆಯ್ತು ಕೊಡಿ ಅದೆಲ್ಲ ನಂಬರ್. Who is in possession of the property?
Both the parties. There is a civil suit for declaration of partition, my lord.
Oh,
So,
family members.
Not family members, but we have purchased the property jointly, my lord. So as per that, we are in joint possession, but they claim that it is their own property.
Let it be decided before the civil court, mister. Why do you want the crime?
This is complaints and counter complaint, my lord.
So what? You will quash everything and permit
Please, my lord.
revival once the civil suit is decided. ಇದೇ ಕೆಲಸ. ಕೊಡಿ ಎಲ್ಲ ನಂಬರ್ಸ್ ಕೊಡಿ.
Yes, my lord. I'll
Give all the numbers. ಎಲ್ಲಿ ನಂಬರ್ಸ್?
ಇಲ್ಲ, ಇನ್ನೊಂದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ there is a list.
ಕೊಡಿ ಆ ಲಿಸ್ಟ್ ಕೊಡಿ. ಮೇಡಮ್ ಆ ಲಿಸ್ಟ್ ಎಲ್ಲ ಹಾಕ್ಸಿ.
ಇದರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ ಫರ್ದರ್.
ನಾಳೆವರೆಗೆ ಏನಾಗಲ್ಲ. 3 ವರ್ಷದಿಂದ ಹಂಗೆ ಇದೆ. ಪಿಟಿಷನ್ ನಂಬರ್ಸ್ ಕೊಡಿ ಸರ್. ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಕ್ರೈಮ್ ನಂಬರ್ ಕೊಟ್ರೆ ಏನು ಉಪಯೋಗ ಆಗುತ್ತೆ?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಇದೆ.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ಸ್ ಕೊಡಿ. ಎಲ್ಲ ಕೊಡಿ. ಅದು ಕೊಡಿ. Will dispose everything. Reserve liberty to revive the crime in the event something is found there. All case and counter cases will be closed. Yes. ನಾಳೆ ಹಾಕ್ಸ್ತೀರಾ? ಅಥವಾ ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ಸ್ತೀರಾ? 22 ಇದೆಯಾ? ಹಾಕ್ಸಿ. ವೆಡ್ನೆಸ್ಡೇ. Next Wednesday. Yes. Same stage.
43,
Charges have been framed, your lordship.
After filing the
Petitioner's one.
Yeah.
And our petitioner is the mother-in-law of the deceased. There is no specific allegation against.
Charge frame ಆಗಿರೋದು ಯಾವಾಗ?
Charge frame ಆಗಿದೆ. Now the evidence is going on. It's for posture for the cross-examination of the parents.
After filing of the petition or before filing of the petition?
Before filing of the petition.
ಅಲ್ಲಿ ಮುಗ್ದೇ ಹೋಗುತ್ತೆ ಬಿಡಿ. Yes. ಇದು ಮೀನಾಕ್ಷಿ ಬಾಲ. ಮೀನಾಕ್ಷಿ ಬಾಲ. Yes. All contentions to be left open to be arranged before the court. Yes. Next.
44,
Complaint is dismissed as not present. The issue before the court is with regard to a transaction which has led the complainant before the concerned court for offence punishable under section 138 of the Negotiable Instruments Act. The present status appears to be that the complainant has withdrawn the complaint on the score that the entire check amount has been paid. In that light, nothing further would survive for consideration at the case at hand in the light of the subsequent development. There is no representation for the on behalf of the parties. There has been no representation throughout in these proceedings. Yes, next. Or last year line bada. Next. Disposed.
45.
Appearing for the petitioner, we are withdrawing the case, my lords.
Yes,
To
ಏನ್
reserve,
7
my lords, 7A matter, my lords.
ಆಗೋಗಿದೆ ಟ್ರಯಲ್.
2023 matter.
The learned counsel of the petitioner seeks leave of this court to withdraw the petition. Next.
46.
Right, sir. I appear for petition in this case, my lords.
Yes, sir.
It's the office petition is under section 406, 409, 415, 420, 506. Read with section 149, my lords, and Butts Act has been included, my lords.
KPI
The allegation is that
ಎಲ್ಲ ಇದೆ. Yes, sir.
additional charge sheet is additional charge sheet is being filed, my lord, and
But Act, I'm not going to interfere. Yes. Discharge ಹಾಕಿದ್ದೀರಾ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ಹಾ, ಹಂಗಾದ್ರೆ
still with charge.
The petitioner is accused number 6 is now at the doors of this court calling in question the proceedings in special CC 2147 of 2022. Heard so and so. The petitioner, along with 6 others, established a firm by name We Care Online Learning App and is alleged to have collected amount of rupees 200 crores from public all over the state, assuring that they would provide classes to students through the online learning app. Neither classes happen nor students get any kind of education. Therefore, the crime comes to be registered that an amount for the that an amount of crime comes to be registered by the second respondent that several crores of rupees have been cheated by to the tune of several crore. There has been cheating in the case at hand for several crores of rupees, and therefore the crime comes to be registered. The police conduct investigation and file a charge sheet which is now pending in special CC 2147 of 2022. The summary of the charge sheet as obtaining in column number 17 reads as follows. The summary of the charge sheet depicts glaring acts of cheating on behalf of the petitioners who, on the garb of the learning app, have said to have cheated several persons to the tune of 200 crores. Therefore, the Buds Act and the KPID are invoked in the case at hand. There can be no warrant of interference with the offences being so against the petitioner, though he is accused number 6, as he is also the one who has established the firm with the other accused. Finding no merit in these petitions, the petition stands rejected. In this petition stands rejected. Next.
47.
For the petitioner, 138 matter, please, my lord. Check was presented on 2nd February 2021. Before that, also I have made complaint to deputy.
Check lost.
Please, my lord. My lord, kindly see annexure D.
ಏನಾಗಿದೆ ಕ್ರೈಮ್ ಅದು?
ಅಲ್ಲ, ಅದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದೇನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಯಾವತ್ತು ಕೊಟ್ರಿ?
B report is filed, madam.
28/1/2021, please, madam.
B report ಆಗಿದೆಯಾ?
B report.
Anything else, sir? ಬೇರೆ ಗ್ರೌಂಡ್ ಇದೆಯಾ?
ಒಂದು section 45 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ.
ಅದು ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲೇ
disposal, please. The petitioner is before the court seeking the following prayer. The solitary submission projected by the petitioner is the accused, the respondent, the complainant. The solitary submission projected by the accused, the petitioner, is that his checks were lost, and those checks were allegedly thieved by the complainant are the ones that are presented before the concerned court. The learned counsel for the complainant submits that the crime is closed on police filing a B report and the court accepting the B report. In that light, the said submission becomes on the face of it untenable. The learned counsel now submits that he has filed an application seeking reference of the signature to the for forensic examination as obtaining under section 45 and 73 of the Evidence Act. The learned counsel submits that a direction be issued to the concerned court to consider the said application. If in the event such an application is pending before the concerned court, It is needless to observe that the concerned court shall answer the same in accordance with the law without broking any delay, ordered accordingly. Yes.
48.
Respondent, my lord. My lord, Anuparna Bodola name may be reflected.
Then 2023 in the pending ಇದೆ ಏನಿದು?
2023, my lord, this is at Raghavendra Sahakara Bank matter, my lord. I filed a petition challenging the discharge application order. Guru Raghavendra.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Reject again, sir.
ಗುರು ರಾಘವೇಂದ್ರ
Guru
bank.
Raghavendra Bank, please.
Accused number 9.
Accused number 9, my lord.
The registry to print the name of
Anuparna Bodola.
in place of Madhukar Deshpande. Copy ಇದೆಯಲ್ಲ?
ಇಲ್ಲ ಕಾಪಿ ಇನ್ನ ಸರ್ವ್ ಆಗಿಲ್ಲ ನಮಗೆ
ಇದನ್ನೇ ಅವ್ರು ಬಂದ್ರೆ ಹೇಳ್ಬೋದು. Petitioner to serve set of papers upon the aforesaid counsel forthwith, as the allegation is that the papers have not been served upon them. List after 2 weeks. Next.
49.
Petitioner, my lords. We request for an expeditious trial, my lords.
ಕೊಡಿ.
The petitioner is before the court seeking the following prayer. The learned counsel for the petitioner in DV proceedings,
Yes, my lords.
DV Act.
Yes, my lords.
The petitioner is the husband, the respondent, the wife. A proceeding is instituted by the wife before the concerned court in criminal miscellaneous 111 of 2022, invoking the provisions of the Protection of Women from Domestic Violence Act, and is the said proceeding said to be pending for the last 4 years. In the light of the said pendency of the said proceeding and the statutory mandate being expeditious disposal, I deem it appropriate to direct the concerned court to dispose the subject application before the subject miscellaneous petition before the criminal miscellaneous petition before the concerned court with an outer limit of 6 months from the date of receipt of the copy of the order, if not already disposed. Ordered accordingly. All contentions remain open.
Sure.
Next.
50.
In this case, my lord. I'm withdrawing the petition. my lord.
Thank you. Yes.
List number 2. Seal number 1. Hearing on IA.
Sorry. I'll file my objections to the vacating application.
Ian, what's the?
My lord, this is also pertaining to employment agreement. My lord. This is also another classic case of heartburn, my lords, where my senior functionaries, they leave the complainant's company, want to join a rival company, then starts this process of embroiling them in this criminal. Till today, not a
The
single.
forensic audit report, and I have filed my vacating stay as well.
Objection to vacating stay and bantil. The criminal petition, sir.
Ivat sudden bantu, I'll prepare and come out. In fact, my lords also is it's covered by several judgments of my lords. I have at least about 4 judgments of my lords on the exact same point.
Let's see.
Your Lordship, if date
In
may be
any short
Wait,
account.
what's the matter?
there is an agreement, non-disclosure agreement. He's joined and taken substantial confidential information. There's a forensic audit. In the report itself, there is evidences that there has been a breach of the confidential information. There's been impersonation as well. So that is it has to be heard, but if a date could be given, a shorter date.
Next Wednesday, Thursday, la? Next Thursday in the same stage.
Lords may extend the interim.
Subject. The learned counsel Surat Sampath seeks time to go through the papers and make his submissions. List the matter next Thursday in the same stage.
Up in the list, Your Lordship, because I filed my
at the same
vacating stay.
at the same stage.
First matter ಇದೆ madam.
First matter ಇದಕ್ಕಿಂತ ಟಾಪ್ ಬರ್ಬೇಕಾ? Then it will be out of the list. ಪರವಾಗಿಲ್ವಾ? Yes.
In fact, till today they have not initiated civil proceedings
That's
for
all right.
injunction.
Yes. List the matter. Next date ಕೊಡಿ. Same stage. Interim order subsisting would continue to the next date of hearing.
Number 2.
My lords, this petitioner, my lords. My lords, I had undertaken, my lords, to give all the monies to the complainants, my lords. But I had taken undertaking here. The effectuation of that order, my lords, before the sessions court, my lords, they have passed an order, my lords, but the office is yet to take steps on it, my lords.
Where are the documents?
Order sheet, my lords.
Al Kodi.
Order sheet of the trial court.
Al Kodi.
Order sheet, my lords, which is at page number 4 or 5. The accounts are ordered to be defrozen and the properties that are subject matter of the attachment shall be attached for the purpose of execution of the undertaking made by the parties before the Honorable High Court of Karnataka. The particulars of the account frozen are to be found in the enumerated so and so. Office to issue directions to the concerned banks and the IO for the compliance. My lords, Sessions Court, my lords, had ordered its office, my lords, its office has to take steps, my lords.
Yes.
For compliance. If my lords, time may be granted, my lords.
We'll grant 2 weeks time after office matter. The learned, in terms of the order passed on 19/6/2026, the petitioner has demonstrated bona fides by approaching the court with the necessary implementation process. The court is yet to take a decision. Therefore, list the matter 3 weeks bit on date court. List the matter in the first week of August.
Interim order may be extended.
Interim order. First week of, list the matter on the 5th of August. Interim order continues till the next date.
Grateful.
Next.
Number 3.
My lord, I may be permitted to appear for the
Yes, sir.
counsel. Lord, consensual, my lord, promise to marry is the allegation that is made 69-115. Your lordships, my lord, legendary judgment, my lord, 150 pages, my lord, your lordship may kindly
Ashtond
see
bardidina?
completely. Allah, 50 pages. My lord.
150
Allah, 50. My lord, I have got this judgment of January, but after that also, my lord, I noticed that there are many other judgments, my lord, that your lordships have passed.
What's the?
My lord, both are doctors, my lord. They were studying together, my lord. They had some relationship in 17 and 19, all consensual, my lord. The allegation is that
when was the complaint registered?
15/3/2025.
Let me more submission, my lords.
Adjournment bit ಬೇರೆ ಏನಾರು ಹೇಳಿ.
The regular
Adjournment
counsel is
ಕೇಳೋಂಗೇ ಇಲ್ಲ
unable to-
vacating stay ಹಾಕಿದ್ಮೇಲೆ.
We have not moved the memo, my lords. We have not moved the memo. Henceforth, the regular counsel is unable to present before his court, my
No,
lords. Due to personal inconveniences.
ಯಾರು? You are not the counsel on record?
I'm not the record, my lord. Respond number 2.
Who is the counsel on record? Shant Kumar.
Shant Kumar, my lords.
ನೀವು ಯಾರು?
Vishnu, my lords. Represent for him, my lord. Henceforth, my lords.
Interim order ಇದೆಯಲ್ಲ?
ಇದೆ.
ಅದಕ್ಕೆ vacating stay ಹಾಕಿ.
Next week, my lords.
Heard the learned senior counsel, G.L. Vishwanath, appearing for the petitioner. The complainant and the petitioner have had a relationship. Complainant and the petitioner meet when they were doctors. When they were doctors working in the same hospital. The meeting develops into friendship. Friendship blossoms into relationship. Relationship also leads to them being living together in a particular flat, and which
Staying separately, she was visiting the flat.
Anyway,
not living together.
The physical relationship between the two continued from 2017 to 2023. The complaint is preferred in the year 2025, i.e. on 12/3/2025, alleging the offences punishable under section 69 Atrocities Act inter alia. A perusal at the complaint would clearly indicate that the petitioner and the respondent complainant have had physical relationship for about 7 years, and when the relationship turned sour, has sought to register the crime, that too for offence punishable under section 69, which is sexual intercourse on deceit of promise of marriage. Nowhere has sprung the promise of marriage, and it would not mean that the woman, that the lady would not know that the promise of marriage would be breached for 7 long years. The issue stands completely answered by the judgments, plethora of judgments rendered by the apex court, and the latest of which is Mukesh Bhai, Govind Bhai. It's not reported in SCC.
Okay.
It is 2026 Live Law 459.
Please.
Yes. 2026 Live Law 459. The learned counsel appearing for the identical facts. the learned counsel for the respondent.
Number 2, my lord.
Number 2 seeks time. As a last chance, list this matter in the same stage next week. In the event the counsel for the respondent would not be present, orders would be passed on hearing the learned senior counsel for the petitioner.
Lordship, just give a date, my lord, any date. that-
Thursday ne?
Thursday.
Same,
Your Lordship
same
may
day.
just say
Thursday.
Thursday.
Date ಹಾಕ್ಬಿಡಿ.
Grateful.
Yes.
Grateful, my lords.
My lord, I am for the
return memo filed by the.
Retired memo?
Retirement memo I filed, my lords.
ಏನು?
ಅಲ್ಲಿ ಇಲ್ಲಿ ಪ್ರಾಪರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡಲ್ಲ, ತಾವು ಹಿಡಿದ್ರೆ ಈಚೆ ಹೋಗೋದು ಹೊಡೆದಾಡೋದು, ಒಬ್ರ ಮೇಲೆ ಒಬ್ರು FIR ಮಾಡಿಸ್ಕೊ ಇದೇ ಆಯ್ತು.
ಓ ಇದು ದಟ್ ಲೇಡಿ.
ಎಸ್. ಅಲ್ಲಿ ಬಂದು ಅಲ್ಲಿ ನಮಗೂ ಟಾರ್ಚರ್.
Police station.
My lord, next my lord, he is absconded missing complaint lodged by the father of the petitioner. My return memo may be up.
When the respondent also filed a case of kidnapping and all.
ಯಾರ ಮೇಲೆ?
ಅಪ್ಪ ಅಮ್ಮಂದ್ರ ಮೇಲೆ.
Oh.
So this is
learned friend on that day in open
ಇಲ್ಲಿ
court.
ವಿಧಾನಸೌಧ PS ಇಲ್ಲೆಲ್ಲ ಬಂದು ನಾವೇ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಂಗಿಲ್ಲ, ಆ ರೀತಿ
I have
ಮಾಡಿದ್ದೀವಿ.
mentioned hide and seek case yesterday.
Permit me to return memo may be
The case your lordship may recall my learned friend made open
ಅಯ್ಯೋ
open
ಏನ್
court saying
ಗಲಾಟೆ,
that
ಈಗಲೇ ಬೆಂಕಿ ಹಚ್ತಾ ಇದಾರೆ, ಇಲ್ಲೇ ಇರ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ ಅದೆಲ್ಲ
You
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
should never step into the shoes of the client, sir. You're advocating a cause, not the client. ಅವ್ರು ಏನೋ ಹೇಳ್ತಾರೆ, ನೀವು ಅದನ್ನ ಅನಲೈಸ್ ಮಾಡಿ ಹೇಳ್ಬೇಕಿಲ್ಲಿ. ಅವ್ರು ಹೇಳಿದ್ನೆಲ್ಲ ಫಿಲ್ಟರ್ ಇಲ್ದೆ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ.
ಅಷ್ಟು ಆರಾಸ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅದಕ್ಕೆ ಫಿಲ್ಟರ್ ಇಲ್ದೆ ಹೇಳೋದು ಎಲ್ಲ ಇಲ್ಲಿ. ಇನ್ನೇನ್ ಬೆಂಕಿ ಹಚ್ಬಿಡ್ತಾರೆ ಅಂದ್ರೆ.
Return memo may be.
ಬೆಂಕಿನೂ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
like ಈ ಸರ್ ನಾನೇ ಬ್ಲಡ್ ನೋಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಆನ್ಲೈನ್.
ನಾನೇ ಬ್ಲಡ್ ನೋಡಿದೆ ಆನ್ಲೈನ್ ಇದೆ.
ಅಲ್ಲ
No, my lord, it was
ನಿಮ್ಗಲ್ಲ ಸರ್, ಅವ್ರು ಹೇಳಿದ್ದು ಹೇಳ್ತೀನಿ.
ಮತ್ ನಮ್ಮಿಬ್ರು ಹಿಡ್ಕೊಂಡಿದ್ರು.
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬ್ಲಡ್ ನೋಡಿದೆ.
ಮತ್ ನಮ್ಮಿಬ್ರು ಹಿಡ್ಕೊಂಡಿದ್ರು.
ಆನ್ಲೈನ್ ಬ್ಲಡ್.
ರಾಜಿ ಮಾಡ್ಸಿ ನಮ್ಮನ್ನ ಅಂತ ಹೇಳಿ. ಬೋತ್ ಅಡ್ವೊಕೇಟ್.
ಏನಾದ್ರು ಮಾಡ್ಕೊಡಿ.
again promised, my lord.
List the matter after 2 weeks.
ಅಲ್ಲ ರಿಟರ್ನ್ ಮೆಮೋ
ಬೇಡ ಬರ್ಲಿ ಯಾರು. ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ವಾಪಸ್ಸು?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇನ್ಯಾರು ವಕಾಲತ್ ಹಾಕ್ಲಿ, ಆಮೇಲೆ ಮಾಡೋಣ.
ಆಯ್ತು.
ಎಸ್.
Orders for 5.
For petitioner.
Office objections. Enter ಮಾಡಿದ್ಯಾ?
Intermodal is.
2 weeks time is granted to the respondent to comply.
They have filed to vacation.
Correct. 2 weeks time is granted to comply with the office objections, qua the statement of objections or the vacating stay by the respondents. Yes, next. Interim order continues.
Kindly one stipulated date.
ಬರ್ಲಿ ಬಿಡಿ, interim order ಇದೆಯಲ್ಲ ನಿಮ್ಗೆ. Yes.
Seal number 6.
23 matter.
23 matter.
List the matter on 21st July.
It's a matter of classic, the same consensual with the
ಇದು ಕಾನ್ಸೆನ್ಷಿಯಲ್ ಏನು?
Bumble dating app.
20
Bumble dating app. At the
ಬಂಬಲ್.
time,
ಎಷ್ಟು ವರ್ಷ?
ಅವಾಗ 33 ವರ್ಷ ಆಯ್ತು, 33 years.
ಅವಾಗ ಎಷ್ಟು ವರ್ಷ ಇದ್ರಿ ಸರ್ ಜೊತೆಗೆ?
No, they have never been. She
Never
has
been together.
It's only through that acquaintance in the Mangalore, when they were working in a hospital, they got acquainted. And like when they broke up, she asked, the complainant asked to return back the money is 45,000.
Oh, money.
ಅದಕ್ಕೆ money extortion ಅಂತ ಒಂದು, then 354.
ಬರ್ಲಿ ಬಿಡಿ.
Subsequently, she has filed one more case. I have annexure same offense in Visakhapatnam. Another FIR has been registered.
ಆಯ್ತು. 21st will close it, ಬರ್ದೇ ಹೋದ್ರು. Yes.
Seal number 6.
Withdrawal.
7.
Chamber.
8.
PCR complaint brought, sir.
ಏನ್ furnishing FPF?
Second respondent is.
Second respondent ಯಾರು?
Bank manager.
ಅವರೇ ಕಂಪ್ಲೇನೆಂಟ್?
Yes, sir. PCR.
A week's time to do the needful. Yes, next.
Meanwhile, Miller kindly plan. Meanwhile, grant me the interim order.
ಈಗ interim order ಇದೆಯಾ?
ಇಲ್ಲ.
ಮತ್ತೆ?
Because loan we have clear, Miller. Annexure.
We'll see.
Page 32.
ಒಂದು ನಿಮಿಷ. ಕ್ಲಿಯರ್ ಆಗಿರೋದು ಎಲ್ಲಿದೆ?
In page 33, Miller. Inverse ಇದೆ ಅವರಿಗೆ.
33?
Yes. closer letter, in page 33 inverse.
ಯಾರು ಕೊಟ್ಟಿರೋದು ಇದು?
Bank. SBI Bank.
The complainant, State Bank of India, on 12/11/2024 had issued the following communication that the petitioner has cleared, ಅವರೇನ petitioner, has cleared all the loan. Before the clearance of the loan, the complaint had been registered. ಮುಂಚೆ ಅಲ್ಲ?
Yes.
Complaint had been registered in crime number 33 of 2023. In the light of the subsequent circumstance of clearance of loan as quoted herein above, further proceedings in CC so and so shall remain state till the next date of hearing. Yes, next. Steps to be taken to serve the second respondent within the next 1 week. Next.
Seal number 9. Wait.
ಲಾಯರ್ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡಕ್ಕೆ
The respondent has appeared in person, seeks 2 weeks time to engage the service. ನೀವು petitioner ಈಗ?
ರೆಸ್ಪಾಂಡೆಂಟ್
Respondent. Engage the service of a lawyer.
ನಮ್ಗೆ 1 month ಬೇಕು
ಆಯ್ತು
ಕಾಪಿ
sir.
ಅಪ್ಲೈ ಮಾಡಬೇಕು.
No problem. For petitioner to serve set of papers upon the respondent forthwith, list the matter after 2 weeks, 3 weeks. Objections, if any, by then, I will. Next.
Seal number 10.
Withdrawal, my lords. In this.
Withdrawal.
My lords, in this 1/6/26, the interim order was given. And on 25/6/26, the police have filed the charge sheet.
Communicate ಆಗಿಲ್ಲ, challenge ಮಾಡಿ. Yes. Immediate ಮಾಡಿ ಅದು.
11.
Chamber.
12.
For withdrawal. Charge sheet, memo ಕೊಡಿ. And yes, sir. 13 ಅಷ್ಟೇ, same.
14.
Maintainability of second petition.
Second petition, the reason is that during, in the first petition, the FIR was stayed. Thereafter, they filed charge sheet. I've challenged it in second proceedings. The second.
First one ಯಾಕೆ ಬೇಕು ಅಂತ?
ಅದಕ್ಕೆ withdrawal ಆಗ್ತಾ ಇದೆ.
ಕೊಡಿ, yes. ಯಾವ್ದು first one, madam?
First one, my lord, is 4369, please, my lord.
All right.
And in 7742, same accused, my lord, all are in-laws. Not in-laws, not the sisters and brother-in-laws.
Stay ಇದೆಯಾ?
ಇಲ್ಲ, first time ಬರ್ತದೆ. The previous order, Lord should get at page number 39 of my petition.
Husband ಇಲ್ವಾ?
ಇಲ್ಲ.
In the meantime.
Please.
Yes.
Obliged.
Next. Same 85 format. Both ಅಲ್ಲ, ಒಂದು withdrawn. 4369 of 2026 is withdrawn.
Please.
7742 of 2026 ಅಲ್ಲಿ interim order.
Obliged, please.
Maintainability stands overruled ಅಂತ ಮಾಡಿ.
15.
I appear for petitioner, I am filing the memo for withdrawal. My being the second.
Which you want to withdraw?
7995.
ಅದರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲ, ಅದು ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಫೈಲ್ ಮಾಡ್ಕೊಂಡು
ಸರಿ. In terms of the memo. Yes.
Connected 2 weeks.
2 weeks.
Weeks to take steps. 16.
Appear for petition, Swami. So 407.
ಎರಡಿದೆ. ಒಂದು ಮೆಮೊ ಹಾಕಿದಾರಲ್ಲ.
One memo, Swami.
In terms of memo.
Stay.
16 ಏನು?
Stay, man.
16.1 withdraw ಮಾಡ್ತೀವಿ. 16 ಏನು? ಸ್ಟೇ ಇದೆಯಾ?
ಹಾ, ಸರ್.
ಇಲ್ಲಪ್ಪ.
Kindly, order 53, page number 53.
ಒಂದು ನಿಮಿಷ.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಕಂಪ್ಲೇಂಟ್.
ಕಂಪ್ಲೇಂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಸಿವಿಲ್ ನೇಚರ್ ಇದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲಪ್ಪ, ಕಂಪ್ಲೇಂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಹಾ.
ಎಲ್ಲಿದೆ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್?
ಆರ್ಡರ್ 53, 50 annexure 53, page number 53, kindly ಸ್ವಾಮಿ.
53.
ಹಾ.
ಕನ್ಸ್ಯೂಮರ್ ಕಂಪ್ಲೇಂಟ್. ಯಾವ ಕಂಪ್ಲೇಂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ? In the meantime, yes.
17.
17.1, I'm drawing the petition.
ಯಾವ್ದು withdrawing?
17.1.
ಇದು 17.
17, it's a charge sheet that they filed. There is stay in the 17.1.
What's the allegation?
Allegation is that my lord, dowry.
85.
Yes, my lord, 85, 115 and 351.
1 ಗಿಲ್ಲ. 2, 3, 4, 5.
Please, man. One ಅಲ್ಲಿ ಏನಂದ್ರೆ there is no they have not proved the allegations at all, my lord.
Early, yes. ಅದು 85 except 1, all else stayed.
Yes.
18.
18, my lords.
Notice may be granted.
Bail condition, my lords, relaxation. I am the daughter of the accused, not an accused, not a witness. Only my condition
Notice
for to travel outside, my lords, I have just
ಇವ್ರಿಗೆ ಯಾಕೆ ಬೇಲ್ ಕಂಡೀಷನ್ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡಬಾರ್ದು?
A1 ಗೆ ರಿಲ್ಯಾಕ್ಸ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
A1 ಗೆ ಆದ್ಮೇಲೆ ಮತ್ತೆ
Stays as
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Sir,
Learned Counsel Madhu and Rao is directed to accept notice for the respondent.
they have already filed.
She's the owner of that King 567. She's the main
21-year-old
person there.
daughter of A1.
No, she may be, but then she's the owner of that King 567 domain name through which the transactions have happened.
Owner of king567.com.
Yes, that's
The allegation, my lords, they pull in details from elsewhere.
the owner of that.
ಮತ್ತೆ A1 ಗೆ ಹೆಂಗ್ ಕೊಟ್ರು?
The same court has granted much prior to
that's what
rejection
we
of
are,
my.
ನೋಡಿ. Yes, Counsel Madhu and Rao, ಇಲ್ಲಿ ಅನುಪರ್ಣ ಅಂತಿದೆ. Notice. Learned Counsel Madhu and Rao is directed to accept notice for the respondent.
Next week.
Registered to print the name of Madhu and Rao is appearing for the respondent same day, Thursday next week.
Tomorrow, my lords.
ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅರ್ಜೆಂಟ್ ಆಗಿ?
ಇಲ್ಲ, my lord.
ಅಲ್ಲ ಹೋಗ್ಲಿ ಎಲ್ಲಿ ಹೋಗ್ತಾರೆ ಅಂತಾನೂ ಕೊಟ್ಟಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅದು ಐಟನರಿ ಎಲ್ಲ ಕೊಡಿ.
I'm not an accused, my lords. I will give.
ಆಯ್ತು, we'll see.
Please.
Oblige.
But the
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಇದು.
special court.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮಾಡಿ.
Please.
ಹಂಗ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 17th. 17th.
May I request, my lords, the office objections be overruled. It's minor.
Office objections overruled. Yes.
Oblige.
19.
ಇದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಇವತ್ತು ಯಾಕೆ ಬಂತು?
Lord, this is a bail matter, my lord. He is in
Correct.
custody. 483 matter. 482 petition has been dismissed by this honorable court, my lord. Now
Correct.
thereafter, my lord, after lapse of 1.5 years, he has been arrested and nothing has been seized and there is nothing to seize also. Entire document is with the government and, my lord, the investigating agency. Lord, the only allegation is that he was chairman and, my lord, he was involved in the illegalities and irregularity committed at the Bagarukum committee.
ನಂದೇ ಆರ್ಡರ್ ಸರ್.
ಅದನ್ನೇ ಅಬ್ಸರ್ವ್ ಮಾಡಿ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ my lord both rejected the petition.
Lordship, have it week after next. Connected matter ಅದು ಕೊಡ್ತೀನಿ. ಇವ್ರದೇ. Week after I'll file my objection.
Connected matter ಇಲ್ಲ. ನಾಳೆಗೆ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಬರ್ತಾ ಇದೆ. ಇದರಲ್ಲಿ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್.
ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅಲ್ಲ, ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ವೈಟ್ನರ್ ಹಾಕಿದ್ದು ಒಂದು ಮ್ಯಾಟರ್ ಇತ್ತು ಅದರಲ್ಲಿ.
ಓ,
the time of irregularities committed. Yes. Tomorrow it is there, my lord. But we have filed application for interim bail also, my lord. He has got, my lord, heart issues, my lord.
Heart ಏನು?
Open heart surgery has been done, my lord, and is under medication.
ವೈಟ್ನರ್ ಬಗ್ಗೆ ಏನು ಬರೆಯೋದು ಬೇಡ.
ಅದೇನ್ ಬೇಡ.
I think
now,
that
since
Whitener
is
also
custodial interrogation not required, my lord.
No, Whitener also
consider my bail
I'll
application.
show it how. The
pre-trial.
ವೈಟ್ನರ್ ನಾನು ಕನ್ವಿನ್ಸ್ ಆಗಿಲ್ಲ.
Lord, the Whitener, that application where he says was signed on 19/6. Your lordship may see the date he puts, 26/6. It's only to get the benefit of grounds of arrest application not being.
But ಅದಕ್ಕೆ ವೈಟ್ನರ್ ಹಾಕಿಲ್ಲ, ಟೈಮಿಗೆ ವೈಟ್ನರ್ ಹಾಕಿದ್ದಾರೆ.
No, time ಇರಲಿ.
Now he is trying to get over from the mistake what they have committed, and they in their application,
this is how he is
objection to the
manufactured
application, they have admitted that they have committed mistake. It is also on the, I will place it also record.
Next week after.
Tomorrow, my lord, I will sort for interim bail because of ill health.
ನಾಳೆ.
Please, very
Yes.
20.
Memo for retirement.
Appearing for the respondent. Senior is not keeping.
You have filed Wakalata?
Please,
All right. The register to delete the name of Satish K as Siri R as entered appearance. Memo for retirement filed by Satish K stands accepted. In 7 or 13?
13, my lords.
Placed on 22nd. 13. 7 alla. 13. 22nd.
Interim order may be kindly.
Idya. Interim order stands accepted.
Much okay.
21.
Lordship, I am the petitioner.
6 respondents. But the matters on a narrow compass, but before that I
But
have to point out.
Lordship, I may be heard for 1 minute.
Please, sir.
Wrong premise, getting of a interim order in a writ petition, WP 15170, and they spiraled it over all the criminal cases. Then bunch of the criminal cases has been put into arbitration proceedings, NCLT, my intellectual property related, assets related.
Why?
And
what's the matter now? Furnishing of process, all are not served?
It's all served, Your Lordship. Only the company is not functioning from 2023.
What's the matter?
This matter is coming from section 9 application, where my application of section 9 has been
Section 9
dismissed.
application and 482.
ಇಲ್ಲ section 9 of arbitration act.
ಅದು ಗೊತ್ತು, but why 482 petition?
He says, my lord, his contention is that there are some misrepresentations made in the objections to the section 9, which has resulted in the section 9 being dismissed. That constitutes perjury. Now, in the perjury proceedings, we should not be heard despite.
Your lordship, I may be here. Section 9 application is dismissed only because the criminal petitions are pending before this court, not looking into
Where is
any
that
of my
order?
documents.
Where is the order, sir? Where is the order?
Let me complete your lordship.
No story here. Where is the order that dismisses on the ground that criminal petition is pending?
It is there in
Page,
the.
page.
Yes, your lordship. In my writ petition.
Page.
In my writ petition, page number 81, sorry, 77.
That is order of
Sorry,
the
80.
order of the coordinate bench.
Order of the coordinate bench. Your lordship can see that.
Your lordship,
My section 9 application is dismissed because the criminal petitions are pending.
Where is that dismissal of the section 9 application order?
Subsequently,
Where is the order?
Your lordship, subsequently I
Which page
filed.
is the order? Which page is that arbitration proceedings dismissal?
That I have not filed it, your lordship. Your lordship, subsequently, section 340 application I filed, same order has been copied. So the coordinate bench has said 1 to 44 documents are perused, but not looking into the document. The previous orders of criminal petitions are pending, which has been
Consider
reused.
the matter of fresh in view of the observations made by this court are directed to appear before. What happened after this?
Illa, so now we have appeared. This petition challenges our appearance, saying in perjury proceedings, the accused have no right to appear.
It's a 2 times they mislead this court, your lordship. Your lordship, kindly look into 2 of the documents which I have produced.
Yes, one moment. This page 71 order of the coordinate bench was passed after hearing you? Were you heard or not?
Yes, your lordship.
You were heard.
Yes.
The coordinate bench said go before the ಯಾರ ಮುಂದೆ ಇದು? Which court?
Before
is
the
it?
commercial court, your lordship.
By commercial court.
Commercial court.
In
87.
commercial AA 197 of 2016.
Yes, your lordship.
All right. Now all of you are before the commercial court.
Yes, your lordship.
Now what has happened in the interregnum?
Problem is again they are using the same criminal petitions to
Which criminal petition?
Criminal petition 1869.
Which is that 1869?
1869 is related to the intellectual property. One of the
Which is
trademark.
that 1869?
Your lordship can see the page number.
Page 160 of our counter affidavit.
63, your lordship. 63 in my writ petition. Sixty-three of my writ petition, your lordship.
63.
Page 63 of my
One moment.
writ petition, annexure.
One moment. What have they said?
The page number, sorry, para number 9. Considering the rival submissions on the materials on record, admittedly, the appellant has filed present applications on the ground that respondent number 2 and 4 and 5 and 6 have made misleading statements before this court and committed perjury, and to have cognizance against them for the same, and to punish them for the offense committed under 193 of IPC. The main defense in the respondent is that applicant is a habit of filing a criminal complaint against the respondents, and the said complaint also stayed by the Honorable High Court. The complaint filed by the applicant in memo of additional documents in a page number 203, Your Lordship.
Absolutely, yes, sir.
Page number 203,
Huh.
only one document. 2 pages before Your Lordship can see, this is a diary number 488 or 88, filed on 16/11/2022 in a Honorable NCLT as an annexure number R19
Yes.
by the respondents. So which says that the next page 203, it says that first board meeting has happened on 10th of June 2021. Subsequent next page, Your Lordship, second meeting happened on 4th of August 2021. Third board meeting they have not produced in a Honorable NCLT. Fourth one has been mentioned as 9th August 2021. There is a subsequent board meeting notices are given, sir, Your Lordship. Now, there is a document which they submitted to ROC, that is on 9 months after my Section 9 application has been dismissed. That is on page number 224. Page 224, Your Lordship can see first board meeting on 10/6/2021. Second board meeting is fabricated. Third board meeting is fabricated. Fourth is fabricated.
Now, the matter is pending, Allah?
Pending before many forum.
No. What Justice Sandesh had said, other matter is
That is
pending.
pending, that is pending. So his
Now,
grievance is,
the allegation is of forging a document before a court.
Yes. And they say that I have resigned voluntarily. My shares are.
All that is pending there, yes.
Yes, Your Lordship.
The petitioner, party in person, is before the court seeking the following prayer. Court page 48. The petitioner was before this court or before this court in same petitioner. Huh? This petitioner was before this court in criminal appeal 2310 of 2024. Therefore, the facts that are obtaining in the said petition are to be paraphrased as facts necessary for consideration of the subject list. The court para page 73 to 74. The coordinate bench disposes the petition. The petitioner was before the coordinate bench on a particular circumstance. The circumstance was that the petitioner had projected before the concerned court of session in commercial criminal miscellaneous 1916 of 2024 of forgery of a particular document placed before the said court. On the orders of maintainability, the said court had rejected the petition. The prayer that is sought in the said criminal miscellany, commercial criminal miscellaneous is as follows, page 5960. The petitioner, the reasons rendered for disposing the said commercial criminal miscellaneous 1916 of 2024 by the concerned court is as follows, page 64 to 66. This is called in question before the coordinate bench. The coordinate bench, in terms of its order dated 71 page 25th April 2025, allows the petition filed by the present petitioner and issues certain directions. The reason so rendered by the coordinate bench is as follows. Para 5 in the end. That is, it starts at
so starts at para 6.
para 6, is it?
Yes.
Having perused. Para 6, page 77 to page 82. The coordinate bench allows the appeal of the petitioner, sets aside the order dated 22/6/2024 passed in Commercial Criminal Miscellaneous 1916 of 24, remits the matter back as observed, and directs the parties to appear before the trial court on 5/6/2025. It is an admitted fact that the petitioner in person and the respondents have appeared before the court and the proceedings are on. During the pendency of the proceedings, the learned counsel for the petitioner in person has again knocked at the doors of this court on the score that the respondents are using a particular interim order that was granted in or the pendency of criminal petitions before the said court before the said court in projection of their defense. The order of the coordinate bench has become final. The order directs the concerned court to redo the exercise afresh after hearing the parties. The hearing is on. At the time of hearing, without a decision being rendered by the concerned court in commercial criminal miscellaneous, after the remittance at the hands of this court, the petitioner in person cannot project piecemeal grounds and approach this court every now and then. It is always open to the petitioner to approach the court after the proceedings are closed whole hog pursuant to the order passed by the coordinate bench, failing which all the grounds that are considered by the coordinate bench while remitting the matter back are being agitated before the court, before this court now. It would amount to this court sitting in appeal over an order passed by the coordinate bench which circumstance cannot be countenanced. In that light, reserving liberty to the petitioner to knock at the doors of the appropriate fora in the event the concerned court would conclude the proceedings in terms of the order passed by the court. The submissions projected before this court, the petitioner in person would be free to project the submissions projected before this court, before this concerned court, ordered accordingly.
Your Lordship,
Yes.
Lordship, 1 to 44 documents I have produced.
Alle
That
madi.
documents,
Yes.
One submission I want to make. Now, that last paragraph which your lordship has dictated, reserving liberty, if that can be omitted for the reason
Okay.
that, let me just
ಈ contentions ಅಲ್ಲೇ ಅರ್ಜಿ
I'll
ಮಾಡಲಿ.
ಮಾಡ್ಬೋದು, but the petitioner here has my lord filed 40 different instances of litigation, misusing that. In fact,
I can't close that door.
My lord, can I just point out against councils, notices are issued to the councils.
You
here.
fight it out, sir. This is not in his proceeding. You are taking an order. No, this is all the order. Yes.
much obliged.
Yes. Next.
22.
For withdrawal. Yes, thank you, sir. Yes.
I lost liberty for filing afresh. Grateful.
23. Roll memo.
In terms of.
Liberty may be granted.
Yes, sir.
Much.
24.
Same.
24.1 is withdraw memo ಹಾಕಿದೀನಿ my lord.
24.1.
Withdraw memo ಹಾಕಿದೀನಿ my lord.
ಸರಿ. ಇದು ಇನ್ನೊಂದೇನು?
ಅದು ಎರಡು withdraw memo.
ಎರಡು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಓ, ಥ್ಯಾಂಕ್ ಯು. ಎಸ್.
ಫೈಲ್ ಮಾಡಿ.
ಡಬಲ್ ವ್ಯಾಮಿ. ಎಸ್. ಇನ್ನೊಂದು ಮೆಮೊ ಕೊಡ್ತಾ ಇದೆ.
25.
Settlement.
ಡಿಡಿ. ಹಾ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ಸರ್, ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಇತ್ತಲ್ಲ ಸರ್, ಮಗು ಕೇಸ್.
ಬಾಕ್ಸನ?
ಮಗು ಕೇಸ್. ಚೈಲ್ಡ್ ಕೇಸ್.
ಟ್ಯಾಂಕ್ ಅಲ್ಲಿ ಚೈಲ್ಡ್ ವಿಚ್ ಫೆಲ್.
ಓ ಎಸ್ ಎಸ್. ಎಷ್ಟು ಕೊಟ್ರಿ?
ನೀವು ಆಸ್ ಪರ್ ಯುವರ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ ಸರ್.
ಎಷ್ಟು ಆಸ್ ಪರ್ ಅಂದ್ರೆ?
6,20,000.
6,20,000. ಅದನ್ನ
FD
ಲೆಟ್ ಇಟ್ ಬಿ ಇನ್ FD.
ಆರ್ಡರ್ ಈ ತರ
5,000 DD ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
5 lakh DD ಮತ್ತೆ 10,000 ಎವ್ರಿ ಮಂತ್ ಅವ್ರ ಅಕೌಂಟ್ ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರು. 5 lakh DD ತಗೊಂಡ್ಬಂದಿದ್ದೀವಿ ಸರ್.
ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರಾ?
DD also your lordship said the deposit in the
FD
legal.
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ, ಮಾಡ್ತೀನಿ. ನಂಬರ್ ಹಾಕ್ಬಿಟ್ಟು ಡೈರೆಕ್ಟ್. ವೇಟ್ ಕೊಡ್ಬೇಡಿ. ಡೆಪಾಸಿಟ್ ಇನ್ ಫಿಕ್ಸ್ಡ್ ಡೆಪಾಸಿಟ್ ಅಕೌಂಟ್.
ನಂದೊಂದು ಸಜೆಷನ್, PMS ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಆಫೀಸ್ ಮಂತ್ಲಿ ಸ್ಕೀಮ್ ಹಾಕಿದ್ರೆ 3,000 ಸಮಥಿಂಗ್ ಏನೋ ಅಮೌಂಟ್ ಬರುತ್ತೆ.
ಕರೆಕ್ಟ್, ಅಲ್ಲೇ ಹಾಕಿ.
ಮಂತ್ಲಿ
DD ಅಲ್ಲಿಗೆ ಕೊಡಿ, ಅವ್ರ ಹೆಸರಲ್ಲಿ ಹಾಕಿ. ಅವ್ರು ಬೇರೆ ಮಕ್ಕಳಿಗೆ ಇಲ್ಲದ್ರೆ ಅವ್ರು ಖಾಲಿ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ನಾನು ಅದನ್ನ ಸರ್ಚ್ ಮಾಡಿದಾಗ PMS 7.4% ಇಂಟ್ರೆಸ್ಟ್ ಬರುತ್ತೆ.
ಆಯ್ತು ಸರಿ ಅದಕ್ಕೆ ಹಾಕಿ ವಿಚ್ ಎವರ್ ಇಟ್ ಇಸ್ 10,000 ನೀವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಏನು ಕೊಟ್ಟಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಆನ್ ದಟ್. ಎಸ್ ಸ್ಪೀಕರ್. The petitioners are before this court seeking the following prayer. The petitioners are accused 1, 2 and 3. They stand at the doors of this court on the offense of section 106 within bracket 1 being laid against them, which is 304A of the earlier regime, the IPC. The second respondent is the complainant. The child of the second respondent, which was playing in the adjacent house, steps into the house of these accused, where construction was taking place. For the purpose of construction, a water tank was in the place. The child falls into the water tank and dies. The result of death is the allegation of rash and negligent acts at the hands of these petitioners. It is an admitted fact that the child is not the one that was, did not belong to the one that was working in the premises of the petitioners. Therefore, on the score that it would not amount to an offense of ingredients of the offense under section 304A stroke 1061 of the BNS, the parties to the list had appeared before the court seeking settlement of the amount. The settlement amount that was projected in the memorandum of settlement between the accused and the complainant was 2 lakhs. This court did not accept that the value of the death of a child would be at 2 lakhs. It was indicated that the accused should come up with a better offer. On 1/7/2026, they did come up with a better offer, and this court recorded the following. Today, the learned counsel for the petitioner has in his hands a demand draft of rupees 5 lakhs. Every month. 5 lakhs, and has undertaken that the remaining amount of 6,20,000 would be paid to the father of the victim at 10,000 rupees every month.
1,20,000.
1,20,000 ಹೇಳಿದ್ದು. 1,20,000. 10,000 each for 1 year. Therefore, the petitioners, the respondent complainant being a poor laborer, would undoubtedly spend the money of 5 lakhs if it is handed over to him. He has other children. Therefore, the said amount be invested by the petitioner, the demand draft that he holds be deposited in the post office.
PMS.
Post office monthly saving scheme.
PMS monthly savings.
PMS monthly saving scheme. After opening an account in the name of the complainant, the amount of interest that it generates from time to time shall be handed over to the post office authority shall hand over. Arrangements be made by the petitioner that the post office authorities would hand over the interest every month to the respondent. On 10 years earlier.
Actually, the 5 years is for me. ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ನಾವು extend ಮಾಡ್ಕೊಬಹುದು.
For the next 5 years, as the scheme is for 5 years, the interest shall be taken by the complainant. In ಬೇರೆ ಮಕ್ಕಳಿದಾರಲ್ವಾ? ಇಬ್ಬರಿದಾರಲ್ಲ. Interest shall be taken by the complainant for the welfare of the other 2 children that he has. And the post office, ಅದರಲ್ಲಿ girls ಇದಾರಾ?
Lady. एक लड़की एक लड़का. ಒಂದು ಹುಡುಗಿ ಒಂದು ಹುಡುಗ.
ಸರಿ. Therefore, the interest, the fixed deposit, the scheme and in the post office shall be renewed up to the girl attaining the age of 18 years. It is then the complainant would be entitled to withdraw the said amount for the purposes later. Therefore, the post office where it will be deposited without any hindrance permit the complainant to withdraw the interest that it gets accrued month on month and every month. The month on month and every month, the undertaking of the petitioner that he would pay 10,000 rupees every month for the next 12 months is also recorded. In the event the amount is not paid by the complainant, by the petitioners, it is open to the complainant to seek revival of the subject petition. With the aforesaid observation and for the aforesaid reasons, the petitions disposed are allowed cost.
My lord, ಇದು ನಾವೇ PM ಓಪನ್ ಮಾಡಿ
ನೀವೇ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳಿ.
ಆಗ್ಬೋದು ಸರ್.
ಹೌದು. ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ ಹೇಳಿ ಅವ್ರಿಗೆಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಆಗ್ಬೋದು ಸರ್. ಹೇಳ್ತೀನಿ.
Laborer, he will not know anything. You help him in doing it.
Okay.
Yes, anyway, I have quashed it.
Okay.
So you should help him in doing it. Yes.
Obvious.
Admission 26.
For the petitioner, your lordship. Petitioner is now read as accused number 1, your lordship, in the charge sheet. The respondent, offense 406/420. The respondent number 2 had entered into a lease agreement with one Sachidananda, who is now accused number 2. And then, your lordships, on 3/5 on page number 53, your lordships, a surrender of lease scheduled property was handed over, was made between the Sachidananda and the complainant. And there, the property was, the possession was taken over by the complainant. There was a MOU between the Sachidananda and petitioner that to run the business, to carry on the business after surrender. But till date, the property is not handed over to me. But since the MOU is there that I will run the business, now the allegation in the complaint is that I was running the business and I have been not paying the rent.
Civil suit ಹಾಕಿದಾರಾ?
ಇಲ್ಲ.
Yes, sir.
Last time a submission was made, civil suit ಹಾಕಿದ eviction order. Then I clarified, ಇಲ್ಲೇನೆ ಹಾಕಿಲ್ಲ. 1 week time ಬೇಕು.
No time, sir. 2023 ಮ್ಯಾಟರ್ಗಳಿವೆಲ್ಲ.
Senior ಬರ್ತಾರೆ.
ಯಾರು ಏನು ಇರ್ಬೇಕಿಲ್ಲಿ. Pass over. Get him.
Please,
offense is SC/ST Atrocities Act. Even from the complaint itself, it's very clear that there is no public view. ಯಾರು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಬಂದ್ರು ನಮಗೆ ಬೈದ್ರು.
ಹಂಗೆ ಇದಾರ.
Page number 22.
ಬರೀ Atrocities Act.
504, 506.
ಅದ ಇದ್ದೇ ಇರುತ್ತೆ.
Yes, there is also a civil dispute. Page number 22.
Where is the complaint?
Page number 22.
22.
7/9/2005 6 ಗಂಟೆ ಸಮಯ ನಮ್ಮ ಮನೆ ಹತ್ತಿರ ಯಾರು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಚೆನ್ನೈಗೆ ಒಂದು ಹಲ್ಲೆ ಮಾಡೋ ಪ್ರಯತ್ನಿಸಿದನು. ಒಡ್ಡರು ಮಾದಿಗರು ಎಂದು ನಿಂದಿಸಿದನು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ. ಚಾರ್ಜ್ ಶೀಟ್ ದಟ್ ಈಸ್ ಪೇಜ್ ನಂಬರ್ 27.
ಸಿವಿಲ್ ಸೂಟ್ ಏನು?
ಪ್ಲೀಸ್
ನಂಬರ್ ಏನು? ಪರ್ಪಸ್ ಏನು?
OS number 512 of 2016.
For
2016. RA number 106 of 2015. There are 3 for suits. In complaint, they volunteer.
ಕಂಪ್ಲೇಂಟ್ ಯಾವ ಪೇಜ್?
ಪೇಜ್ ನಂಬರ್ 22.
22
ಅದರಲ್ಲಿ ಸದರಿ ಸ್ವತ್ತಿನ ಮೇಲೆ ಮಾನ್ಯ ದಾವೆ ನಂಬರ್ OS ನಂಬರ್ 502 2016 ಚೆನ್ನೈಗೆ ವ್ಯಕ್ತಿ ನಮ್ಮ ಮೇಲೆ ಪ್ರಕರಣ ಹೂಡಿದೆ ಎಂದು ಪ್ರಕರಣ ವಜಾವಾಗಿರುತ್ತದೆ. ಮಾರಪ್ಪ ಮತ್ತು ಕುಟುಂಬ ಪರವಾಗಿ ಆದೇಶ ಬಂದಿರುತ್ತದೆ. ಮಾರಪ್ಪ ಮತ್ತು ಕುಟುಂಬ OS ದಾವೆ ನಂಬರ್ 418 2006 ಮಾರಪ್ಪ ಚೆನ್ನೈಗೆ ಮೇಲೆ ದಾವೆ ಹೂಡಿದ್ದು.
The petitioner is before the court calling in question proceedings in special case 1225 of 2023. Heard so and so. Facts in brief germane are as follows. On an incident that takes place on 7/9/2023, a complaint comes to be registered by the second respondent complainant, alleging hurling of abuses which could become the ingredients of the offences under section 31R and S of the Atrocities Act. The police conduct this becomes a complaint, crime in crime number 725 of 2023 for the aforesaid offences. The police file, post investigation, the police file a charge sheet. Filing of the charge sheet has driven the present petitioner to this court in the subject petition on the score that the offences under the Atrocities Act can never be alleged against the case at hand. This court, in terms, had granted an interim order of stay 3 years ago, and the same is subsisting even today. The learned counsel appearing for the petitioner submits that the very complaint is that the petitioner has allegedly hurled abuse not in a public place or a place of public view, but where there were nobody. He would submit that this could not have resulted in the charge sheet being filed by the police at all. Per contra, the learned counsel appearing for the complainant would submit that the police have filed a charge sheet post investigation. Therefore, it is a matter of trial for the petitioners to come out clean. The learned HCGP would also toe the lines of the learned counsel to seeking dismissal of the petition. I have given my source. Therefore, narrated facts are not in dispute. An incident that triggers registration of the crime happens on 8/9/2023. 8/9, huh?
7/9.
7/9/2023. The next day, the complaint is registered. The complaint reads as follows, page 22. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column 17 reads as follows, page 27. If the complaint and the charge sheet are read in tandem, what would unmistakably emerge is that the offences under the Atrocities Act cannot be laid against the petitioner for the reason that the allegation itself is not that it has taken place in a public view or in a public place. A public place howdo yaru irlilla anta. Public place or a public view. The offences alleged are the ones punishable under section 31R and S. They read as follows. 31R requires hurling of abuses with an intention to insult in a public place. 31S requires the hurling of abuses with an intention to insult in a place of public view. In the case at hand, the complaint itself narrates that the abuses were hurled in a place where no one was there. Therefore, though it is a public place, it was not in place of public view or in front of people. It was between the petitioner and the complainant. It is in these circumstances the apex court, and it would become apposite to refer to the judgment of the apex court interpreting the offences under section 31R and S. The apex court in 2026 SSC online SC page 834 in the case of Gunjan was a state Gunjan was a state has held as follows. Court para 5.1 to 9.1. In the light of the judgment of the apex court, which considers the entire spectrum of the law, permitting further proceedings against this petitioner would become an abuse of the process of the law and result in miscarriage of justice. Allowed post.
Lordship,
28.
I'm appearing for the petitioners in this case, my lordship.
Offense in.
For the offences punishable under section 420, 506, 504 and read with section 34 of IPC. Lordship, she has filed this case for recovery of the money, my lordship.
Page.
Kindly peruse that page number 22, my lordship, the 10 para 10 of the...
Husband and wife.
They are not husband and wife, my lordship. The petitioners are husband and wife, my lordship. Petitioner number 1 is the wife. Petitioner number 2 is
complainant. Yaru?
Complainant is the known person, my lordship.
Known person.
My lordship, on the same day, my lordship, on the date of alleged incident, my lordship, their marriage was there, my lordship. May kindly peruse that page number 24, my lordship. The nikah of the petitioner number 3, my lordship, who is the son of the petitioner number 1 and 2. May kindly peruse, my lordship, one more submission would be, my lordship, at the same time of the incident also, my lordship, they were, the nikah was, ceremony was there, my lordship, at 12:30, my lordship. May kindly peruse, my lordship, nikah also, my lordship. Invitation card, my lordship.
ಎರಡು ಕಂಪ್ಲೇಂಟ್ ಇದೆ ಯಾವುದು?
That one is for 138 she has filed.
Which is 138?
138 is, my lordship,
No, that is, this case does not concern 138.
no, my lordship. 188 PCR, through PCR she has approached, my lordship.
The petitioners are accused 1, 2 and 3, 1, 2, 3 and 4 are before the court calling in question the proceedings in crime number 158 of 2018. Ada?
Yes, my lordship, please, my lordship.
2018 registered for offences punishable under section 420, 504, 506 of the IPC. The petitioners, it is the case of the complainant that somewhere in the year 2017, she lent an amount of rupees 12 lakhs as a loan. And after about a year for the said lending, the petitioners are said to have issued certain checks. The checks having been dishonored, separate proceeding is taken up under section 1 for offence punishable under section 138 of the Negotiable Instruments Act. A month before taking steps to prosecute these petitioners for the offence under section 138 of the Negotiable Instruments Act, the petitioner files the subject private complaint invoking section 200 of the CRPC. Private complaint thane?
Please, yes, please, my lordship, please.
The matter was referred for investigation and a crime in crime number 158 of 2018 comes to be registered. The police conduct investigation and file a charge sheet. Filing of the charge sheet has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner has set the criminal law into motion for the purpose of recovery of money, which cannot be permitted. The learned counsel further submit that the proceedings under section 138 of the Negotiable Instruments Act are also instituted by the very petitioner a month before, 1 month after the setting the criminal law into motion for the aforesaid offences. He would seek the obliteration of the entire proceedings. The complainant, though served long ago, remains unrepresented even today. Therefore, the learned HCGP is heard in the matter. The learned HCGP, Deepthi Alva, appearing for the respondent, appearing for the state, would submit that the police, after investigation, have filed a charge sheet. Therefore, the petitioners must be permitted to face trial and come out clean in a full-blown trial, as the offences are clearly made out in the case at hand. I have given my, so therefore narrated facts lie in a narrow compass. A transaction between the petitioners and the complainant is in the year 2017. Two proceedings have sprung out of the said action. One is for the dishonor of the checks said to have been issued by the petitioner. The complaint in the case at hand comes to be registered on in crime number 158 of 2018 on a complaint which reads as follows. Page
10 minutes.
Page 12 to 14 marked portion. The complaint is referred for investigation, which becomes a crime in crime number 158 of 2018 for offence punishable under 420, 504, 506. The police conduct investigation and file a charge sheet. The summary of the charge sheet is as follows, page 33. The offences that are alleged in the charge sheet is not under for offence punishable under 420, but only 504 and 506. The summary of the charge sheet would not indicate even a titter of offence, the ingredient of the offence under section 504 or 506 of the IPC. Interpretation of section 504 or 506 need not detain this court for long or delve deep into the matter. The apex court in Muhammad Wajid versus State of Bihar 2023 SEC Online SC page 951 has 951 formulates an issue as to what would become the ingredients of section 504 and 506. They are found in section 503. A perusal at section 5 perusal at the complaint or the summary of the charge sheet would not indicate even an iota of ingredient of offence under section 503 for it to become offence under section 504 or 506, permitting further proceedings against these petitioners in the light of the aforesaid in the light of the law laid down by the apex court and the summary of the charge sheet would become an abuse of the process of the law and result in miscarriage of justice. Allowed cost. Next.
Deeply applicable.
29.
The husband and wife petition. Stay was granted to petition number 2 to 4. Petition number 1. Divorce petition was filed on 4/12/2023. Immediately on the next day, wife appeared and filed the wakalat and demanded for the 3 crores.
Why
I
3
told
crores,
I pay this something monthly. She's on that day,
Husband
mutual
go stay
consent was
ಆಗೋಗಿದೆಯಾ ಇಲ್ಲಿ?
husband filed. The mutual consent was failed. Again, on the next 1 month, she filed this complaint, false complaint, 5 pages complaint.
ಯಾಕೆ ಪೇಜ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತಾ?
ಅಲ್ಲ ಅದ್ರದ್ದು ಹೇಳಿದ್ದವ್ರು ಅಲಿಗೇಷನ್ 1 year ಮೇಲೆ ಆಫ್ಟರ್
This is what you told your
ಮ್ಯಾರೇಜ್ ಆಗಿರೋದು 2023.
ಒಂದ್ ನಿಮಿಷ.
Memo of retirement I have filed. my
ಇವ್ರು
lord,
ಯಾರು?
that the new
I am undertake to file the wakalat for R2
ರೆಡಿ ಇದ್ದೀರಾ?
as per direction of legal service committee.
ಅಲ್ಲ ರೆಡಿ ಇದ್ದೀರಾ? ಇಲ್ವಾ?
Next time.
Learned, sorry, I forget your name. Learned counsel so and so submits that she has retired from this case and the counsel so and so has been entrusted with the matter. List this matter next Thursday in the same stage. Interim order subsisting will continue.
Granted to petition number 1 also.
Seriously. Bada santosh. Yes. List on Thursday, next Thursday, same stage, same.
Interim order may be extended.
The interim order as subsisting will continue. Madam, next week ready agiri.
30.
Hearing for the petitioner, my lord. Petitioner, my lord, is accused number 1. Offense is under section
Husband.
4. Please, my lord. My
Yes,
lordship
madam.
has granted stay in this matter.
ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಾ?
Please.
By mistake ಇರ್ಬೇಕು.
Illa, I'll take my lordship to the case. My lord, after marriage, my lord, petitioner and R2, my lord, moved to the US. My lord, husband, my lord, in page number 64, my lord, of the petition, files for a protection order, my lord, against the wife because she files a domestic violence case against the husband, my lord, in page number 65. I'll take my lordship to domestic violence case, which is in page number 65. The same, my lord, after thorough investigation, prosecution is declined. If my lordship finds exceptional clearance date 10/8/24, 11/11 prosecution declined. My lord, page number 65.
No,
my
who
lord.
appears for respond?
She has
Served, is it?
It's served, my lord. It's served. Page number 62, my lord, husband files for a protection order. Same is allowed. Page number 62, my lord. The court finds that the petition requested respondent 62, my lordship. Please, my lord. Husband, my lord, in page number 78.
When did she come back?
She, my lord, she comes back to India, files complaint against the husband
When
on
did she come back and
19/8/24. Complaint is registered on 19/8/24. She goes back, my lord. She files one DV case there.
Where?
In the US. She files a DV case against husband in US, which is declined. She comes back to India, files a 498A. Husband files for a protection order, which is allowed.
That
She
is in
again
US.
goes back. Please, she again goes back to US, my lord. Husband's filed for a divorce.
Again goes back to US.
Please, she goes back to US.
Hmm.
If my lordship can see in page number 62, it is a contested case for protection
ಸರಿ,
order.
divorce ಆಯ್ತಾ ಆಮೇಲೆ?
Divorce ಆಗಿದೆ. 78 ಅಲ್ಲಿ divorce is granted. Page number 78. She goes back, my lord, and divorce is granted. Now, my lord, she comes to India. She's married, my lord.
Married?
She's married here, remarried after divorce, securing divorce. She's not coming before the court, my lord.
No, this complaint was registered in the interregnum.
Please, my lord. 78 is the divorce order. If my lordship sees, she first files for a DV Act there. After getting that rejected, she comes to India, files a complaint here, my lord. He, my lord, has difficulty in getting his passport renewed. He's not able to come pendency of this case.
He is
Now,
in
my
the US,
lord,
is it now?
Please, my lord, he is in the US. I have filed the lease agreement, his driving license and his ID card, my lord, to show that he's
ಏನು
not-
ಇಲ್ವಾ? ಅಲ್ಲ ಎಲ್ಲ ಇಲ್ಲ. ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ವಾ ಈಗ?
ಅಲ್ಲ ಅಲ್ಲಿದೆ, he is there. He's not able to come, my lord.
Not able to come back.
He's not able to come back because pendency of this case, visa clearance is getting issued. Issue is that, my lord, clearance of visa, my lord, because of the pendency of criminal case.
Yes, Deepthi madam.
There's some charges against him, your lordship.
Prior to filing of this complaint, she files a case there, my lord. Even the protection is contested, even the divorce is contested.
Hmm. Where's complaint?
Page number 38, my lord. Complaint is in page number 38.
Thirty?
38, my lord. They get married on 27/4. They fly to US, my lord, on 23/5. She, my lord, goes to the office of the husband, my lord,
Where?
tries
US?
in the US, and she starts filing complaints. She'll try to reach out friends, my lord. Hence, my lord, looking into those facts, the US court, my lord, grants a protection order from restraining wife, my lord, to reaching out husband to office or at home, my lord. Detailed protection order is in page number 62, my lord.
Hmm.
After a thorough investigation, my lord, DV Act, domestic violence case is dismissed, my lord. The case filed by wife.
Yeah. No, no time will be granted. These are all listed for disposal, madam. ಅದು ಬರೀ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ತಗೊಂತಾರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಲ್ಲ ಅಂತ ಎಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಈಗ. The petitioner accused number 1 is before the court calling in question the registration of calling in question proceedings in CC 30347 of 2024 registered for offences punishable under section 498A, 323, 504, 506 read with 3 and 4 of the Dowry Prohibition Act. The petitioner and the respondent complainant get married on 27/4/2023. Immediately thereafter, fly to the United States, where the husband had his avocation and lived there for about a year. The relationship between the petitioner and the respondent complainant appears to have floundered while in the United States, and therefore certain proceedings are taken up both by the husband and the respondent wife before the respective courts in the before the respective courts in Michigan, Massachusetts. The court therein declines to accept the plea of the wife of domestic violence, but in turn accepts the plea of the husband seeking protection from the hands of the wife and issues protective orders. In the teeth of the said orders, the wife is said to have the wife is said to have traveled back to the shores of the nation and registers a complaint in crime number 74 of 2024 for the aforequoted offences. Registering the complaint, she flies back to the US. Innond case hakadರಲ್ಲಿ
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
flies back to the US and is said to have married and settled with someone else. The crime is investigated into by the jurisdictional police, and police and a charge sheet is filed, which is pending before the concerned court as CC 30347 of 2024. Caught in this quagmire, the petitioner husband is before the court in the subject petition. The learned counsel for the petitioner, Raksha Kirtana, would take this court through the documents appended to the petition. Srimati Raksha Kirtana would take this court through the documents appended to the petition to demonstrate that the petitioner husband had suffered at the hands of the wife even in the United States, and therefore had to apply for seeking protective orders. Protective orders are granted by the court at the United States, and in turn the petitioner, the complainant wife, had alleged domestic violence by the hands of the husband again in the court at United States, the court declines to accept and dismisses the plea of domestic violence. After losing the said case, comes to India and registers the subject crime and goes back to the United States. The petitioners are now divorced by before a competent court in the state of Michigan, and therefore would submit that the proceedings must be obliterated as the wife has now remarried and is not interested even in prosecuting the subject petition. And the petitioner, due to the pendency of these proceedings, is not able to get his passport renewed nor any other statutory document renewed in the United States or in this country as the case would be. The petitioner The aforenarrated facts, link in the chain of events, and the dates are all a matter of record. They would not require any reiteration. Suffice it would be to start the narration with the order passed by the courts at Michigan. Where is that domestic violence?
My lord, page number 65, my lord.
The court declines to accept the plea of domestic violence that is projected by the wife. Where is that closure? Page
65 wale my lord, prosecution declined.
65.
65. Exceptional clearance reason.
The endorsement that is issued by the court, by the jurisdictional police therein of domestic violence is as follows, page 65. The petitioner husband applies for protective orders. That is granted. Where is that?
62, my lord.
60?
62. Page number 62.
Where do I get the operative portion?
It is ordered, my lord. It is the court finds that
Page.
62, my lord. It
is ordered,
It
yes.
is ordered, my lord.
Yeah, is the court
Entering into property where petitioner lives.
Therefore, the wife is stopped from entering into the property where the husband lived, owing to the counter violence alleged from the hands of the wife to the husband. The wife then comes back to the shores of the nation, registers a complaint of the offense of demand of dowry, cruelty on demand of dowry. The complaint, though in detailed narration, lacks the basic ingredients of the offense under section 498A of the IPC. All that has happened from the date of marriage and in the United States is sought to be projected in the complaint after having failed to secure any orders from the hands of the competent authorities in the United States. The gist of the complaint is as follows. Page 42, 41. The police conduct investigation and file a charge sheet. The summary of the charge sheet is as follows. A perusal at the summary of the charge sheet would indicate vague instances of alleged torture, while there is none being projected by the petitioner in the case at hand. Though the case concerns the husband, it is not that it is no rule that if the husband is the accused, proceedings must be permitted to be continued. The apex court, even in cases where the husbands are drawn into the proceedings without any rhyme or reason, has directed the courts to examine the issue beyond the complaint and arrive at a finding even against them. The apex court in Achin Gupta, 2025, 3 SCC, page 756, has held as follows. Court para 24 and 32. The apex court later in 2025 SCC online SC page 2890 has again considered that without rhyme or reason, the husband and the relatives of the husband are being dragged into the proceedings, which on the face of it would become an abuse of the process of the law. Para 22, 24 and 27. Both the cases concern, the case of Achin Gupta concerns only the husband. The case of Swagat Kumar Supra concerns the husband and other relatives, both of which clearly lay down that without there being any allegation, the husband or the members of the family are drawn into the web of proceedings. In the peculiar facts where there is nothing found against the husband, more so in the light of the fact that the wife is not appearing before the court on the score that she has already married someone else after divorce and is living with is living, the further proceedings, if permitted to continue, would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, allowed, quashed.
Oblige.
Yes.
31.
Appellant, my lord, is a 498A case.
ಅದು ಅದೇನಾ
498A.
ಸರ್ವ್ಡಾ ಇದರ
Is that
ಫಸ್ಟ್ ಟೈಮ್
first time? Sir.
ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆಯಾ?
First time birthday.
The 498A is all else except husband.
Interim order will grant.
Huh?
Interim order.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ಈಗ ಹಸ್ಬೆಂಡ್ಗಿಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ.
Husband bid well.
Yes. Next.
1 to 4 is there. Still is there.
Huh?
1 to 4 ಇದ್ದಾರೆ ಸೋನಲ್ಲಿ.
ಗೊತ್ತು ಒನ್ಗಿಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
But now.
Yes.
32.
Same issue, but 498. In-laws are there
ಏನು
before.
498 ಏನ ಇವತ್ತು? All are 498. In-laws ಆ?
In-laws, in-laws. Omnibus allegations that they support.
Entry ಮಾಡಿಲ್ವಾ?
There, notice was issued, so there was no.
No entry ಮಾಡಿ.
No entry. Now it's, charges will be framed, not otherwise.
Petitioners ಯಾರು?
They are the in-laws of the, and the complainant's daughter.
Accused numbers?
2 and 3.
Heard the learned counsel, Sunil Rao, appearing for the petitioner. The allegation against the petitioners accused number 2 and 3, as found in the summary of charge sheet, is as follows. This can by no stretch of imagination become the ingredients of offense under section 498A of the, there shall be an interim order of stay where these petitioners till the next date of hearing. Yes, next.
33.
My lord, I'm for 126 class.
Sorry, page ಹೇಳಿಲ್ಲ. Mark ಮಾಡಿ page ಹೇಳಿಲ್ಲ. ಆಮೇಲೆ ಅವ್ರು ಹುಡುಕ್ತಾ ಕೂತ್ಕೋಬೇಕು.
My lord, I'm for respond number 2.
ಒಂದು ನಿಮಿಷ.
Please.
ನೋಡು. Page 32. Yes.
Offense punishment 126 class 2, 126 class 2, 354 class 4, 74, 115 class 2, 352, 351 class 2.
126. Yes.
76, my lord. 74.
Page.
My lord.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ.
Charge sheet is filed, my lord, and cognizance
There is
has
a
been taken.
civil dispute, my lord, the complainant and petitioner. Page number 29, my lord.
ಸೀರೆ ಹಿಡಿದು ಎಳೆದಿದ್ದೀರಾ ಅಂತದೆ.
That's not the
Civil dispute license ಅದು.
ಅಲ್ಲ, so I am also filed a complaint against the complainant.
Same complaint, huh?
No, it's
17,
a
crime
case
number
of
17.
Case and counter case, my lord. And both the FIRs have been registered after a delay of 2 days, my lord.
ಎರಡು ನಡೀಲಿ ಬಿಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ ಎರಡರಲ್ಲೂ?
Charge sheet ಆಗಿದೆ.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
No, my lord. So far not.
So far,
So far no.
my lord, my crime number, my lord, 17, my lord.
No,
Their
there are
crime
three
number
eyewitnesses
19,
to
my
the
lord.
offense.
Correct, ಇಲ್ಲಿದೆ.
Please.
ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ?
My lord, there are 3 eyewitnesses to the offense. I
No,
have to
this we
obtain-
will not a problem, but if you want to settle it, settle it.
Please, my lord, I'll get the instructions.
Let's the matter on 24th.
ಅಲ್ಲ, ಅಲ್ಲಿ ಚಾರ್ಜ್ ನಡೀತು.
Parval, parties to explore the possibilities of a settlement, if any. In the event there is no settlement, matter would be considered on its merit.
May
Yes.
contribution not to charge my lord. The charge ನಡೀತಾ charge
ನಡೀಲಿ
ಆಗ್ತಾರೆ
ಬಿಡಿ.
day by day my lord. Kindly my lord, I request before
ಚಾರ್ಜ್
this court.
ಫ್ರೇಮ್ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಕನ್ವಿಕ್ಟ್ ಏನ್ ಆಗಲ್ಲ ತಾನೆ. ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದ್ರು ಮಾಡಿ.
Any short date?
24th sir.
Please.
Yes.
34.
Forwarding of my lord social media post, my lord, where?
Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ, fresh. Somebody forwarded, my lord, the document which has been forwarded is the
ಯಾಕೆ
allegation.
ನೀವು ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ?
My lord, some other counsel was there, my lord, took adjournment, it seems, my lord. Now, learned friend has filed NOC. Only the complaint was against unknown persons, my lord. Now the charge sheet has been filed for 425, 469 and 201 IPC. Complaint against unknown persons, my lord. There are other offences also. 505 plus 1 also there. They only, my lord, caught the person who forwarded.
ಫೋರ್ಸ್ ಮಾಡಿದ್ದೀರಾ ಅಂತಿದೆ?
ಇಲ್ಲ, there is no
ಅದು
allegation
ಯಾರ್ದು?
of forwarded ಅಂತ.
ಹೆಂಗ್ ಮಾಡಕ್ ಆಗತ್ತೆ? ಇವ್ರನ್ನ ಫೋರ್ಸ್ ನೀವು?
What has happened is, my
What do you
lord,
mean?
he said, my lord,
ಅಲ್ವಾ?
if so and so wins
ಮತ್ತೆ?
in the election, I will resign to the MLA.
He won.
post. He won.
ಹಾ.
Thereafter,
You did
this
not
came,
resign.
he did not resign. Somebody forwarded
crime.
this and further forwarded. That's all.
The main time is great. Next, heard the land seen in the council.
My lord, I appear for the petitioner, my lord. The charge sheet is filed under Prize and Money Circulation Scheme Banning Act, my lord. The other provisions were deleted, 423 and
Correct,
4.
madam. Price sheet ಸಾಕಲ್ಲ.
My lord, my submission is this, my lord. The complaint is none other than the ASI, my lord, the police.
No problem, madam.
No
No
moto complaint has been. Yeah. Then, my lord, the charge sheet came to be filed on 23/6/18, my lord. Kindly peruse the final report, my lord, which is filed by the police, my lord.
We'll continue at 2:30.
Your lordships, one.
My
Your
lord,
lordship.
I have little inconvenience at 2:30. Can it be taken on some
We'll
other,
take it next week. Yes.
any
Your
date,
lordship.
my lord?
Next same day. Yes.
One memo,
Much
my
obliged.
lord. CBI has freezed my bank accounts, my lord.
Sorry?
CBI has freezed my bank accounts, my lords. They are issuing NBW. Some urgency, my lords.
ನಿಮ್ದೇನು?
Lordship, promise to marry, relationship of 2 years, and the complainant is
ಬೆಳಗ್ಗೆ
married.
ಯಾಕೆ ಮೂವ್ ಮಾಡ್ಲಿಲ್ಲ?
Lordship, ಬೆಳಗ್ಗೆ, there were a lot of.
ಅದಕ್ಕೆ ಈಗ ಬೆಸ್ಟ್ ಟೈಮ್ ಟು ಮೂವ್ ಅಂತ.
I'm so, I didn't want to trouble
Move
you.
it tomorrow.
Can we have?
All of you
can
move
it
it
be taken
tomorrow.
up?
Tomorrow morning you move. Let me see tomorrow. ಯಾವ ಡಿಸಿಪ್ಲಿನ್ ಇರುತ್ತೆ? Tomorrow. Move it tomorrow.
But serial number 24, list 1, my lord. Interim order was granted, my lord. The police was directed to deposit the money in the bank account.
ಏನಾಯ್ತು ಅದಕ್ಕೆ?
The magistrate also may be included.
ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅದು PF ಮಾಡಿದಾರಾ? ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ?
After 10 days, my lord.
ಮಾಡಿದ್ರೆ ವಿಲ್ ಸಿ. ಯಾವ್ದು ಸಿಲ್ ನಂಬರ್? ಮಿಕ್ಕಿದ್ ಕರೆದು ಬಿಡಿ ಮೇಡಮ್ ನೋಡಿ.
Page wise adjournment. Page 7. 36 and 37.
My lord, sir,
Page
37. my lord.
30?
37.
Ah.
List 2, my lord, sir. Raise for adjournment, my lord.
ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲವಾ?
Yes, my lord.
ಓ ನಿಮ್ದಾ? ವೇಟ್. ನೋ. ಎಸ್. ಅವರು ರಾಡ್ ಎಲ್ಲ ಹಾಕ್ಸ್ಕೊಂಡಿದಾರಂತೆ.
Page 8.
Kindly, my lord, sir.
No, sir.
Serial
I'm
number
not granting.
36. I
If
want to
there is
withdraw my.
objection, I'm not granting at all. Yes.
I want to withdraw my
sir.
impleading application, my lord. Serial number 36.
36 ಏನು?
I'm just withdrawing my impleading application, my lords. My impleading application.
You are still yet to come into the scene. Wait.
Page 8.
36 ಏನು adjournment ಬೇಕಾ? That's at 1 crore deposit. What's happened later?
The company has been admitted to insolvency.
That we'll see. We'll take it. The ozone.
Yes, my lord. But there are also few things I wanted to point out. There are also few things I want to point out on the.
ಏನು?
But the DD which I've received was from NR residences. When I went
ಈ
to
ದುಡ್ಡು
the-
ಬಂತಾ? ಬಂದಿದೆ ತಾನೆ. ಸರಿ ಆಯ್ತು.
It is from the CEO who was there in the company.
ಅಲ್ಲ ಯು ಗಾಟ್ ಮನಿ ರೈಟ್. ಅವರು ಬೇಕಂತ ಕನೆಕ್ಷನ್ ಆಗ್ಬಾರ್ದು ಅಂತ ಬೇರೆಯವ್ರ ಮೂಲಕ ಕೊಡ್ಸಿರ್ತಾರೆ ಅಷ್ಟೇ ಸಿಂಪಲ್.
1 crore 80.
That it doesn't want to get into the web. That's why somebody else will regulate.
1 crore 88 crore lakh still.
Inna?
1 crore 88 lakh still.
Yes, Deepak.
He has to go before the NCLT now because of insolvency.
We'll see. Yes, we'll take it after 2 weeks. Yes. One ನಿಮಿಷ. I'll come.
Page 8, 38 to 42.
39, 38.
39 ಏನು?
There for 1 week's time.
Intermod ಇದೆಯಾ?
ಇಲ್ಲ.
At the request 2 weeks. Yes.
38, my lord.
At the request the council appearing for the petition 2 weeks.
38, my lord.
38 ಏನು ಧೀರಜ್?
My lord, a week's time. my lord.
There's an interim order operating.
What's the interim order?
That's the proceedings before the magistrate has been stayed.
Pollution.
Pollution.
ಏನು pollution ಮಾಡಿದ್ದಾರೆ?
To show that, that's
Pollution ಇಲ್ವಾ?
the solution was only that.
Only crime.
That's the only option.
ಆಯ್ತು. Finally 1 week.
That's why I have it tomorrow. Next week, same time.
let's
It's not
we'll-
tomorrow, sir. Next week.
Lord, there is one thing. My learned friend should also produce the administrative approval of the chairman because that is covered by your lordship's judgment. That's the only reason.
Correct. Kudi. You will produce it. Why are you worried?
Copy is not served on me. That's the reason.
Yes.
Interim
Wait.
order requires to be extended.
Next week.
Next Thursday.
Please.
As a last chance.
Please.
Interim order stands extended. 41. Learned Counsel P. Usman submits that he has entered appearance for the respondent complainant, registry to print the name of so and so is appearing for the complainant. Interim order ಇದೆಯಾ? Then list date ಕೊಡಿ madam. List on 21st. The fresh matters list. Yes.
My lord, serial number 43, list 2.
Page 9,
I appeal for the respondent.
43 to 46.
43 ಏನು sir?
Seek time to file objections. There is an interim order.
Interim order. Yes. Counsel Kapil Dev Ullal seeks 2 weeks time to file statement of objections. List on 23rd July. Objections, if any, by then. Interim order subsisting would continue till the next date of hearing. Preliminary hearing.
Serial number 49, my lord.
One ನಿಮಿಷ.
Second list.
ಒಂದು ನಿಮಿಷ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ. ಅಲ್ಲ 44, 45, 46 ಏನಿಲ್ವಾ? Yes.
49, my lord. The connected matter.
49 ಏನ್ ಬೇಕು?
ಅದು connected matter listed on 17th, my lord. That same day.
17th, yes.
My lord, serial number 48, the matter is settled in BMC. It was signed, mediation agreement was signed on 7th. It's being called out today for reporting, so can
What,
we have it?
when do you want? Next week?
24th August.
24th. August? Why?
The parties are not available.
Not willing.
No, they're not available, they're traveling.
Mediation, you get the mediation papers, that's enough. I'll take it on 24th July.
Okay, ma'am. Much obliged.
ಇನ್ಯಾವುದಿಲ್ಲಲ್ಲ? Other hearing. 2:30. 2:30. Where are you moving now? Move it tomorrow. Yes. When? Reserved. Which one? ಯಾವುದು? Huh. What judgment? On what? Lokasa? No. We should follow Supreme Court or Punjab Haryana High Court. We'll see. Yes. ಅದು ಸಾನ್ಯಾ ಮೇಡಮ್ ನಿಮ್ ಕೇಸ್ ಇದೆ, ಅವರು ಕಾಪಿ ಕೊಡಿ. ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ? ರೇಸರ್ ಪೇದಲ್ವಾ? ಹಾ. Delivered a baby. So? Not tomorrow, Monday. Try ಮಾಡಿದ್ರಾ? ನೀವು ಈ ತರ ಮಾಡಿದ್ರೆ ಯಾವುದು ಆಗಲ್ಲ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. You don't follow anything, I can't help it. ಅದು ಏನ್ ಮಾಡೋದು? Morning if you are in chaos like this, I also can't handle. ಬರಲ್ಲ, ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ. ಎಸ್ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ.
Fresh matters at 2:30 PM. Number 54.
What are these matters? Observed. Oh, ಆಯ್ತು ಸರ್, ಆಯ್ತು. Now one by one. Yes.
Private respondent, the wife.
Except adjournment, ask anything else.
But that's
No, I'm not seeking action.
Then tell me.
No, nothing. I'm just saying that.
Fine, no problem.
That's one small submission. Milords. I appear for respondent number 2 in 54.5, who is a third person to the dispute between husband and wife. Milord. It has been connected.
You are for the petitioner.
No, for the respondent number 2, de facto complainant.
I will take it. Wait.
Milord, it is wrongfully connected.
Oh, it is not connected with this at all.
The wife is included there, my lords.
Wait, madam. Wait. Yes. Yes. What is this?
First petition. 2404.
We'll go petition by petition. 2404 of 2026. Another.
It is one for forgery.
Forgery.
Of a GPA. Where she has gone to the registrar and executed the GPA. Got same complaint. This is the first complaint given to Ramgere, Gandhinagar police station. Lord, when it comes to the other petition,
First ಇದು ಮುಗಿಸೋಣವಾ?
There's a charge file in this.
overall the allegations are one and the same.
ಒಂದು ನಿಮಿಷ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ ಇರಲಿ. ಫ್ರೇಮ್.
No, not frame. Police report is filed.
No problem. That's okay. So what?
Lord, with respect
GPA, two complaints given, one in Davangere, one in Basavadi.
with the same cause of action.
Same cause.
ಇದು ಯಾವ ಇದು CC 5512 ಎಲ್ಲಿದು?
This is Davangere. Davangere Gandhinagara Police Station.
This is Davangere. Which is Basavannagudi?
Basavadi 4718 of 2023. That is serial number 2, 54.2.
54.2, 3531.
Sorry, 4718. 4718 of 20.
That is 54.1.
Yes.
So 54 and 54.1 are on GPA forgery. One in Davangere, one in Bangalore. The instrument is the same. I'll get back to you, sir. Wait, sir. You are for the wife?
Yes.
Lot to answer. Wait, sir. Yes.
Then we have the next in the list, 54.2.
ಅದೇನು?
This is 498A, filed after 35 years of marriage. Against husband and son.
What's the age of the son?
Son is now doing MD in gynecology. 30 years.
ಆಮೇಲೆ
Then you got
54.3.
that is criminal petition 5953 of 2024. This is against husband and son for theft of car.
Which car?
One four-wheeler Altros, Tata Altros. When down payment was done by husband, loan was cleared by husband.
ಯಾರ್ RC ಯಾರ್ ನೇಮ್ ಅಲ್ಲಿ ಇದೆ?
RC is in the name of wife.
ಅವ್ರು ತಗೊಂಡ್ ಹೋಗ್ತಾರೆ ಬಿಡಿ. You forget Altros. Yes.
Now, the last number, 13659 of 2025.
13659
of 2025.
Hmm.
It is filed by mother against son for stalking and trespass, criminal trespass of a house which is owned by son.
ಇದು ಮದರ್ ಅಂದ್ರೆ ವೈಫ್.
Wife against. And criminal intimidation.
ಆಯ್ತು 54.5 ಕನೆಕ್ಷನ್ ಇಲ್ವಾ? ಡೀಲಿಂಗ್ 50 ಸಾರಿ ಡೀಲಿಂಗ್ 54.5 ಲಿಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಮೇಡಮ್? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಲಿಸ್ಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಈಗ 1 2 3 4 5 cases. ಎಲ್ಲ parties to the list same. Husband, wife, son.
There cannot be a direct presumption that just because it is a marital discord,
Yes,
there are
sir.
no criminal activities.
Absolutely, sir.
Yes. And it's with great difficulty, after many years, she decided to come to the police. And the charges are quite clear, Your Lordship. Till the estrangement, she was owner of at least 5 to 6 properties. And just before the estrangement, there's no forgery, Your Lordship. There's a fraudulent execution of the power of attorney on a date when the parents wanted to gift certain properties to the daughter. There were 3 gift deeds which were executed by the parents in favor of the daughter. On the same date, the husband slipped in a power of attorney.
Slipped in?
Yes.
Oh.
It's a fact, Your Lordship. Because, Your Lordship, based on the power of attorney, the husband executes a sale deed in favor of the son. If a mother has to give a property to the son, why should it be a sale deed? It could be a simple gift deed. And then the transaction, Your Lordship, therein, a sale consideration is paid. And the sale
But why 2 crimes?
Your Lordship, that I accede.
So one will quash.
Yes, Your Lordship, I'm willing to that. Your Lordship,
Davangere or
because
Bangalore, whatever it is, we'll see. One goes.
Yes, Your Lordship, because the other is getting in.
The other will answer on merits. One will go now, which is Davangere will go.
No. Davangere report is filed, police report is
All
filed.
right, we'll consider that. We'll take this Basavannagudi off, which is that 54.1.
4718.
4718.
Why did you register 2?
Your Lordship, this was at the chronology. The moment she found out something, she filed a complaint. It is not that all the cases were filed at the same time. And when it was this, the one, the other cheating case which was filed in Davangere, at that point of time, she got to know that there was a fraudulent execution of power of attorney and etc.
Mhm.
And when that was investigated,
You did not sign on it?
I signed on it.
On the GPA?
On the GPA, I signed on it, but totally unaware of the fact.
Unaware.
Yes, Your Lord.
What are you? You're a homemaker?
I'm a homemaker generally, but
Ah.
I used to teach in a school.
Oh, you're a teacher too. What's your qualification?
I, she's a graduate, that much I was.
So it's not that you're a nitwit that you will not know what is there in the GPS. Yes, next.
No, Your Lordship,
Next submission. Yes, sir.
Your Lordship, she grew up in a totally patriarchal system. She was very naive.
So, absolutely. She didn't know, doesn't know what is there in the GPA and things like that.
Absolutely no, Your Lordship.
Yes, sir.
Your Lordship, let me explain, Your Lordship.
Yeah, please, sir. Yes.
Your Lordship, there's a chronology. At that time, the power of attorney was executed, the sale deeds were executed, taking away all her properties. Not a single property is left with her. All her properties given to the son in a form of sale deed. The sale consideration comes to a joint account of the husband and the wife. From the said joint account, the husband takes off that money and puts it in personal account. These are all facts which are revealed in the charge, in the police report. And there has these facts prima facie should lead to a presumption that there is some criminality there.
Why? Always.
Not
We'll
always.
see. We'll decide about it. Yes. Then next.
Sort of investigation, Your Lordship.
What is investigation?
No, not
It's already a final
trial,
report.
trial. There are all the ingredients of the crime. Events have occurred,
Mhm.
and these facts are on record.
Now you are left with nothing, is it?
I'm left with nothing. My mutual funds, my joint fixed deposits, every document is with him. My father died. He bequeathed certain properties to me and my sisters.
Even that is not there with you?
No, none of the properties documents are with me.
Documents are with you, not with your properties also.
My entire family's title documents are in his possession. And he holds that to a ransom.
ಯಾಕೆ ಸರ್ ತಗೊಂಡಿದ್ದೀರಾ ಅದೆಲ್ಲ? Now, this 54.1 we will quash. 54 I'll pass an order now. Now come to 498A. When was it registered after this property is going away from the hands?
2020 is the 11th.
Concurrently it was happening.
One consent deed is entered
Between?
father-in-law,
Hmm.
husband, wife, and mother-in-law,
Hmm.
settling all the properties because she says the properties were acquired by jointly the father-in-law and my husband. This was
So,
a statement of
what did the wife get?
11/3/20.
What did the wife get?
She got a property
Hmm.
by way of gift
From?
from husband
Hmm.
to wife in 2017 itself. And this is not the matter of challenge.
No, it's all right. Now he says wife has nothing. You have taken away everything.
Not be true.
Let the trial go on.
He has two sides.
No problem. Let the trial go on. Let there be equal distribution. You can't hold the crown and give something there.
Just make a note of date 11/3/2022.
It's a consent deed.
Consent. On the very same day, one gift deed by wife to husband,
Hmm.
one gift deed by father-in-law to wife, same day,
Hmm.
and one GPA, registered GPA,
Hmm.
on the very same day.
Hmm.
All are registered documents.
Hmm.
But in fact, if I have entered into some transaction by way of registered document, let us assume, for the sake of argument, any transaction which takes place thereupon, by no stretch of imagination, any penalty can be attached. You can always say the GPA is wrong. I was forced to enter into this GPA, claim back the property, or get the sale deed cancelled. Get the sale deed cancelled, and sale deed happened to whom? To whom I have used this GPA? To her own son. I have gifted or
Now the
sold property to
relationship between you strained.
his friend. We are not together.
Hmm.
She is residing in the house property which is now standing in the name of son. And when son went to get his books, a FIR came to the lodge for stalking and criminal trespass. And he never went into the house again. She is currently residing in the house, enjoying the house property.
Which is in the name of the
In the
son.
name of son.
Why?
From last,
Why?
your son has not taken any.
No, why?
steps to-
Why in the name of the son when the wife is still alive?
Third, there was a matrimonial discord between daughter and her husband. And all the family members decided not to have the properties in the name of
Now-
wife or husband.
Oh, who decided?
Family members. This was in 2020. And that is when the GPA came about. And all the properties were shifted to son. So that son-in-law cannot claim anything. That was the family arrangement. Be that as it may,
Son-in-law yaru?
there are two.
Alla, son-in-law
there are
yaru?
two children. There are two children.
Alla, where is the son-in-law now?
Son-in-law and daughter, they had a marital discord in 2019 and 20.
ಓ ಆ son-in-law ತಪ್ಸಕ್ಕೆ ಇದನ್ನೆಲ್ಲ ಮಾಡಿದ್ದೀರಾ?
Between the family members, not only husband.
ಹ್ಮ್.
It was all the family members put together. And they decided to give it to son.
No problem. Yes, whatever.
Lordship, once
ಇದು 498 ಮೇಡಮ್ 54.2 ಕೊಡಿ. ಯಾವ್ದ್ರಲ್ಲಿ? ಇದು ಕ್ರೈಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದಾ? ಚಾಲೆಂಜ್ ಮಾಡಿರೋದೇನು ಸರ್? ಚಾರ್ಜ್ ಶೀಟೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದಲ್ವಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀರಾ? ಹ್ಮ್.
Can they have looked at the charge sheet and the IO conclusion? Page number 7.
ಈ ಡಿವೋರ್ಸ್ ಆಗಿದೆಯಾ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Pending. Matrimonial cases are pending. 35 years of marriage.
The mother used to get beaten up by the son and the husband. That was the severity of the relationship.
35 years of marriage.
ಸೋಯ್ ಆಮೇಲೆ ಬರಬಾರ್ದು ಅಂತಿದ್ಯಾ?
Now dowry arrangement case. And kindly see the conclusion drawn in the IO's report.
ಇದ್ಯಾವುದು 448, 511, 506?
The son used to hold, the father used to slap.
13659. That is stalking and trespass against son.
ಯಾವುದು?
13659.
$448.
Yes. Against son. Was then studying as 5th year MBBS student. Now he is doing in videographic evidence is collected.
1 minute. $498, there is no case. Absolute. First one, GPA, we'll see. 498A.
Your Lordship, the entire marriage
No problem.
was suffering.
No case for 498.
All these financial abuses are part of the 498, Your Lordship.
You can't wake up at any time you want and allege all that.
No, Your Lordship. I woke up after he left. No, I was, Your Lordship, the least I asked was a monthly maintenance of 20,000 rupees.
That's okay. This will not come in the way of all that.
I'm not saying, what I'm trying to say is the malice behind this, Your Lordship, and therefore 498.
498A will not get attracted at all. Other things we will consider. Yes. Ashana?
CV Prakash and Kaushik, your marks.
Maybe. So what? 498A. See, I'll tell you what. First petition will have to go. That forgery trial should be permitted. I will permit trial against you. How's GPA forgery, whatever is there, that let it go on. The second one, definitely, second one will quash it. The third one, 498A, even that has to go. And what is this car thing? What car?
Your Lordship, the card, I paid the entire installment.
RC ಅವ್ರ ಹೆಸರಲ್ಲಿದೆ, ಏನ್ ಮಾಡ್ತೀವಿ
RC is my.
ಅಷ್ಟೇ, that's all.
Subject to that direction, I'm looking.
And last one is against son for stalking and trespassing.
Son for stalking.
Your Lordship, I had an additional injunction or restraining both the father and the son.
CCTV thing.
Your Lordship, my fear is that I am absolutely petrified looking at these two people.
Why it took 35 years for you to know that?
No, Your Lordship, doesn't matter that after 35 years, these things will not come up. Merely because I suffered 35 years.
How can son stalk you or trespass into the house? I know that's why you have done it is because the house stands in the son's name. Tomorrow he may say, go out. So if you register this crime, it will be fine. This is the only reason you have registered. Absolutely nothing else.
I understand. Your Lordship, there are chronology of events when these complaints came to me.
It is not difficult to draw an analogy of your chronology. Absolutely nothing, because the house is in son's name. Register a crime against the son so that he will not intimidate, that you will
I already have
take
an
it.
order of injunction, Your Lordship.
Now then why are you worried? Why this crime?
No, therefore I'm not worried that he will come in.
Why will the son stalk a mother, sir?
Not stop, Your Lordship.
Then that's the allegation.
No, he wanted to, I don't know what, but he was with many people, not alone.
Mm-hmm.
We have CCTV thing.
Nothing. That also will go. 54.4 will go, and 54.3 will be disposed. You give up the car. Car is in her name. She has paid installment or you have paid installment. Forget it. The car, you will get the car. Car war will come down. Yes. Then for 54.2, I'm going to quash. No 498A at all in that. 54.1, anyway, dual complaint will quash. 54.
Your Lordship, I have all the documents of being beaten up, fully bled.
Good. Where is it?
The part of records, Your Lordship.
Page. In which petition have you said? Which petition is that? Page number.
I'm so sorry, Your Lordship, I'm not prepared with that.
You should come prepared, sir.
I'm sorry.
No medical records. No sir.
No? Or we'll give you time till next Thursday.
Yes, Your Lordship, please give me.
Prepare a note.
Yes, Your Lordship.
In each of the cases.
Yes, Your Lordship.
This is the prima facie view what I have told you. If you still have material to project that they are guilty, we will hold it against them.
Yes, sir.
But car case will go, son's case will go. 498 if you have, you tell me.
Yes, sir.
Next week we'll take it in the same time. Because these are 2026 matters. Monday there will be 300, 400. It's difficult, sir.
I have a excuse, my family bereavement.
When?
On 15th.
Will not take it on 15th, 16th?
Your Lordship, I have to travel to Kerala.
All right, sorry. Then 21st then.
21st.
Yes. 21st in the same stage. Interim order, if any, subsisting shall continue to the next date of hearing. ಯಾವುದು?
35, 31 of
35, 31 is 498A. ಆಮೇಲೆ?
and 13659.
That is sun stalking. Sun stalking we will stay, but not 498A. List the matter on 21st in the same stage. 1 minute, in the same stage. There's in 54.4 ಬರ್ಕೊಳ್ಳಿ madam. There shall be an interim order of stay of further proceedings, further investigation. Charge sheet ಆಗಿದೆಯಾ? Further proceedings square the petitioner till the next date of hearing. 498A, I'm not staying.
Son is also an accused.
That's okay. ಏನಾಗಲ್ಲ ಬಿಡಿ. Investigation ಆಗಿದೆಯಲ್ಲ? On 21st. Yes. And that day no adjournment. ನೀವು ಅಷ್ಟೇ ಪ್ರಿಪೇರ್ ನೋಟ್ ಆನ್ ಈಚ್ ಕೇಸ್. ಯಾವ ಕೇಸಲ್ಲಿ ಯಾವ ಫೈಲ್ ಏನಿದೆ ಅಂತ.
55.
I'm appearing for the respondent, my lord. Undertake to file wakalat on the next date.
55.
I'll undertake to file wakalat.
Allah, well, send it back to consider in accordance with the Supreme Court judgment.
I am not the lower court counsel, my lord, on record. So I have to
Allah,
seek
ಏನಾರು
instructions.
ಆಗ್ಲಿ. See, I'll
Hello.
tell you the ground on which he is here.
Please,
The proceedings are initiated by him. He is the complainant under 138. Ali, my moratorium is clamped on the company. Now, on the ground that moratorium is clamped, an application is filed saying stay the proceedings under 138. That's all right, so and so. So the court stays it, notwithstanding the fact of 3 Supreme Court judgments being against that concept. Moratorium issued will not take away the liability of the directors. Idರಲ್ಲಿ directors have issued checks in their individual capacity and not in the name of the company.
I'll seek in
So I will send it back.
weeks time.
ಆಯ್ತು,
Because
ತಗೊಳ್ಳಿ,
he's
but
staying in Mumbai, my lord. So
whoever it is, I'll send it back to reconsider the application. That's all the order.
I will file wakalat.
Same, Haki. Learned counsel so and so undertakes to enter appearance for the respondent in all these cases. Registry to print the name of so and so is appearing for the respondent. List the matter on 23rd. 23rd. In the fresh matters list at 2:30 PM. ಅವತ್ತು ಅಷ್ಟೇ ಆರ್ಡರ್ ಮಾಡೋದು, ವಾಪಸ್ ಕಳಿಸ್ತೀನಿ. I'll quote the Supreme Court judgments, ask the court to consider it.
Supreme Court judgment was placed on delay.
Which Supreme Court judgment?
Rakesh Bhanot judgment.
ರಾಕೇಶ್ ಬನ್ನೋ ಡೇಟ್ ಏನು ಸರ್?
1st April. 1st April.
ಯಾವತ್ತು ನೀವು ಮೆಮೊ ಹಾಕಿದ್ರಿ ಸರ್? ಒಂದ್ ನಿಮಿಷ.
Document number 6 at page 48.
ಯಾವತ್ತು ಮೆಮೊ ಹಾಕಿದ್ದು ಸರ್?
13/10/2025.
30/10 after Banoth.
Yes, sir.
Yes, I will see.
That judgment was placed on delay.
I will direct it to consider it.
Let them serve a copy to me.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ.
56.
There is subsequent judgment also. 987. 2026 SSC online SC 987. Look into that also and come. ನೀವು ಅದೆರಡು ನೋಡ್ಕೊಳ್ಳಿ. Yes.
My lord, today I have filed wakalat for R2, my lord. Kindly
50?
out and next week, my lord. 56, my lord.
Learned counsel so and so submits that he has entered appearance for the second respondent complainant. Registry to print the name of so and so is appearing for the second respondent complainant. Objection ಆಗ್ತೀರಾ?
File more.
List the matter on 23rd for objections, if any, by the respondent by then. Accused number ಯಾರು ಇವರು? All accused, ah? Okay, thank you. Fresh matters. Yes, next.
57.
Post immediately after service of notice upon the respondent, interim order. Yes, next.
58. 58.
Howd sir, beating the child.
He's not the custody of the.
Oh, that we'll see. If you have beaten the child and the video is circulated everywhere, child is in your possession, you are beating the child.
Video, my lord, is not, those such children.
No problem. Kerana bidi. Post the matter in admission. Yes. Next. Learned HCGP is directed to accept notice for the respondents. Post the matter in admission. Yes. Next. In admission, barli.
My lord, they are already, they collected the documents, my lord, they found that, my lord, it is not working.
No, no. Nothing. Yes, yes.
59.
Yavat. Next Thursday. Yes, fresh matters.
60.
Pass over 45 order le. Section 45 order. ಏನಕ್ಕೆ pass over? Yes, madam.
ನಾನು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಇಟ್ ಇಸ್ ಅ ಸ್ಟೇಜ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮುಗಿಸಾಗಿದೆ ಸ್ವಾಮಿ. ನೌ ದೇ ಕಮಿಂಗ್ ವಿತ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ಅದು ಸ್ವಾಮಿ ಅದು ಫೋರ್ಜರಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Yes.
If you look at page
Check
number
is admitted.
ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ.
That is a matter of evidence. Yes.
ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್ 95 ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ. I'll read out 2 lines for this. ನನ್ನ ಸ್ನೇಹಿತ ಮಂಜುನಾಥ್ ಸ್ನೇಹಿತರವರಿಗೆ ಹಣ ಪಡೆದಿದ್ದೆ. ಈ ಸಮಯದಲ್ಲಿ ಭದ್ರತೆಗಾಗಿ ಸಹಿ ಮಾಡಿದ ಚೆಕ್ಗಳನ್ನು ಮತ್ತು ಒಂದು ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾವಿಷನ್ ನೋಟ್ ಗೆ ಸಹಿ ಮಾಡಿ ನೀಡಿದ್ದೇನೆ ಅಂತ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸಿಗ್ನೇಚರ್ ಮಾಡಿ
anything else?
ಸ್ವಾಮಿ. Those are exhibit 59 and 60.
Check is issued to whom?
Manjunath. He is not the complainant. Complainant is told.
Where is the check?
Exhibit 359 and 60, 60A and B ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
Check ಯಾರ ಹೆಸರು ಕೊಟ್ಟಿದ್ದು ಮೇಡಮ್?
ಸ್ವಾಮಿ ನಮ್ಮ ಹೆಸರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನರೇಶ್ ಕುಮಾರ್ ಅಂತ ಇದ್ದಾನೆ ಇದೆ.
ನಾವು ಕಂಪ್ಲೇಂಟ್ ಸ್ವಾಮಿ.
You are ನರೇಶ್ ಕುಮಾರ್.
Blank check ಅನ್ನ ಮಂಜುನಾಥ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
Blank check ಕೊಟ್ಟಿದ್ದು. Anything else, sir?
He claims that under 2 agreement, my lord, I have issued the check. Lord, that agreement is, I have produced that page number.
ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಸರ್. 482 ಏನ್ ನೋಡೋದು?
ಸ್ವಾಮಿ ಎಲ್ಲ ಮುಗ್ದೋಗಿದೆ ಸ್ವಾಮಿ. ಟ್ರಯಲ್ ಮುಗ್ದಿದೆ ಸ್ವಾಮಿ.
It is not my signature.
Signature on the agreement, not on the check.
Check contents of the check.
ಅಲ್ಲ, check contents of the check and signature is admitted.
No, my lord.
Why?
Lord, he has issued signed and unsigned signature to the.
Unsigned check.
Security has ತಗೊಂಡಿರೋದು.
ಸ್ವಾಮಿ ಇಲ್ಲ ಸ್ವಾಮಿ ಸಿಗ್ನೇಚರ್ ಅಂತ
ಸೆಕ್ಯೂರಿಟಿಗೆ ಅನ್ಸೈನ್ಡ್ ಚೆಕ್ ತಗೊಂತಾರೆ ಯಾರು? ಯಾಕೆ ಕೊಟ್ರಿ?
Loan ತಗೊಂಡಿದೆ.
Anything else, sir?
Kindly see page number
The
19.
petitioner is before the court calling in question seeks the following prayer.
Under 2 agreement, my lord, he is claiming that I have issued the check to the present complainant.
That's a matter of evidence, sir. Ali. Yes.
Evidence ಆದ ನಂತರನೇ
See, check ಅಲ್ಲಿರೋ signature is yours. And
one of the endorsement is, my lord, signature of the draw is different.
ಎಲ್ಲಿದೆ? And all these 2018 ಇದು ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
After evidence I filed. After completion of the evidence for both.
ಯಾಕೆ ಚೆಕ್ ಮುಂಚೆ ನೋಡಿರ್ಲಿಲ್ವಾ ನೀವು?
Trial ಅಲ್ಲಿ ಅದನ್ನೇ ನಾವು.
ಅಲ್ಲ, ಚೆಕ್ ಮುಂಚೆ ನೋಡಿರ್ಲಿಲ್ವಾ? ಮತ್ತೆ ಅವಾಗ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ?
ಸ್ವಾಮಿ ಎರಡ್ ಸತಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Admitted that signature difference ಇದೆ ಅಂತ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಸ್ವಾಮಿ 97 ಪೇಜ್ ನಂಬರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ನನ್ನ ವಿಚಾರಣೆಯಲ್ಲಿ ಸಹಿ ಹಾಗೂ ವಕಾಲತ್ತಲ್ಲಿ ನನ್ನ ಸಹಿಗಳು ವ್ಯತ್ಯಾಸ ಇದೆ ಎಂದರೆ
ಏನು
ಅಂತ
ಕೇಸ್ ಇಲ್ವಾ? ಮತ್ತೆ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಈ ಸ್ಟ್ರೇಂಜರ್ ಬೇಡ.
ನೋ
kindly see page.
ಸ್ಟ್ರೇಂಜರ್ ನರೇಶ್ ಕುಮಾರ್ಗೆ ಕೊಟ್ಟಿರೋ ಚೆಕ್ ನೀವು.
ಸ್ವಾಮಿ ಒಂದು ಡಿಡಿ ಮತ್ತೆ ಒಂದು ಚೆಕ್ ಪಾಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
Page number 119. He says that I have executed this agreement. Annexure M, sir. 120, sir. Last line, sir.
ಅಲ್ಲ ನರೇಶ್ 3 ಲಕ್ಷ ಎಷ್ಟು?
Total 13 lakhs.
ಒಂದು 3 ಲಕ್ಷ ಒಂದು 10 ಲಕ್ಷ ಸ್ವಾಮಿ.
The petitioner
120, page number 120.
ನೋಡಿದೆ,
ಒಂದೇ line.
ನೋಡಾಯ್ತು. Yes.
Last line.
The petitioner is before the court calling in question an order dated seeks the following prayer. The petitioner is the accused, the respondent the complainant. The two have a transaction. The transaction leads the petitioner to issue certain checks. The checks are presented which get dishonored. The proceedings are instituted by the respondent complainant in the year 2019. After 7 years of the commencement of the proceedings, at the time when the matter was at the stage of arguments, the petitioner files an application under section 45 of the Indian Evidence Act, seeking reference of about 15 documents for forensic examination, most of which are the agreements that are entered into between him and one Manjunath. The concerned court has rejected the same.
He claims that I have executed with the complainant.
The agreement pursuant to an agreement anta ಮಾಡಿ madam. The concerned court rejects the application under section 45 filed under 45 of the Evidence Act. It is this that has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner would reiterate the grounds set out in the application on the score that the agreement was entered into between him and Manjunath and not this man.
Loan agreement with the Manjunath.
Entered into a loan agreement with one Manjunath, and checks had been issued to Manjunath and not to Naresh Kumar, who is the complainant. Manjunath has not filed any complaint, therefore the signatures on the check placed before the concerned court by the complainant Naresh Kumar are disputed, and therefore it had to be referred for signature for forensic examination. Is the submission of the learned counsel appearing for the petitioner. The learned counsel appearing for the respondent submits that the check is issued by the petitioner in favor of Naresh Kumar, the complainant, and not in favor of Manjunath. The evidence, the matter is at the stage of evidence, stage of arguments after completion of evidence. At that stage, the petitioner files an application seeking reference of 8 documents for forensic examination on the score that it is not his signature that is found on those documents. The concerned court by the learned counsel submits that the court has appropriately rejected the application for reference to the forensic examination. I have given my source. The aforenarrated facts, transaction and the role of the petitioner and the respondent in the episode of the proceedings before the concerned court are all a matter of record. The petitioner is said to have issued certain checks totally amounting to 13 lakhs in favor of the petitioner and favor of the complainant. The complainant Naresh Kumar institutes proceedings which is pending in CC 6847 of 2019. For 6 years, the matter goes on. The petitioner does not realize that he had issued a check to one Manjunath and not to this petitioner. The instrument was placed before the court long ago. Evidence not once, but the examination and cross-examination not once but twice take place before the concerned court. When the evidence was closed and the matter was at the stage of arguments, the petitioner accused comes up with a plea that the agreement that was entered into, the check was not issued in favor of the present complainant Naresh Kumar, but towards a loan agreement to one Manjunath. Since Manjunath is not the complainant, the signatures found on the instruments or the documents produced in the concerned court must be referred for examination. The concerned court by the following order has rejected the plea. The petitioner rejected the plea. I do not find any warrant of interference with the order passed by the concerned court purely on this score that the checks or the documents did not emerge yesterday, but it was throughout in the knowledge of this petitioner accused for over 6 or 7 years when the matter was pending. When the matter was pending, now at the fag end of the trial, when the judgment is to be passed, the petitioner has come up with the subject application without any semblance of ground to urge that at this stage. Therefore, reserving liberty to the petitioner to urge all the contentions when he is making his arguments before the concerned court, the petition stands disposed. Next.
61.
The petitioner to serve on the counsel who represents the respondent in the trial proceedings. ಎಲ್ಲಿದೆ? ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರಾ? ನಿಮ್ದೇನು ಗ್ರೌಂಡ್? ಏನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್? In the meantime, yes, next.
62.
FSL ಹೋಗಿದೆಯಾ? ಯಾವಾಗ ಬರುತ್ತೆ? Yes, the matter and on 30th, in the event investigation is concluded, the mobile phone shall be instructions be sought when the mobile phones would be returned to the petitioners. Yes, next.
63.
In the meantime, yes.
64.
ಬೇಡವಾ? In the meantime. Yes.
64.
Petitioner is accused number 6.
Not stay. There are CCTV, I have seen the CCTV, of course, his role may not be there. Let him cooperate with the investigation.
The petitioner accused number 6 is before the court on the score that he has no role to play in the episode of crime. While that would be acceptable as the first blush, the petitioner's presence in investigation may be required to unearth the truth qua other accused. In that light, the petitioner shall cooperate with the investigation. No coercive steps or precipitative action in the garb of investigating the petitioner shall be taken against him. That's complete protection, don't you? Yes.
Lords,
65.
if my lords is okay, my lords may kindly give a date and then guide them like on this date. Certain kind of investigations might take place.
Our investigate cooperate ಮಾಡಿ. I'll take it on 30th.
Please.
Yes, list on 30th.
The allegation that the breach of promise.
Sorry,
I
65.
know section 64.
Breach of promise to marry.
I know section 64 and 69 were that.
64 and
69.
69 li bail ಸಿಕ್ಬಿಡುತ್ತೆ and 64 ಹೇಳ್ತಾರೆ.
According to the complaint, my lord, the relationship started in the year 2022 and they fell in love. They celebrated the New Year in Oyo Hotel.
Celebrated?
New Year in Oyo Hotel. That's what the case. Your lordship, I mean,
ಆಮೇಲೆ
this case is covered by the judgment of the Samadhan versus State of Maharashtra. Your lordship judgment in Harshit Singh.
ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ?
Arrested, my lord, is JC.
Is in custody.
Is in custody.
ಸಿಕ್ಸ್ಟಿ-ಫೋರ್ ಇರೋದ್ರಿಂದ ಕಸ್ಟಡಿ ಅದು. 64 ಅಲ್ಲ 64 ಇದೆ.
Identical case your lordship has.
ಅದ್ರಲ್ಲಿ ಬರೀ 69 ಇದೆ. 64 ಇಲ್ಲ ಅದು.
Yes, ma'am.
ಗೊತ್ತು ಏನ್ ಬರ್ದಿದ್ದೀವಿ. ಕುಡಿಯೋದು. Chintamani. You stay in Chintamani now?
He's from Chintamani.
Married and not disclosed that too.
They have departed in the year 2025.
Correct, you are married.
I come, as per the complaint, my lord.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ? You are married ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
Married.
Then?
As per the panchayat held in 2025 May, my lord, they have discussed and they have departed. In 2026, he got married.
Who got married?
The petitioner.
Oh, at the time of affair, you are not married.
He was not married.
Oh.
Now, my lord, in June 2026, they filed a complaint. When she came to know he is married. For 9 months, they did not speak. There was no connection. There was nothing.
No, that's all right. When did you get married?
Let him produce the document.
When did you get married?
I will take date.
You take instructions and tell me when did you get married? You are in custody.
But if I read the whole, the
Yeah,
first,
164 statement ಇದೆ ಇಲ್ಲಿ.
the first complaint, very
Complaint
narration.
ಬಿಡಿ 164 statement ಇದೆ. ನೀವು ಮದುವೆ ಆಗಿದ್ರಿ ಮುಂಚೆ ಅಂತ.
No, my lord.
That's why I want to know.
No, my lord.
You produce.
The complaint is, I mean, absolutely nowhere in the complaint is stated that I was married.
You want to see the statement, 164 statement.
I'm sorry, I'm going through the complaint.
Complaint illa, wait. You produce your, when did you get married? If you are married and you are told, I'll marry you, then.
That is not the case.
We'll see.
The complaint allegation, my lord.
Monday, fresh matters.
Complaint allegation, my lord. Here,
I came to know that he is married. That is why I am filing complaint.
He was already married and he has promised.
That is
me.
not the case of the
That's the
complaint.
statement. That's why, where is the marriage certificate? Where is the document to show that you got married later?
I will produce.
You produce that first. Monday fresh matters. ಅವತ್ತು ರಿಲೀಸ್ ಮಾಡುವ. ಅದು ನಾಳೆ ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ. Let it come to the file.
My lord, I seek for a short accommodation.
2 weeks IO. Entry matter ಇದೆ.
This is a forest matter. My contention is that we have to challenge that order in a sessions court.
It is a.
And his contention
I
is that
then we'll take it on 20th. 20th fresh matters. Yes.
Interim order.
Huh?
Interim order may kindly be extended.
That will continue, sir.
In same statement.
First interim order continue. ಹೋಗಿ ತೊಂದರೆ ಇಲ್ಲ. Yes.
57.
My lords, for the petition, my lords, offense under
Here for the
812
respondent.
of Act
Yeah.
161.
Please, your lordship. I'll file my objections, my lord.
8 and 12, sir.
8, my lord.
My lords,
You are not a
allegation-
public servant.
My lords, I am a public
Then
servant, my lords. The
Your
complaint is not a
complaint is
public
that you are
servant.
trying to bribe a private party.
Private party. My lords, initially there was a complaint regarding Hemavati, large scale corruption.
Reverse.
And the trap has
Petitioner shall
failed, my
file
lords.
the statement of objections. ಈಗ charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ, my lord.
Filing the respondent shall not file the charge sheet without the leave of the court. Yes, next.
My lords, no
On,
coercive action. my lords.
22nd.
My lords, till then.
ಇನ್ಯಾವ
he's-
precipitative action?
My lords, as he's on the verge of retirement, my lords now.
No precipitative action shall be taken against the petitioner in the garb of investigation.
Great.
Next.
68.
160 ಕರ್ನಾಟಕ
Timber forest.
5 HP ಮಿಷಿನ್ ಇರಬೇಕು, ಹೆಚ್ಚಿಗೆ ಮಿಷಿನ್ ಹಾಕೊಂಡು ಕಟ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ. ಆಲ್ ಆರ್ ವ್ಯಾಲಿಡ್. ಅಲ್ಲಿ ಬಣ್ಣ ಹೊಡೆದಿದ್ರು ಮಿಷಿನ್ ಮೇಲೆ ಅಂತ.
ಓ, ಹಳೆ ಮಿಷನ್ ಗೆ ಬಣ್ಣ ಹೊಡೆದಿದ್ರ?
ಅಕಾರ್ಡಿಂಗ್ ಟು ಕೇಸ್ ಆಫ್
ಅದು ಹೊಸ ತರ ಕಾಣ್ತಾ ಇತ್ತು.
5 HP ಮಿಷಿನ್ ಪರ್ಮಿಷನ್ ಬೇಕಾಗಿಲ್ಲ, ಬಣ್ಣ ಹೊಡೆದಿದ್ರು. 5ಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ಮಿಷಿನ್ ಅಲ್ಲಿ ಇದು ಮಾಡ್ಕೊಂಡು
ಅಂತದ್ದೇನು ಇರಲ್ಲ ಬಿಡಿ. ನೋಟಿಸ್ ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ?
ಇಲ್ಲ, ಬಂದಾಗ
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಬಂದು ಡೈರೆಕ್ಷನ್ ಅಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
ಬೇಕು ಅಂತ ಇದೆ. That endorsement what he got is wrong. I have the notification. It's ಬೇಕು.
ಪರ್ಮಿಷನ್ ಬೇಕು.
ಅಲ್ಲ ಅಲ್ಲ.
5 HP
ಪರ್ಮಿಷನ್ ಬೇಕು. He received one endorsement from an RFO saying that ಇಲ್ಲಿ ಸಾಮಿಲ್ ನಡೆಸೋದಕ್ಕೆ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
ಸಾಮಿಲ್ ಅಲ್ಲ, ಸ್ಮಾಲ್ ಸ್ಕೇಲ್ ಇಂಡಸ್ಟ್ರೀಸ್ ಇಸ್ ನಾಟ್ ಎ ಸಾಮಿಲ್.
ಸಾಮಿಲ್ ಅಲ್ವಾ?
ಪ್ರೈವೇಟ್ ಸಾಫ್ಟ್ ಪಿಟ್ಸ್. Private soffit 165, punishment is 5,000 rupees. 163 and 165.
ಅಲ್ಲ ಅದೇನಾರು ಇರ್ಲಿ. ಬಟ್
Penalty is
ಸಾಮಿಲ್ ಅಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಸ್ಟೇಟ್.
private.
ಸಾಮಿಲ್.
163.
Samil, the learned counsel for the petitioner submits that
Sawmills.
the industry is not a sawmill. It is only
Only private sawmill is permission.
private sawmill.
Private. 163, 5 HP ಗೆ ಏನು ಬೇಕಾಗಿಲ್ಲ. ಇದು ಸಿಲ್ವರ್ ಮರಕ್ಕೆ ಪರ್ಮಿಷನ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಇದೆ.
Yes, David sir.
Punishment is 5 months or 6 months or 5,000 penalty. Only 63.
Monday. Yes. Next.
69.
Monday fresh matter.
Monday fresh matter.
This is a peculiar case, my lords, where this complaint came to be filed to stop petitioner number 4 to going abroad, my lords, for studies, my lords. Lords, I would like to produce the document, my lords, how this complaint came to be filed.
ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ ಈಗ?
ಅಲ್ಲ, ಸೊ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ my lords, I would
ನೀವೇ
like
ಏನು atrocities act?
my lords, atrocities only, my lords, the only, my lords, FIR is at page number 20, my lords. The only offenses is atrocities acts, unlawful assembly and abatement, my lords. Let's petitioner number 4 is aged about 25 years, my lords. She wants to go to abroad for studies, my lords. When
No, what is the animosity between you and the complainant?
My lords, we stay in Bangalore, my lords, and the petitioner number 1 is stays in Mysore, my lords. Lords, petition number 2, 3, and 4 is the sister of husband, my lords. My lords, there is no
Sister of husband.
husband sister. There is no complaint against husband, my lords. The complaint is only against the father-in-law, mother-in-law, and sister husband and sister's daughter, my lords. My lords, I would like to produce the documents, my lords, how this complaint came to be filed, my lords. My lords, one in the year, in the month of February, the one a coffee ಕೊಡ್ತೀನಿ. They have also filed the objections, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದ್ರಲ್ಲೇ. Let's see here, page number 1. My lords, on 11/2/2026, my lords, one gift deed came to be executed by the father of the husband to the husband, my lords. Let's kindly come to page number 5, my lords, where there is a condition. ಸದರಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು 5 ವರ್ಷಗಳವರೆಗೆ ಯಾರಿಗೂ ಪರಭಾರೆ ಮಾಡುವಂತಿಲ್ಲ ಹಾಗೂ ಶ್ರೀ
Yes, madam.
ಮೇಘಾರಾಮ್
Look into these documents. Tuesday. List on Tuesday in the fresh matters
only
list.
one, my lords, 13th report ಮಾಡ್ಕೊಬೇಕು ಅಂತ.
ಎಲ್ಲಿಗೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋಬೇಕು?
My lords, college I am traveling to abroad, my lords, loan
Which
ಎಲ್ಲ
college?
sanction. My lords, I produced at
Admission
page
details ಕೊಡಿ.
My lords, page number 16, my lords.
Of what?
Of now I have given document. Page number 15, my lords, sanction letter. Page number 16, my lords, loan is also been sanctioned, my lords. My lords, where, my lords, kindly see the chronology, my lords, on 16/5/2026, my lords.
When is the college commencing, sir?
My lords, I'll.
ಅದ್ಯಾಕೆ ಹಾಕಿಲ್ಲ ಇಲ್ಲಿ?
My lords, ಅದು ಈಗ ನಮ್ಮ ಮೇಲ್ ರಿಸೀವ್ ಆಯ್ತು ನಿನ್ನೆ. ನಂಬರ್ 4, my lords, ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆದಾಗ ಅವರು ಅವ್ರ ಗಂಡ ನನಗೆ ಹಕ್ಕು ಬಿಡುಗಡೆ ಮಾಡ್ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ಹಕ್ಕು ಬಿಡುಗಡೆ ಮಾಡಿದಾದ್ಮೇಲೆ ದ ರಿಮೈನಿಂಗ್ ಪ್ರಾಪರ್ಟೀಸ್ ವಾಸ್ ಪ್ಲೆಜ್ಡ್ ಟು ಟೇಕ್ ದ ಲೋನ್, my lords. Then all these complaint came into picture.
ಇನ್ನು ಎನ್ರೋಲ್ಮೆಂಟ್ ಡೀಟೇಲ್ಸ್ ಫಿಲ್ ಅಪ್ ಮಾಡಿಲ್ಲ ನೀವು?
ಅಲ್ಲ, ಫಿಲ್ ಅಪ್ ಮಾಡಿದೀನಿ.
ಅದೇ ಹೇಳಿರೋದಿಲ್ಲ.
ಅಲ್ಲ, my lords, kindly see, I have also page number 17, my lords, fees is also been paid.
Yes, madam. What is it against?
My lordship, since 2018, she is going through the same insult and humiliation only because she belongs to the scheduled caste community, my lordship. Even ಅವ್ರು ಕೊಡೋ ನೀರು ಮತ್ತೆ ಊಟ ಸಹ ಕನ್ಸ್ಯೂಮ್ ಮಾಡೋದಿಲ್ಲ ಇವರು ಮನೆಯಲ್ಲಿ. From the first 2 days itself, husband has kept her separately in a rented house, and he had promised her that he will take her
Who is the
back.
husband here?
No,
Husband is not.
Why?
My lordship, she is living with her husband, and husband is also staying with the wife, and he also stays with the in-laws, my lord. He also stays with his parents. He is allowed inside the family, but not the respondent number 2 and her kids. She also have 2 minor kids. This discrimination is also planted in the heads of those minor kids, and they are also not allowed inside the family.
My lords, only 2 minutes, my lords.
This is
Kindly
not
come to
just
page
now,
number
my
30, my
lordship,
lords.
not one
My lords,
instance.
where the first complaint is filed on 23/4/2026, my lords. My lords, in that complaint she says ನನ್ನ ಅತ್ತೆ ಮಾವ ನನ್ನ ಜೊತೆ ಚೆನ್ನಾಗೇ ಮಾತಾಡ್ತಾ ಇದ್ರು. ನಮ್ಮ ಅಕ್ಕ ಮಾತ್ರ ನೀರು ಕುಡಿಯೋದಕ್ಕೆ ನಾನು ಅಡಿಗೆ ಮಾಡಿದ್ರೆ ನೀರು ಮತ್ತೆ ಅಡಿಗೆ ಮಾಡಿದ್ರೆ ತಿಂತಾ ಇರ್ಲಿಲ್ಲ. ಮತ್ತೆ ನನ್ನ ಇವ್ರು ಗಂಡನ ಅಕ್ಕನ ಮಗಳು ಇವರು ನೀನ್ ವರದಕ್ಷಿಣೆ ತಂದ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕಿರುಕುಳ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ ಓನ್ಲಿ ಅಗೇನೆಸ್ಟ್ ಮಲರ್ಸ್ ನನ್ನ ಗಂಡನ ಅಕ್ಕನಾದ ಕೃಪಾ ಕಿರಣ್ ಮತ್ತು ಮಲರ್ಸ್ ಅಲಿಗೇಷನ್.
I'll take it on Monday. Yes. List on Monday in the fresh matters list. Next.
70.
Investigation complete ಯಾಕಾಗಿ?
Your lordship may have to take this matter along with the Attica. Lordship,
ಇದು Attica gold ಆ?
ಅವ್ರ ಕಡೆಯಿಂದ ರಿಕವರಿ ಮಾಡಿಲ್ಲ ಅಂತ. Your lordship, if the kind of response Attica has given to her. In fact, my lord, one particular
ಇನ್ನೊಂದು ಅದರ ಜೊತೆ ತಗೊಂಡ್ವಾ?
ಅದರ ಜೊತೆಲೇ ತಗೊಂಡ್ರೆ.
ನಂಬರ್ ಏನದು?
I'll give it.
We'll tag it. Wait. Yes. A number ಇಸ್ಕೊಳ್ಳಿ, tag and list them on Wednesday ಅಂತ ಮಾಡಿ.
In fact, they issue a notice to us saying that Attica Babu has nothing to do with this case, and why are you issuing notice?
We'll take it along. Yes, next.
ಅಲ್ಲ, further hearing ಇದೆ madam.
71.
That matter is for further hearing.
ಅದ್ರ ಜೊತೆನೆ ಟ್ಯಾಗ್ ಮಾಡಿ, ನಂಬರ್ ಕೊಡಿ. ಇದು SPP moved it, so I had to take
Yes,
it.
my lords. I was wondering, of course, SPP would have already gone through this. But
Yeah, ಅದಕ್ಕೆ, that's why.
four dates, I'll just give it. 17/6, accused number 1, 2, 4 and 5 are
ಅಲ್ಲ,
arrested.
ಇದು ನಾನು ಇಂಟರ್ಮಾಟರ್ ಕೊಟ್ಟಿರೋದು CCTV ನೋಡ್ತಾರೆ ಅಂತ ಮಾತ್ರ.
So far as CCTV is concerned, it is already spent itself. Because we filed this petition on 1st of July. 4th of July, they have made a request for search warrant. Search warrant is issued. On 6th of July, they have carried out the search in respect of my house as well as my office.
So ಅದಾಯ್ತು ಈಗ.
That has become a fait accompli.
Then come on merits.
Now, so far as the merits is concerned, my lords.
Yes.
Your lords were to see the first remand application.
Page.
My lords, can I just pass on? There is a small compilation which I have made. my lords.
Yes.
ಅವ್ರಿಗೊಂದು copy.
ಏನು ಇಷ್ಟೊಂದು compilation ಏನಿದು?
Lords, so many remand applications only to indicate, my lords, I did not want to hold back any papers which we could lay our hands upon. Page number 38 is the first remand application. Lords, in the first remand application, can I proceed? Lords will see the array of accused. There are 5 accused. At page 38, Lords may kindly come to page number 41.
41.
ದಿನಾಂಕ 17/6/2026 ಸದರಿ ಪ್ರಕರಣದ ಆರೋಪಿಗಳನ್ನು ಪತ್ತೆ ಮಾಡಿ ನೇಮಕ ಮಾಡಿ ಗಳಿಸಿಕೊಟ್ಟಿದ್ದ ಠಾಣಾ ಅಧಿಕಾರಿಗಳು ಸಿಬ್ಬಂದಿಗಳಾದ ಸೋನ್ಸೋ ದೀಪು ವೆಂಕಟೇಶ್ ಬಾಬು 9:30 ಗಂಟೆ ಹೊಸಕೋಟೆ ಟೌನ್ನಲ್ಲಿರುವ ಆನಂದ ಗ್ರ್ಯಾಂಡಲ್ ಪ್ಯಾಲೇಸ್ ಮುಂಭಾಗದಲ್ಲಿ ನಿಂತಿದ್ದವರನ್ನು ವಶಕ್ಕೆ ಪಡೆದುಕೊಂಡು ರಾತ್ರಿ 10:45 ಗಂಟೆಗೆ ಠಾಣೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳು ವಿಚಾರಣೆ ಮಾಡಲಾಗಿ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ ಪಡೆದುಕೊಳ್ಳಲಾಗಿ ಆರೋಪಿಗಳ ಕೃತ್ಯದಲ್ಲಿ ಭಾಗಿಯಾಗಿರುವ ಬಗ್ಗೆ ನುಡಿದಿದ್ದು ನಮ್ಮನ್ನು ಕರೆದುಕೊಂಡು ಹೋದರೆ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದ ಮೃತದೇಹ ಬಿಸಾಕಿದ ಸ್ಥಳವನ್ನು ಹಾಗೂ ಪ್ಲಾಸ್ಟಿಕ್ ಟಾರ್ಪಾಲ್ ಮತ್ತು ಜಮಖಾನವನ್ನು ಸುಟ್ಟು ಹಾಕಿದ ಸ್ಥಳವನ್ನು ಗುರುತಿಸಿ ತೋರಿಸುತ್ತೇವೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ನಂತರ ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳು ಮೇಲೆ ರಾತ್ರಿ 11:30ಕ್ಕೆ ದಸ್ತಗಿರಿ ಮಾಡಿಸಿಕೊಂಡು so on and so forth. The statement is said to have been recorded. Voluntary statement is said to have been recorded between 10:45 to 11:30 p.m. on 17/6/2026. I have no problems with this. Now this remand is given from 18/6. This remand application is made on 18/6/2026. Remand is given up to 1/7/2026. Now on 24/6/2026, they again say that since we have been informed that the investigation is now handed over to the CID, we don't want them for further questioning. Therefore, we are placing them for the before the court so that they could be placed under judicial custody. Lords may kindly see that statement at page number 49. In this, A7 is added. This is as on 24/6/2026.
Page 49 ಅಲ್ಲ?
Page 49.
ಎಲ್ಲಿ ಎಡಿಷನ್?
ಅಲ್ಲಿ ಕೆಳಗಡೆ A5 ಆದ್ಮೇಲೆ A6 ಪ್ರಸಾದ್ ರಾವ್, A7 ಲೋಕೇಶ್ ಲಾಯರ್ ಆನೇಕಲ್ ಅಂತ ಬರೆದ್ರು.
ಅಲ್ಲ ಇದು ನೀವು ಇದರಲ್ಲಿ
49 ಅಲ್ಲ? Also, I am referring to the compilation.
49.
49.
Yes, sir.
On 24/6. Lords, the custody is between
A7 so and so.
Yes. A7 ಮಾಡಿದ್ಮೇಲೆ Lords may kindly come to page number 52. Second unnumbered paragraph. They reiterate the same contents. 10:45 ರಿಂದ 11ವರೆಗೆ ನಾವು ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದೀವಿ ಅಂತ. ಇದು ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಇದರಲ್ಲಿ. And then
ಮೇಲೆ ಅಲಿಗೇಷನ್ ಏನು?
ಅಲಿಗೇಷನ್ ಏನು ಅಂತಂದ್ರೆ ಈಗ as on
the
date,
who is murdered?
Lords, the person who has been murdered is now I have no relationship with him.
Correct. Who is murdered?
Lords, the deceased name is Vijay Kumar. He is a gym trainer. Vijay Kumar.
Gym trainer.
He is a gym trainer. He has been murdered. Accused number 1 to 5. The allegation is that he was invited for a party to a place.
Yaro, this gym trainer.
This trainer was invited to a party, saying that it's a birthday party. 1 to 5 are there, and they have bludgeoned him to death, and then they have packed his body by the using a tarpaul, etc., etc. That's the nature of statements which they have recorded.
Against accused 1 to 5.
That's against accused 1 to 5.
6.
That's accused 6. How his accused number 7? Accused number 6 is now said to have given supari for the purposes of killing this.
Who has given supari?
Accused number 6.
6 has given supari to kill
accused number 1.
kill that gym trainer.
Gym trainer to accused number 1. Accused number 1 happens to be a corporator of Anekal.
Oh.
He is taken supari is the allegation, but that is how essentially the prosecution case proceeds. Doesn't matter.
Sorry.
Now,
so where did you come into the picture?
Where we came into the picture is
we obretane.
Obre. As on 24/6 also, the requirement for me being labeled as an accused is at page 56, 17 and 18 and 19. These two has spent itself.
CCTV
ಆಗೋಯ್ತು. Next page 57 para 27. ಈ ಕೇಸಿನ ಕಡತವನ್ನು ಹೆಚ್ಚಿನ ತನಿಖೆಗೆ ಮಾನ್ಯ DGIGP ಸಾಹೇಬ್ರವರ ಕಚೇರಿ ಆದೇಶದಂತೆ CIT ಕಚೇರಿಗೆ ನೀಡಲು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಅದರಂತೆ CID ತನಿಖಾ ತಂಡದವರು ಮುಂದಿನ ಹೆಚ್ಚಿನ ತನಿಖೆಗಾಗಿ ಆರೋಪಿಗಳನ್ನು ಮತ್ತು ಪೊಲೀಸ್ ಕಸ್ಟಡಿಗೆ ಪಡೆದುಕೊಳ್ಳುವರಾಗಿರುತ್ತಾರೆ. On 24/6, the accused are sent to judicial custody. Notes then on 2/7, page, kindly have a look at page number 66. This is the remand application dated 2/7/2026. Notes, they don't request for further police custody, CID. Lordships may kindly have a look at page 68.
I'm there.
ಲಾಸ್ಟ್ ಪ್ಯಾರಾ. ನಂತರ ಆರೋಪಿಗಳು ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆಗಳನ್ನು ದಾಖಲಿಸಿಕೊಂಡಿದ್ದು, ಆರೋಪಿಗಳು ತಮ್ಮ ಹೇಳಿಕೆಗಳಲ್ಲಿ 6/6/26 ಮೊದಲೇ ಸಂಚು ರೂಪಿಸಿದಂತೆ ಬರ್ತ್ಡೇ ಇದೆ ಎಂದು ಹೇಳಿ ಸುಳ್ಳು ಹೇಳಿ ವಿಜಯಕುಮಾರ್ ಅವರನ್ನು ಹಸಿರುವಾಣಿ ಜಮೀನಿಗೆ ಒಳಗಡೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಪಾರ್ಟಿ ಮಾಡೋ ನೆಪದಲ್ಲಿ ಕೊಲೆ ಮಾಡಿದ ನಂತರ ಮೃತದೇಹವನ್ನು ನೀಲಿ ಬಣ್ಣದ ಟಾರ್ಪಾಲ್ ನಲ್ಲಿ ಸುತ್ತಿ ಡ್ರಿಪ್ ಇರಿಗೇಷನ್ಗೆ ಬಳಸುವ ಪೈಪ್ ನಿಂದ ಮೃತದೇಹವನ್ನು ಸುತ್ತಿ ನಂಬರ್ ಪ್ಲೇಟ್ ಬದಲಾವಣೆ ಮಾಡಿಕೊಂಡು ಸೋನ್ಸೋ ಹಿಂಭಾಗದ ಡಿಕ್ಕಿಯಲ್ಲಿ ಹಾಕಿಕೊಂಡು ಹೊಸೂರು ರಸ್ತೆ ಚೆಕ್ ಪೋಸ್ಟ್ ಹಾಗೂ ಇತರೆ ಕಡೆಗಳಲ್ಲಿ ಸುತ್ತಿ ನಂತರ ಸೋನ್ಸೋರನ್ನು ಮೃತದೇಹವನ್ನು ಆನೇಕಲ್ ತಾಲೂಕಿನ ಕಲ್ಲೇಶ್ವರಿ ಗ್ರಾಮ ಖಾಲಿ ಜಾಗ ಬಿಸಾಕಿದ್ದು ಹಾಗೂ ಈ ಕೆಲಸಕ್ಕೆ ಲಾಯರ್ ಲೋಕೇಶ್ ಅವರು ಹಣವನ್ನು ನೀಡಿದ್ದು ಸದರಿ ಡೀಲ್ ಅನ್ನು ಪ್ರಸಾದ್ ರಾವ್ ಎಂಬುವರು ನೀಡಿರುತ್ತಾರೆ ಎಂದು ಲಾಯರ್ ಲೋಕೇಶ್ ಅವರು ತಿಳಿಸಿದ ಬಗ್ಗೆ ಆರೋಪಿಗಳು ನುಡಿದಿದ್ದು ಹಾಗೂ ಸಾಕ್ಷ್ಯ ನಾಶ ಮಾಡುವ ಸಲುವಾಗಿ ಮೊದಲನೇ ಸಂಚೆ ರೂಪಿಸಿದಂತೆ ಆರೋಪಿಗಳು ತಾವು ಬಳಸಿರುವ ಕಾರು ನಕಲಿ ನಂಬರ್ ಪ್ಲೇಟ್ಗಳು ಅಳವಡಿಸಿ ಕೃತ್ಯದ ನಂತರ ಪ್ರತ್ಯೇಕ ಬಳಸಿದ ಟಾರ್ಪಾಲ್ ಮತ್ತು ತಾವು ಧರಿಸಿದ ಬಟ್ಟೆಗಳು ಸುಟ್ಟಿರುವುದು ಇದುವರೆಗಿನ ತನಿಖೆಯಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. I'll just pause here. The only statements which is said to have been recorded is from accused number 1, 2, 4 and 5. The accused number 1, 2, 4 and 5, their statements were recorded between 10:45 to 11:30 as stated by them in the 2 remand applications. None of the accused have given such a statement. If this was the contention, my lord, then this would have been a very serious issue, certainly. Then on the remand applications dated 18/6 and the remand application dated 24/6, there is absolutely no whisper about such a kind of statement having been made. For the first time, it surfaces on 2/7 after we filed this petition. This petition is filed on 1/7.
It comes up before me, not on 1/7.
No, the second as on that 7. Yes. On 1/7, we had already served the copies and the matter had been directed to be listed. We had moved the memo, my lords. We had got the details saying that the matter was ready to be listed by 2/7. After that, this statement is made for the purpose of seeking. Now, that is the only ground on which they have now moved the matter, saying that this is the basis on which they want to go. Lords, I don't want to stand in the way of a fair investigation being conducted. On instructions, I am stating, my lords, that had it been the old police station, probably we would have had some grievance, because there was something which was happening where probably my name might have been included. Now we have full faith, my lords, in the investigation which is presently being conducted, but I am in a position to demonstrate that till such time we had filed this petition on 1/7, in none of the records which has been produced by them saying that this is the investigation materials collected by them till the date of remand on 18/6 or 24/6. There was absolutely nothing against me, and they only wanted to have a search and seizure in respect of the 2 properties, that is my house as well as my office. That is now become a fiat accompli because those 2 things has already been accomplished. Now, for the first time, after this petition is filed on 2/7, this allegation comes into existence. Lords, I am not saying that it should not be investigated. That will be, Lords, your Lordships may only say, I will fully cooperate with whatever investigation is required to be undertaken. But with this suspicious development of events which has taken place, your Lordships may safeguard my interest that no coercive steps should be taken. Lords, I'm not saying that I'll not cooperate with the investigation.
Yes, SP Pure.
The statement of 17/6, I placed the
Yardidu?
The accused number 1. And it's not just based on a statement, my lord. I'll place the Lordship may have this.
Oh, CDR.
Yes. We are now looking into IPDR because there are certain things which looked into. And more importantly, my lord, from the day of incident, telephone of the present petitioner is switched off. We have not even asked him. We have not even identified him. He didn't even know his existence. His phone from that day switched off. His and his assistant, accused number 7 and 8, both phones are switched off since that day. Your Lordship may see the statement which he has given. And the statement now, I can show the bank statement of this present, the accused, my lord, which corroborate with each other.
Accused number 1 is the key assailant.
Yes,
Bank statement ke?
bank statement.
Allah.
He says that money has been collected by him
By whom?
from the accused, from the present petitioner's office.
From the advocate.
From the advocate and advocate.
Ah.
That money paid to him by the father of the one of the girl with whom the deceased had any relationship.
He is also my client. Prasad Rao is my client. I am handling at least six matters on his behalf.
Well, why did you have to transfer money to accused number 1?
There is no transfer. Milords,
That's
let
what
them
he
show
said.
that there is a transfer.
Money has been
Let them show there is a transfer, Milords. I am sure there is no
These are
transfer.
things to be investigated.
I have no difficulty, Milords.
Not stall anything.
Cash has been paid.
Milords, they
Cash
have
has
already
been
collected
deposited.
the entire set of details. I can understand, Milords, if they have not collected the details. What is that they wanted to do at the first instance?
They will investigate it.
I have no difficulty, Milords. I am making a statement that let them carry on with the
I
investigation.
cannot direct investigation in a particular manner.
Milords, I am not saying that your lordships will have to direct the investigation in a particular manner.
CCTV ಮೇಲೆ stay ಕೊಟ್ಟಿದ್ದಷ್ಟೇ murder case ಅಲ್ಲಿ interfere ಆಗೋದು ಎಲ್ಲಿಂದ ಬಂತು?
Milords, I am not saying
sir.
that your lordships may have to interfere in a matter of this nature. We
Oh,
are
no,
only
sir.
making a statement, Milords, that the complicity of this accused comes into existence only on 2/7. That is how the statement is said to have been recorded. Milords, we have placed.
Ravi Shankar sir, no. This is not the case where I should interfere at all. Not in these grounds. It's a murder.
Milords, I understand, Milords.
It's a murder and the allegation is that you have transferred money to that
Milords,
person.
now,
It's a matter to be investigated, sir.
Can I say this, Milords? Can I say this? Only one indulgence your lordships may kindly show me.
Why gym trainer was murdered?
Gym trainer eloped with Prasad's daughter.
Yaru Prasad, that is his client.
Prasad is the one of the real estate developer in that area. He is accused number 6. He is the gym trainer is eloped with the accused number 6 daughter.
All
who
right.
used to visit gym. So because of that, there's a grudge between Prasad and this gym trainer. So
All right. Who is accused number 1?
Accused number 1 is he has multiple other cases against
Can
him.
I say
He is
this?
yes.
Milords, can I say this, Milords?
And in fact, my lord, the accused number 1 and
Prosecution,
accused number 2.
Milords, investigation cannot proceed on the basis of.
Sir,
Milords, I
Ravi
just
Shankar
kindly
sir,
permit me to say this.
I
Milords.
cannot
No,
direct
I'm not saying that.
investigation to proceed in a particular manner.
Not at all. Milords, I just wanted to say the incident of eloping which my learned friend is referring to happened 2 years back, 2024. From the past 6 months, this girl whom they are referring to is studying abroad. She is studying abroad.
Now those are matters to be investigated.
I have no
into, sir.
difficulty. Now the allegation made, Milords, is this. Milords, I am an advocate for Prasad Rao and I am also the advocate, Milords, for accused number 1. I have produced the documents to show that I have appeared for both of these persons in several matters. Now that's not the question. The question is, the complicity is brought about on 2/7. Now the allegation is being made saying that there is a transfer of money. One document, let them show that I have transferred money to accused
They will
number 1.
investigate, sir.
Milords, I have no difficulty. They have already investigated bank documents. They have already seized. They have done the seizure already. Let them show that there is any seizure of the bank documents or any other document
Bail
evidencing that I have paid the
Bail
money.
ತಗೊಂಡಿಲ್ವಾ?
No, Milords, we have come before
Take
this.
bail, sir. First bail. Yes, take bail. Secure bail, sir.
Milords, I'll secure bail, Milords.
No,
That
no,
shouldn't be a
nothing.
difficulty.
No,
Milords,
no,
to
no,
secure
secure
the-
bail, sir. Yes.
Milords, I am making
Not in a case of murder and
No, no, Milords, now-
accomplices in murder, no,
The
sir.
reason why my name has been brought about is there is a reason behind this. My name would not have been brought about if this matter was not before this Bannerghatta police station. There is a reason why this matter went to Bannerghatta police station.
Sir, reasons may be
Therefore,
manifold. But Ravi Shankar, sir, you should secure bail. What is this?
I have no difficulty.
No,
Then
sir.
your lordships may protect it for 2 weeks since.
No, 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 sir, nothing. Investigation, I am not going to stall.
I am not saying
In
that
this
your
case,
lordships may
nothing
stay
doing.
the investigation. Let there be no coercive steps for 2
No,
weeks.
no,
In the
sir,
meantime,
nothing,
I'll
nothing.
move for the
Tomorrow
bail.
you should file a bail application tomorrow.
I'll do that, Milords. Your
Please
lordships
do
may
it, please.
protect me
No,
for a
this is,
period of 1 week at
I
least.
granted an interim order on a CCTV which had spent itself.
Milords, CCTV is concerned, Milords. Your lordships have already prevented and no further investigation on this basis should proceed is what the order is passed.
So that
I'm not
will go
saying-
now. Yes.
Milords, now, as on the date on which.
And look at your prayer. Deletion of accused number 7. No, sir.
Milords, I am not saying, Milords.
See the prayer, sir.
Milords,
See the prayer.
Milords, as. can I-
Mandamus to direction quashing inclusion of the petitioner's name as accused number 7. Do I direct
As-
investigation
Milords,
here?
As on 1/7/2026, when I filed this petition, even according to the prosecution, no materials was placed before the magistrate to bring about the complicity of this accused.
No, no. Yes.
Absolutely nothing was brought before the
Will pass
magistrate.
the order.
Can I say
The-
this, Milords? Your lordships
sir.
may only protect that
No,
I,
no,
no
nothing, no,
coercive
sir.
steps for a period of 2 weeks. I'll appear, my lords. I'll go before the
You
investigating
appear,
officer.
you cooperate with the investigation, you seek bail, whatever you want, you can do.
Very well.
My conscience would not permit for this. Yes, the petitioner is before the court seeking the following prayer. Heard the learned senior counsel, D.R. Ravi Shankar, appearing for the petitioner. The petitioner is drawn as accused number 7. The petitioner is said to be an advocate practicing in the advocate enrolled with the Karnataka State Bar Council. The issue is registration of a crime in crime number 142 of 2026 when it comes to be registered on 9/6/2026. The petitioner was not drawn as an accused in the said crime. The fulcrum of the crime is a gym trainer getting murdered. The allegation is that the accused number 1 has committed the act of murder of the said gym trainer. The said gym trainer. The accused number 4, accused number 2 to 5 are said to have contractor.
Supari.
Are said to have given supari because I saw that somewhere.
Accused number 1 to 5 are the Supari killers. Supari was given by accused number 6.
The accused number 1 to 5, who are said to be the supari killers, is said to have been contacted and handed over a contract by accused number 6. Accused number 6 is that Prasad Rao.
Prasad Rao.
Accused number 6, one Prasad Rao, who the learned SPP submits that had an axe to grind, that his mother, his daughter had an affair with the said gym trainer. Be that as it may, the petitioner was not in the picture till that date. While filing a remand application before the concerned court, the petitioner is drawn as an accused as accused number 7, and the remand of the petitioner is sought. It is then the matter comes up before this court.
Remand of the petition was not sought. That's the only remand application where there is a reference made to the petitioner saying that they want
in the said remand application, clauses 17 and 18 would read as follows.
18 and 19.
18, 19. It is on that strength, it is on that strength the court granted an interim order on 6/7/2026. The learned SPP again moved the matter on the score that there is more than what meets the eye in the case at hand. Therefore, the matter is reheard today. The learned senior counsel, D.R. Ravi Shankar, would submit that.
Can I make this request, Minots? If these contentions are to be considered, Minots, it may affect the consideration of my bail application.
That's why you secure bail.
Can I request this, Minots? If your lordship were to say that since the grounds at 18 and 19 have spent itself because of the warrants having been issued, fresh materials have come into existence, your lordship is not entertaining this petition, so that at least he will be. That's essentially, my lords, what I could request.
And I thought of recording that 164 statement also. Yes, the Hangbarkole. This interim order was granted on this so and so. Since clause 18 and 19 of the remand application have already spent themselves, they only spent themselves, the petitioner spent themselves, and several new evidence or material has sprung pursuant to the investigation according to the learned SPP. It is in the fitness of things, it is appropriate that the petitioner would seek bail of whatever kind before the hands of the concerned court.
Please.
On 3 days protect madava. Badva.
There are serious issues. I would not have insisted.
All right. Yes. No, when there in this murder case,
understand, my lords.
We will not pass any orders against our conscience. Not correct. Otherwise, I did it the other day.
No, my lord.
But these facts are I did not.
We were also not aware. As on 24th and 17, whatever materials was there, we placed it. Beyond that is what
the whole problem is, if accused number 1 to 5 are supari killers,
yes,
why should money from your account go to those?
I am making
a
statement
cash and deposited in accused number 1's account.
Why, sir?
And that's why the CCTV they want.
Advocate extra.
That's what I am submitting, my lords.
Sumne alla.
But whatever he is saying, my lords, that's it. Something else, it is something, we have no difficulty, but he will get through with this investigation, he will come in.
Whatever it is,
But when this came about, I made a statement because that these materials are there, it requires investigation. They only said that let there be no coercive steps, so that they will also understand that why his name has been brought up. If a fair investigation is conducted, absolutely no problem. I know, it's very simple. Something else is going on.
Why advocate for it?
These things do happen. Things do happen. Cases, we are also as much vulnerable as anybody else in the hands of the police. Yeah,
Police are like this. Why entertain the clients to that level?
It's not happened. These things were
That is what.
and the eloping takes place 2 years. Anyway, that's what the prosecution wants to pursue as well.
Because no course of substance further.
No. Answer.
If it is anything, you can always say.
$71. Sorry, 72.
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿದಾರಲ್ಲ ಅಲ್ಲ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿದಾರ ಅದೇ ಅವ್ರು ಹಾಕಿದಾರ
Allegation is against the person that he has impersonated himself and told that he's trying to assert ownership of the property. I have already, he's entered an agreement to say with me, I have paid 3 crores. Complainant.
Look, now complainant has instituted a civil suit as well.
Yes, not complainant. Accused number 1 is. I got that.
No. Accused number 1 ಯಾರು? Agreement ಯಾರ ಜೊತೆ ಆಗಿರೋದು? That's exactly the point. Now Francis has instituted a civil suit against the complainant.
I'm also victim. I have paid 2.5 crores to this Francis.
We'll see. One HCGP 2 emergent notice. Heard the learned senior counsel Prabling Nawadgi appearing for the petitioner. The accused number 1 institutes a civil suit against the complainant. The petitioner also has entered into an agreement with the accused number 1 concerning the property, which has now become the subject matter of the civil suit between the accused number 1 and the complainant. It appears he is caught in the crossfire, and the criminal law is set into motion on this score. Set into motion on this. In that light, there shall be an interim order of stay of further investigation qua the petitioner till the next date of hearing. Same, huh? The accused number 1, huh?
73.
Same order, yes. The petitioner, adal accused number ಏನು? Second. All right, yes. Madam.
Admission 37.
Yogesh, party in person.
13%.
Not yours. Yours, sir. There is no Radha Krishna here. You are Radha Krishna? No. Why? No, sir. I told you in the morning itself. Huh? Senior iga? Our accident 4 time ಆಗಿದೆಯಾ? First time. Finally list on Wednesday in the fresh matters list. In the event the petitioner would not be present or make arrangements for submissions, a respondent would be heard and appropriate orders would be passed. Yes. Next.
39 urgent, 40.
$498 ಏನ? ನನ್ನ ಹತ್ರನೇ ಬಂದು ಎಸ್ ದಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ ಮೇಡಮ್? I have not granted stays. The learned counsel for the respondent seeks 2 weeks time to file statement of objections if any by the next date. ತೊಂದ್ರೆ ಇಲ್ಲ sir. No, list on 22nd in the fresh matters list. In the event objections would not be filed by then, this court would be constrained to grant an interim order of stay. 22nd.
41 urgent, 42.
ಇದೇನು? Reserved.
Your lordship reserved, but asked us to explore.
Settlement, correct.
We had given an offer, they have given.
ಏನಾಯ್ತು?
Another offer today, my lords. I shared with the client, petitioners, they are examining short date maybe.
Tuesday.
17th? 3 more days. 17th. List. No, 24/6/2026 order quote ಮಾಡಿ. List the matter on 17th, heard so and so, Senate Council. Yes.
73 urgent, preliminary. Sorry.
43 urgent.
Urgent, preliminary, 44.
Irfan. Cow slaughter.
Lordship, I seek for a short application.
No representation in petitioner list after 2 weeks. Yes.
45.
There was no representation by the petitioner earlier also. Even today, there is no representation list after 2 weeks. Yes.
45 offences
Yes,
are
Anya.
cheating and forgery, my lords.
Sorry?
Cheating and forgery are the offences, my lords. Petitioner was not arraigned as an accused in the FIR.
Not necessary.
Subsequently, only on the
Voluntary
statement of the
statement.
co-accused, he has been arraigned as accused number 6.
Remote ಇದೆಯಾ?
No, my lords. The state was to go
Accused
through
number
the charge
6.
sheet.
What forgery, madam?
The allegation against 1 to 5 is that they were creating fake ESI cards to ineligible candidates. But accused number 6, there's no such allegation. Only co-accused says that she was introduced to one of the, that A6 introduces her to one of the people.
We'll see. SP pure.
Statement of the witness, my lord, speaks about the.
That we've produced now. CW 27.
Not the co-accused only.
No, not a co-accused one. One statement, at least they themselves produced, my lord.
CW 27, but he only
Speaks very
says.
clearly that.
No, my lords, that statement may
About
be
his role.
seen. That statement may be seen, my lords, the third
So if
paragraph.
witness has spoken, then
But he only
accused,
states-
co-accused statement matra idre kashta. Witness
Understand,
has
my lords, but
spoken.
he
ಏನು
only
ಮಾಡಲ್ಲ.
states that he was introduced to A3 by A6, that's it. Not that he has gained any benefit out of it, nothing else.
Allegations are grave against accused number 1 to
1 to
5.
5. A6.
Again, trial ನಡೀತಾ ಇದೆಯಾ?
It's there tomorrow, my lord, summons stage.
Not a case for interference. ಬರೀ co-accused witness statement ಇದೆಯಾ?
Statement.
But in that witness statement, he only states that I approached him for some help, medical help. He just introduced me to A3, that's it. He doesn't state that he gave him any money.
We'll
or
see,
that he was-
list on ನಾಳೆ ಏನ್ ಚಾರ್ಜ್ ಇಲ್ಲ ಅಲ್ಲ?
Some-
Thursday next.
Much.
Fresh matters. On a preliminary.
46, I appear for the petitioner, my lord.
ಏನಿದು?
My lord, the charge sheet has been filed against accused number 2 based on solely on the statement of co-accused. Now, my lord, the accused number 2 was in custody in Bijapur. The allegation is that when he was in Bijapur, my lord, he made a threatening call to the complainant. Now the SIM card owner, my lord, the SIM card owner gives a statement. He gave it to the SIM card. The SIM card was given to an accused who's in Mysore. Though requisition is made, my lord, to inspect the premises in Mysore, they don't, my lord. I am in Bijapur. The
Yes.
SIM card owner himself says that the SIM card is handed over to a person in Mysore.
ಯಾರಾದ್ರೂ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಸಿಮ್ ಕಾರ್ಡ್ ತಗೊಂತಾರ?
ಇಲ್ಲ, ಟ್ರೇಸ್ ಮಾಡಿದ್ದಾರೆ. Trace ಮಾಡಿದ್ದಾರೆ. That SIM card owner says SIM card was handed over to co-accused who is in Mysore cell. Now they give a requisition, my lord, to inspect the Mysore jail, but my lord, they don't do it. They inspect the premises in Bijapur. They don't find anything. If my lord they had visited, my lord, the Mysore premises, my lord, they probably would have gotten something. But to say that, my lord, we visited Bijapur and there was no material.
ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನ್ ಇದ್ರಲ್ಲಿ?
Stay of proceedings. In so far as accused number 2.
ಕಾಲ್ ಡೀಟೇಲ್ ವಾಟ್ಸ್ಆಪ್ ಕಾಲ್ ಮಾಡಿದ್ದಾರೆ.
ನೀವು ಜೈಲ್ ಇದ್ದೀರಾ ಈಗ?
ಜೈಲಲ್ಲಿ at the time of incident, my lord, we were in custody.
ಈಗ
even now malats.
Even now in the jail. ಏನ್ ಸ್ಟೇ ಆದ್ರೇನು ಏನಾದ್ರೆ
ಅಲ್ಲ ಬಟ್ malats
ಜೈಲಲ್ಲಿ ತಾನೇ ಇರೋದು.
ಅಲ್ಲ even then malats.
But now kindly see now what happens, my lord. The SIM card owner is traced. SIM card owner, my lord, says that he was the SIM card was given to person in Mysore. Requisition is given, they don't follow it up. But the, my lord, they visit, my lord, the Bijapur and say there is nothing forthcoming. Only based on statement of co-accused, my lord.
See, we'll take it. ಹೆಂಗೂ ಜೈಲ್ ಇದ್ದೀರಾ, ಒಂದ್ 2 ವಾರ ಬಿಟ್ಟು ತಗೊಳ್ಳೋಣ ಬಿಡಿ. ಎಸ್
malats in one of the matters.
ಏನ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಸರ್?
ಅಲ್ಲ I am just submitting this malats in the matter in which he is convicted, he has been acquitted by the High Court now malats in the last week. We'll move for bail malats in the other matters as well.
Right, we'll see. Yes, list the matter on 22nd. Yes.
That's my request. Fresh matters list.
Fresh matters. Preliminary hearing, sir. Fresh ಬರಲ್ಲ. Fresh matters ಅಲ್ಲೇ ಬರಲ್ಲ.
Please.
ಅದು ಅಷ್ಟೇ ಸಾನ್ಯ, ಅದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ಲೇ ಹಾಕಿ. Yes.
14 settlement 47.
In this matter.
Offense.
420 lordships, the matter has been settled, lordships.
Where?
The matter has been settled in Delhi Mediation Center because there was a connected matter in Delhi. So for which they have filed, they have gone to the mediation. In the mediation,
Document
yes,
ಹಾಕಿದ್ದೀರಾ
they have produced a certified copy of the mediation report, lordships, in this, wherein they have agreed that they will withdraw this case, lordships, and also
That is
payments have
also
been
a
made.
condition?
Yes, yes, we have mentioned that, lordships.
Idea,
Page
man.
4 of the mediation report, I have filed the
Alright,
memo.
yes.
And
Yes,
all the
quashed.
payments have been
Disposed.
Yes, grateful, lordships.
Next.
48 49 enter.
No. 230 ಮೋಡ್ ಮ್ಯಾಟರ್ ಬಂತ?
230 more matter. Fresh matter still number 1. Shant SK.
Petition malats. Offense of
ಬರ್ಲಿ ಫೈಲ್ ಅನ್ನ.
CST malats. There was a relationship of a landlord and tenant. I was a landlord, my lords, and the property.
ನಂದಿನಿ ಮಿಲ್ಕ್ ಪಾರ್ಲರ್.
South. Now the tenancy has come to an end. They try to.
You are the landlord.
Please, my lords. I've said no for the.
The petitioner is the landlord, the respondent, the tenant, who runs a Nandini milk parlor in the premises owned by the petitioner. The tenancy comes to an end. The petitioner wants the tenant to get evicted. Sutu hakadra? Get evicted. At that point in time comes the allegation, which allegation of including the offences punishable under the Atrocities Act. Finding no allegation, that no ingredient that could touch upon the said offense except the wreaking vengeance by the complainant, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Next.
Number 2. Shant PG.
Petitioner's counsel, my lord. In
Hospitality.
No, my lord, in 138 proceedings, entire check amount has been, my lord, sent through RTGS. After that, even they are pursuing the matter.
How do you get that?
Lord, the RTGS details are there.
What is the check amount?
My lord, it is 7,86,000.
Where do I get the check?
Lord, my lord, page 42.
42 is the check.
No. Page 42 is the RTGS detail.
Check elli?
But check, we have not produced, my lord, check.
ಅರೆ ಚೆಕ್ ಅಮೌಂಟ್ ನೋಡಕ್ಕೆ ಚೆಕ್
Complaint
ಬೇಕಲ್ಲ.
has been produced, my lord, complaint ಅಲ್ಲಿ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ?
Same, lord.
ಸೇಮ್ ಅಂದ್ರೆ?
But 5 lakh.
7,86,598.
28, my lord, 7 lakh, yes, my lord. 86,000.
Check bearing, one ನಿಮಿಷ. The complainant was okay, instructed so and so. Gross sum of rupees 7,86,000 15 days ಆಯ್ತು. ಈಗ 7,86,000 RTGS ಮಾಡಿರೋದೆಲ್ಲಿದೆ?
Page 42. Third, page 42, one RTGS detail, and page 43, another RTGS. Altogether, my lord, the check amount has been repaid.
ಎಷ್ಟು ಅಮೌಂಟ್ ಇದರಲ್ಲಿ? 3,93,000.
Yes, my lord. 3,93,299. One RTGS details. My lord, UTR number is.
The heard the learned senior counsel Arun Sham appearing for the petitioner. The petitioners are drawn as accused in a proceeding instituted by the respondent complainant for offence punishable under section 138 of the Negotiable Instruments Act. The learned counsel for the learned senior counsel submits that the entire check amount 7,98,000. 86,000 has been completely repaid through RTGS. Notwithstanding the same, the check is presented and the proceedings are now continued. In the light of the said circumstance, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. The advocate on record shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement list on 27th in the fresh matters list.
Request for handle your
Why?
warrant has been issued.
ಕೊಡಿ.
Great.
Number 3.
For the petitioner, my lords.
What, Delhi?
3.1, my lords, there's a stay, interim order has been granted. 3, my lords, is a matter where referring to a lifetime tax has not been paid.
Lifetime?
Lifetime tax of the vehicle has not been paid.
Lifetime tax?
Please, my lords.
Why do you not pay?
No, my lords, a notice has been issued, notice as in that a receipt has been given saying that for 15 years back you have not paid the lifetime tax. On that basis, my lords, and offences under section 3
Anyway,
and 4 of
3.1 ಅಲ್ಲಿ ಇದೆಯಾ?
3.1, there's an interim order, my lords.
In the light of the interim order subsisting in 3.1, there shall be an interim order as is obtaining in 3.1 and 3 as well. Yes.
The interim order in 3.1 to be extended, my lords.
Please. Extend, interim order extends. Next.
Number 4. RK Mahadev. RK Mahadev.
Hmm.
341,
354, sir.
54 delete in the charge.
Delete ಮಾಡಿದ್ರಾ?
Delete. Page number 25 minutes.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಪ್ರೊಸೀಡಿಂಗ್?
ಇದಿದೆ ಅಲ್ಲಿ.
ಇದೆ ಗೊತ್ತು, ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಇದು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ. Petitioner is a
Proclamation is issued and attachment of.
Last
ಯಾಕೆ ಹೋಗಿಲ್ಲ ಸರ್?
ಇಲ್ಲ, petitioner working as a president of the trust.
President of what?
School trust.
So
ಅಲ್ಲ only 2 hearings is absent.
ಅಲ್ಲ ಯಾಕೆ ಹೋಗಿಲ್ಲ ಅಂತ?
Page number on the same page number 56, my lordship.
ಅಲ್ಲ ಯಾಕೆ ಹೋಗಿಲ್ಲ?
ಅಲ್ಲ ಅದು
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು?
ನೆಕ್ಸ್ಟ್ 18 ಇದೆ.
18 appear. The petitioner shall appear before the concerned court on 1/8/2026. 11/8 the date, sorry, appear before the concerned court 11/8 the date of listing, next date of listing before the concerned court. List the matter on 12/8. In an interim order would be considered to be granted only on the appearance of the petitioner. Till such time the proclamation shall remain stayed. Yes.
Order still number 5. Aditya.
Lord, I appeal for the petitioner, my lord. The offences are 304 and 504 and 307, my lord. The accused, the present petitioner is accused number 2.
Pending matter ಇದು.
My lord, notice is issued.
But why it's moved then?
It's for framing of charges tomorrow, my lord.
Tomorrow.
I moved it on the score that it's listed
Oh,
for
all right,
framing of
all right,
charges.
yes. What's the offense?
It's 504 and 307, my lord. The present petitioner is accused number 2. Accused number 1, my lord, all the allegations are.
Lady.
Please, my lord. Accused number 1 is dead. 3 to 6 are, my lord, dropped from the area of accused.
3 to 6 dropped.
Please, my lord, for the lack
The
of
only
want of
person is
evidence.
this lady now.
Please, my lord. I was not present at the time of the incident, my lord.
Accused number 1 is the husband, is it?
No, my lord, just the relatives. They're all related, family members. Column number 17, my lord.
Heard the learned counsel Srimati Kirti Reddy appearing for the petitioner. Notice was issued on 25/3/2026. The matter is moved on the score that the matter is listed tomorrow for framing of charges in the case at hand. The learned counsel taking this court through the documents appended to the petition would demonstrate that the only person left in the fray is the present petitioner, a lady, who is not even alleged of the offence under section 307 or 448 of the IPC. The one who had been alleged, i.e. accused number 1, is now no more. Therefore, the petitioner, the learned counsel would submit that the petitioner was not even present at the alleged scene of crime. Be that as it may, perusal at the summary of the charge sheet would indicate that the offences concerning ingredients concerning the offence under section 307 of the IPC are against accused number 1, Vikasa, who has passed away. In that light, there shall be an interim order of stay of further proceedings square the petitioner, accused number 2, till the next date of hearing. Yes.
My lord, can I request for a hand delivery?
And this on the hand delivery code.
File the memo, my lord.
Tomorrow, yes, memo.
I'll file the memo. Obliged.
Number 6, Manjunath N.
Petitioner, my lord. Based on the private complaint, the FIR has been registered, my lord. For the offence punishable under section 270, 56, 351, 78.
356 ಇದೆಯಾ ಎಲ್ಲಿದೆ
56, my lord. 270, 351, 70, 79,
ಏನು ತಪ್ಪು
126.
ಏನು ತಪ್ಪು
No, the entire allegation made against the accused number 2 only, my lord. Prior to this complaint, already I lodged a complaint against the these complaints, my lord. On dated 7/4/2026.
that to this ಬಿಟ್ಟು ಬೇರೆ ಏನು ಡೇಟ್ ಹೇಳಿ ಸರ್
7/4/2026. As per their complaint, my lord.
7/4/2026 is your complaint.
Yes, my lord.
25/6/26 is their complaint.
Yes.
Counter blast. But 78 ಇದೆಯಲ್ಲ.
There is cause of action is different, my lord. Kindly look at the page number 18, my lord.
Cause of action.
Kindly look at the page number 18, para number 3, my lord. Now we are in the month of July.
ಹೌದಾ?
Already they are alleged, my lord, 9/11/2026. Through their uncle, they have approached to the respondent police and they are lodged a complaint.
ಅಂಕಲ್ ಮೂಲಕ ಹೋಗಬಾರ್ದಾಗಿತ್ತು.
In the month of November, now we are in the July, my lord.
That to this ಸರಿ ಇತ್ತೇನು. Yes. The petitioner is before the court calling in question registration of a crime in crime number 121 of 2026. It transpires that the petitioner has registered a complaint against the complainant on 7/4/2026. The incident is said to have happened ಯಾವತ್ತದು 25 ಅಲ್ಲ.
Our prakar allegation.
The incident is said to have happened on 9/11/2024. 26 9/11 ಬಂದೇ ಇಲ್ಲ ಇನ್ನು.
Yes, my lord. Our allegation, page number 18, para number 3.
In the light of the crime registered by the petition against the petitioners being a counterblast to what the petitioners have registered 2 months ago, there shall be an interim order of stay of.
Much obliged.
Quoting settlement, seal number 7, Shri Ranganath Reddy R.
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತಾರೆ.
Seal number 8, Sanna Rao R.
Offense
306 of IPC, your lordship.
306.
Please, your lordship, abetment to suicide.
Come on, merits. What's the matter? Who died?
Wife, your lordship. She has committed suicide, your lordship.
You are the husband.
Please, your lordship.
Oh, settlement.
Any day, your lordship, I don't have the.
We'll take it on merits.
Monday, your
List on 16th.
Grateful.
List on 16th for admission. Yes. No settlement in 306, madam. That too. Wife commits suicide and husband settlement, no.
Number 9, Ismati S.
Milords, financial transaction, milords. Parties have settled.
Settled. Yes, Kodi. Settlement.
May be permitted to file the wakalat for respondent.
Yes, sir.
307.
307, 324.
307 idea.
ಇದೆ.
Where is the own certificate?
Moon certificate illa swami.
ಮತ್ತೆ
Verify the antecedent.
ಯಾರು ಇವರೆಲ್ಲ?
He is the complainant and they are the petitioners.
Attempt to murder ಮಾಡಿದ್ ಯಾರು?
Allegation is that these
Complainant ಯಾರು?
complainant is the punishment. He is the complainant.
ಅವ್ರು accused ಆ?
Yes.
ಅವ್ರನ್ನ ನೋಡಿದ್ರ ಹೊಡೆದ್ರ?
ಹೇಳಿ.
ಏನ್ರಿ ನೋಡಿದ್ದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಹೊಡೆದ್ರ? ಮತ್ತೆ ಈಗ ಯಾಕೆ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ರಿ? ದುಡ್ಡೆಲ್ಲ ಬಂತ ವಾಪಸ್ಸು?
ಇಲ್ಲ, he has taken the amount. He repaid it.
ಅಕ್ಯೂಸ್ ನೋಡಿದ್ರೆ ಸಾಕು, ಹಂಗೆ ಹೊಡಿಯೋದೇ ಬೇಕಾಗಿಲ್ಲ. ಎಸ್, ಆಂಟಿಸಿಡೆಂಟ್ ಸ್ವಲ್ಪ ನೋಡಿ. ಮುಂದಿನ ಶುಕ್ರವಾರ ತಗೋಣ.
Please.
ಮತ್ತೆ ಬರಕ್ ಹೇಳಿ.
My name may be shown, my lord.
ಅವ್ರ ನೇಮ್ ತೋರಿಸ್ಬಿಡಿ.
Till number 10.
ಗಿರೀಶ್ ನಿಮ್ದೆ.
Matrimonial dispute resolved between the parties. And they have secured
ಎಲ್ಲಿ?
the decree of divorce before the.
ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಕೊಡಿ.
Divorce ಆಗಿದೆ consent.
ಕೊಡಿ ಕೊಡಿ.
Case and counter malady.
Case and counter case.
ಆಯ್ತು ಕೊಡಿ.
Permitted to file wakalat.
ಎಸ್.
307 ಇದೆ ಸರ್ ಒಬ್ಬರ ಮೇಲೆ.
Not 70.
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ತಾನೆ?
Husband.
Husband and wife. Compromise.
ಅಲ್ಲ ಅವ್ರ ತರ ಹಂಗಿರ್ಬಾರ್ದು.
ಇಲ್ಲ ಅದಕ್ಕೆ I disclose the things before your lordship.
307 ಇದೆ ಇದು.
ಇರ್ಲಿ ಬಿಡಿ.
ನಾನು ಅದನ್ನ ಹೇಳಿದ್ದೆ ಈಗ. They are undertaking before the family
all
court
right.
stating
Yes.
that we are agreed to compromise the criminal cases.
Yes, yes. Next.
Much obliged.
Both. Both. 11 ಇವ್ರದೇನಾ? ಹಾ ಸರಿ ಸರಿ, ಆಲ್ ರೈಟ್. ನಾವು ಗೋ ಬ್ಯಾಕ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Further hearing.
ಇದಲ್ಲ, ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ತಗೊಳ್ಳಿ. ನಿಮ್ದೇನ್ ಕರ್ದಿಲ್ಲ, ತಾಳಿ ವೆಯ್ಟ್. ದೇರ್ ಆರ್ 2 matters ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಕಳಿಸಿದೆ. 330 ಅದೇ ಯಾವುದು ಇನ್ನೊಂದು 50 ಅದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆಯಾ? ರಾಘವನ್ ಸರ್, 330 ಇರೋ ಫರ್ದರ್ ಹಿಯರಿಂಗು ಅದೇ ಫ್ಯಾಕ್ಟ್ಸ್. ಈಗ ನಿಮ್ ಫಿಲ್ಮ್ 53 ಇರೋದು ಫರ್ದರ್ ಹಿಯರಿಂಗು ಅದೇ ಫ್ಯಾಕ್ಟ್ಸ್. The thing is that this enforcement directorate, this is yours.
No, that's different. This is a private.
That I know.
This is a private. That your lordship may.
No, that I know. The fulcrum is transposed to that completely.
But here, my lord, the question is.
Because ನೆನ್ನೆ I was hearing, NAM research ಎಲ್ಲ ಇದೆಲ್ಲೋ ಕೇಳಿದಿನಲ್ಲ.
Yes. Fulcrum is this.
Yes.
But the scope of.
ಈಗ ಮಾಡಿ.
ಅವರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್.
ಎಲ್ಲಿದ್ದಾರೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್?
My lords, I'm impleading applicant. I'm being led by Mr. Hemendranath Reddy, senior advocate.
Where is he?
I am there, my lord. I am there, but I think video there is a problem. So I'm in a court chamber, my lord. See, in fact, I wanted to go to office and log in.
You want to? I'll give you a passover.
It takes, my lord. Traffic, Hyderabad traffic is also like Bangalore traffic. So I'm in High Court chamber. Video is some problem. Let's.
Well, you want argument or adjournment?
I don't. Well, I thought I was told that that TD matter is going on. That's the reason why I'm not there physically. Otherwise, I would have come. In fact, this is a matter.
You
to
said
come
you
physically and
are correct. Yes.
That's what.
So we'll take it tomorrow or on Tuesday.
Whatever.
Tuesday it may be taken. Tuesday 3:30. I'm there physically. Yes, ma'am.
By that day, I think the other matter will be over.
This is, my lord.
I'm aware of this. Yes.
No,
ಅದರಲ್ಲೂ ಇದೇನೆ same facts,
same facts.
ಪಂಡಿತರ ಸರ್,
Tuesday.
Tuesday. This will take heard. ಎಲ್ಲ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ರಾಘವನ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. Ajesh Kumar, then KIDB, our impleading applicant.
Tuesday it may be taken on Wednesday, my lord.
Accused?
ಅಲ್ಲ Wednesday ತಗೋಬಹುದು ಅಂತ.
Instead of Tuesday, all right, Wednesday. No problem.
Wednesday is also fine with me.
Fine, fine. Raghavan sir, ನಿಮಗೆ ಪರವಾಗಿಲ್ವಾ? Wednesday. All right.
We had 3:30 minutes, timing is 3:30.
3:30. Yes, by then I would have finished this 3:30.
Yes. Yes.
Interim order ಇದೆಯಾ? ಏನಿಲ್ಲ ಅಲ್ಲ?
That
ಏನಿದೆ?
continue ಮಾಡು.
Oh, that is restored ಅಲ್ಲ anyway. Division bench has restored it.
Restored it. But
That will continue.
Division bench restored it till the matter comes up before your lordships.
No, anyway, I have continued it last time.
Your lordships.
Same will continue till the next day.
Is it? It may continue.
It will continue.
Grateful.
Yeah, impleading applicant, senior counsel ಹೆಸರೇನು?
Hemendranath Reddy.
Yes. On Wednesday, we should be able to finish this, sir.
Yes, my lord. I'll be there
Yes.
physically. Yes.
On the impleading application. Yes.
Allah, we'll hear it.
But no, my lord. First, whether they are entitled to come on record. That, because even earlier
That I am
litigation-
satisfied, my lord.
But
Absolutely,
let-
we are entitled to come on record.
Even in the
As a
earlier
respondent.
round,
No, I will hear him completely.
Earlier
Don't
round,
have-
Yeah,
I was
earlier-
not suited as a plaintiff, writ petitioner, not as a respondent. Now I
Devannath
want to
sir,
come on
don't
record
worry.
as a
You
respondent.
will be completely, don't worry. Yes.
in the earlier round of litigation,
Now he doesn't want me to come and tell the true facts to your lordship. That is his endeavor. No, true facts he doesn't want. Because
You
KIDB
don't
is
have to
not-
worry.
not
I will
critical.
hear all the facts.
Yes, my lord.
in the earlier round of litigation, your lordships heard only on the question of maintainability.
No, now that
No,
the
no.
division bench has.
2023, your lordship has
No, no,
passed an order saying that the
ಆಯ್ತು,
locus
ಅವತ್ತು ಮಾಡೋಣ.
litigates.
ಅವ್ರ ವಿಡಿಯೋ
In fact, your
ಕಾಣ್ತಾ
lordship passed a very recent order in 2023. Excellent order is passed in 2023, and that was never said.
But that's
by the
reversed.
division bench.
That order is reversed.
No, it's not reversed. Only, my lord, the division bench has said, I need not be participating in the inquiry that is to be conducted by KDB. That's all. Even my locus is not reversed. But unfortunately, my lord, the coordinate bench has interpreted as if the division bench has reversed your lordship's finding. Absolutely not. In fact, your lordship's order, except 2 clauses, everything is confirmed in toto. I will just satisfy your lordships.
All right.
Unfortunately, because the earlier coordinate, so that's why your lordship's subsequent matter followed the coordinate bench. Otherwise, my lord, there is
No,
objection
subsequent order, I followed the coordinate bench, no doubt about it.
That's what I'm saying, my lord. Now, in view of the latest developments, I'll convince your lordship saying that that finding was never interfered, and that too now I'm trying to come on record as a respondent, not as a writ petitioner. Your lordship,
All right, sir.
difference between yes, my lord. I don't want to waste
Wednesday
your
ran,
lordship's time
sir.
right now. Yes, my lord.
Wednesday వస్తారు సార్.
వస్తాను తప్పకుండా వస్తాను.
Yes, sir. Ran, sir.
I am from Bangalore only. I did law from Bangalore, so I love to come to Bangalore anytime.
All right, sir. Bangalore is good, sir. Now weather-wise and otherwise, come, sir. Yes.
Absolutely, my lord.
Yes.
Grateful, my lord. Great.
Yes.
Obliged, madam.
Admit 74.
Mr.
ಎಲ್ಲ
Hussain will
ಮುಗಿಸ್ಬಿಡಿ.
appear on.
ಪುಣ್ಯದ ಲಿಸ್ಟೇ ಖಾಲಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಸೊ ಇದೊಂದೇ ಇರೋದು.
Little surprising, my lords.
No, today I'm not well, so taken a little less today.
Lords, I will not take much of your lordship's time, except to show my lords from their documents and what he had contended. Lords, the compilation which they gave to my lords of documents, ED, on 22/6/25. 26, my lords.
Oh, convenience compilation.
My lords, that's what I don't know. It's a production of documents. Same
No, all
thing,
right.
is it?
That's 22/6. Yes.
22/6/26. That my lord, the first letter which my learned friend was pointing out, 311, if your lordship kindly see.
Madam, ಅದು ಬೇಕು document. Compilation on court.
It says production of document by Anuparna.
By?
Lords,
ಏನು
I'm
author
saying-
ಹೇಳ್ದಂಗೆ by so and so.
Because I don't know, lot of papers have now got jumbled up, my lords, to search also. Because it has we have also given so many documents. It's dated 22/6/26, correct? No? Date? I don't have. ದಪ್ಪದ್ದು.
ಇದರಲ್ಲಿದೆ ಕೊಡಿ. Yes, sir.
Lords, in that 311, page 311 is a letter dated 7th of Feb 2025. If the pagination is.
Yes, yes, correct ಆಗಿದೆ. Pagination correct ಆಗಿದೆ.
My learned friend was referring to that.
Yes.
Lords, to say the permission
That
for
is
sublease.
7.2.
Yes, 7.2.
Yes.
In that plea, that was, my lords, where permission for sublease was granted.
To LAM research. Yes.
For embassy to.
Correct.
Yes, my lord.
To enter into sublease
yes,
with LAM
sublease.
research. Yes.
And in that last two lines, your lordship may kindly observe. In that letter, this letter is issued, your lordships have that, my lords. Subject to obtaining consent from banks, financial institutions with whom the land is mortgaged for availing loan and financial institute. Why this comes about is, there was an earlier order passed by KADB itself, approving the mortgages, my lords. That's all. Then, my lords, my learned friend pointed out at page 313 regarding the agreement of sale entered into between embassy and LAM, and repeatedly showed clause 9, Roman 9 at page 316, to say that I have misrepresented to LAM, saying that I have the right to convey the property. Column 9, clause 9.
Yes.
My lords, in any sale, there is something known as caveat temptor, buyer's thing. And when such a transaction takes place, but anyway, please come to page 325. It is, there is no, and if I have misrepresented, only LAM can say I have misrepresented. But please come to 325. It's clause 2.2, my lords. It starts with subject to completion of the project development in respect of the scheduled property by the purchaser in accordance with the principal agreements within term or a term as extended by KADB as per clause 2.4 below, and or upon the seller fulfilling its obligations to KADB under the principal agreements with respect to the larger land, seller shall, upon prior to expiry of the term of renewal term or upon being entitled to sell execution of the sale deed, make requisite applications before KADB to execute the KADB sale deed and subsequently execute and register LAM sale deed in favor of the purchaser. So there is no question. If you're going to read only clause 9, my lords, it gives such an impression. But clause 2.2 says so, and clause 2.3 also, your lordship may kindly observe. Upon occurrence of earlier of the following, despite the purchaser not having fulfilled its obligations under clause 4.2.1, the seller becoming entitled to have a sale deed executed by KADB for conveyance of the larger land in its favor, or KADB confirming its willingness to execute KADB sale deed for conveyance of the scheduled property in favor of the seller or directly in favor of the purchaser. Each a conveyance event, the seller shall immediately and in any case no later than 3 business days from occurrence of any of the conveyance event, inform the purchaser in writing. Upon occurrence of either of the conveyance event, the purchaser shall within 15 days thereof seek conveyance of the scheduled property in its favor by issuing a written notice to the seller, along with a copy sent to the joint custodian. Then, my lords, 2.4 is that. Please see 2.4 also. In the event purchaser fails to complete the project because there is already a sublease in his favor, my lords. Project development in accordance with principal agreements within 6th June 2029, due to which seller is prevented from approaching KADB for procurement of KADB sale deed, then the purchaser shall by 6th September 2028 intimate the seller in writing as to the status of the project, and seller shall accordingly apply and obtain extension of the term under the principal agreements within 6th June 2029 at the cost of the seller, and party shall execute a renewal sublease deed for such extended term, and such renewal shall be on same terms and conditions as the sublease deed. It is, however, clarified that in this scenario, purchaser shall be obligated to remit tranche 3 amount. So, my lords, question of these are all agreements, my lords, between me and a purchaser. So that, my lords, to say that I have misrepresented somebody else, that is not even a crime, and it's not LAM case, neither KADB's case, that I have cheated anyone. Now, my lords, the other document which I wanted to show to your lordships is, my lords, 3 documents to say that a sublease, your lordships, the other side said I have handed over mortgage, I have handed over the possession under the agreement of sale.
Correct.
Please see, under the agreement of sale, there is no handing over of possession at all.
No, that is the CEO's own statement. It was not my submission. It's the CEO's statement.
I,
My lords, now please come to the registered sublease deed, which is document number 2. It
Page.
starts at running page 14, my lords.
14
It's a
of
new
what?
compilation.
Nimdon compilation.
Ashta. 3 documents, nothing. It's all within their custody. We have given. It's soft copy.
Page.
My lords, the sublease deed starts at 14, my lords, running page 14. It is after obtaining permission. It's 20th March 2025, my lords. In that, your lordship may not go to anything else, but please come to clause.
Now LAM has begun operations, is it?
Yes, please come to clause 3. This is a registered sublease. At running page 32. Running page 32. my lords. It's on top, my lords. 32 is on top.
32.
In that clause 3 relates to possession and access, and possession is 3.1. The sublessor shall simultaneously with the registration of this deed deliver physical possession of the scheduled property free of all encumbrances except as
So property is delivered.
it is delivered, property possession is delivered under the sublease, registered sublease. And my lords, that's why if it is an agreement of sale and if you have to deliver, it has to be compulsorily registered. So
it is not under agreement of sale. It is under the sublease document that the possession is delivered.
And for sublease, permission was granted by KIDB, which your lordship saw on 7/2/2025. Then, my lords,
2023.
my lords,
3 or 5 hours?
Yes, 24. 7/2. Lords, it is 7/2/2025.
25. All right.
25. 7/2/25. This comes to be registered on 20th of March 25. Then, my lords, the document number 1 is the earlier order of KIDB, which was passed under section 34B. And that's, my lord, it starts at page 1.
Page?
Running page 1, it starts.
One moment, sir.
In that.
This was what was called in question?
Not in the present writ. It was a part of earlier writ petitions, my lords. It was filed by rival operators, which your lordships had dealt sitting single, lords, in a writ petition, which is called out at para 17, my lords. If your lordship kindly come, running page 6. Or para 15, my lords. Para 15 at running page 5.
Initiate action.
And your lordships had granted permission to those 2 petitioners therein that they can appear and they can oppose before the KIDB. Now that, based on that order, my lords, embassy had taken it up in a writ appeal.
Correct.
The division bench which
reverse agide ante.
Reverse agಲಿಲ್ಲ, except to the extent that those 2 persons need not be heard.
Oh.
They did not have any right. Anta para 18 it's called out in the earlier order.
All right.
Then, my lords, the question of mortgage and payment to others is called out in my reply at para 22, running page 8. Regarding all the mortgages, my lords, which is set out in the table in the information now given to the police, all this is considered by KIDB. Ultimately, what KIDB does is, please come to my lords, para 27, running page 11. And this is with them. They have referred to this order also. Running page 11, my lords, para 27. The lordships should get in the inquiry. It starts. In the inquiry, having considered the statement submitted by the allotee, your lordships have that. It's para 27, running page 11.
I am there. Yes.
In the inquiry, having considered the statement submitted by the allotee during the hearing and the report submitted by the executive engineer, the arguments, the records, and examining the replies and written submissions submitted by the allotee, following facts are to be observed. Allotee defended the title of the board to the allotted property from 2008 as against the forest department till 19/11/2020. I'll pause here. ED went on saying, I did not develop, I have kept the land vacant. This Kadugodi plantation land was a subject matter of a writ petition before. Forest department claimed that it is a forest land.
That is why it was kept vacant.
Embassy had to take it up to the Honorable Supreme Court to get it cleared that it is not a forest land but a KDB land.
When was that cleared?
My lords, that is also, it is recorded, my lords. I'll just show that it's also, my lords, it comes at, my lords, para 10 at page 3 in that same thing, in the very same thing, my lords. Para 3, I mean page 3, para 10. It starts with the range forest officer, if your lordships have that, in the same documents.
Yes.
The range forest officer issued notice to Concord India on 6/4/2008 for unauthorized occupying 78 acres of forest land in survey number.
Anyway,
11.
when did it get cleared?
That, my lords, ended in the Supreme Court, my lords, in 20, my lords, around 2020, my lords. I'll just tell that about.
No problem.
My lords, I am told 2022, Honorable Supreme Court confirmed the division. So I had to fight against the Forest Department. That's all. Then if I continue, my lords, at page 11, para 27. Allotee has submitted an application to the board for approval for undertaking the project as on 23/5/2022. Thereafter, once again on 12/12/2023 by securing all the approvals from the concerned authorities.
So 2022 clear agide.
Clear agide Supreme Court forest anta. Then please see C at page 12.
Allotee has borrowed.
Borrowed loans with prior approvals of the NOCs of the board dated 3/7/2007 and 31/8/2019. The allotee have been undertaken site clearance so and so. In view of the foregoing observations, I am of the considered view to extend the time of 2 years to commence the project by the allotee on the condition that an undertaking be given by the allotee that all the monies taken as loan as against this property will be utilized for completing the proposed project by the allotee. So this attained finality. That's all what I wanted to show, my lords, to my lords. Of course, there is one more letter, the last document which may not be necessary, where I asked for sublease and also asked for a right to sell. Right to sell was not given. Now that is a subject matter. Now subsequently they have again resumed the land. I am fighting that separately. But to say, my lords, the entire, if your lordship sees 2/12/2025 letter of ED, except mentioning this, there is nothing else. Followed by 10/12, they only say that I have created I have entered into an agreement of sale. That cheats. My lords, if there is a breach, it is not. And my lords, as I submitted, I have given the compilation. Under the Transfer of Property Act, an agreement of sale does not even create an interest. Suppose, my lords, anybody has a grievance against that agreement of sale, it can only be LAM. LAM cannot proceed against KDB. LAM can proceed only against me only for specific performance. That's the law laid down by the Honorable Supreme Court interpreting Section 53 of PPA. If there is a breach, KDB has now taken action. That's all what I have to say.
That's different.
That's yes, my lords. That will. So there is no criminality attached to this. Is what I wanted to say.
That B report matter.
May I only take? I had undertaken to take not more than 10 minutes on that B report issue.
You want to submit in this again?
No, in the B report.
B report.
In the B report. In
Yeah,
this, my lord, my learned friend is not, as far as this case is concerned, whatever he has argued just now is his defense.
Yes.
Defense
So
is
it has
not
to,
to be
it has to be tested there only.
Defense is not to be considered at the stage of quashing. That is a well settled position. Second, my lord, no answer on what I submitted.
It's not my defense. I am saying their action is wrong.
Ella correct. Defense consider ಮಾಡಬಾರದು ಅಂತ ಯಾರು ಹೇಳಿದ್ರು 482 ಅಲ್ಲಿ?
But I'm
ಅದು
yet
only
to
in
catch
order
up on
7
my.
rule 11. That is civil 482.
Yes. Now, even in criminal quashing, my lords have held defense is not to be seen. Keep be that as it may,
Now
my lord.
Apex Court says everything has to be seen.
Very well.
See
My lord,
Muhammad Ali.
also
See Muhammad
there
Ali.
is
Yes.
yes, my lord.
Everything
Yes, my
has
lord.
to be seen.
As far as my submission on the consent and
No,
the
we'll
permission
consider
being
that. Not to consider
Lord,
defense is.
there is no response on that being a valuable security, on that being taken out from KIDB by fraudulent misrepresentation. There is absolute complete silence, my lord, on that.
All right. Yes.
Now, my lord, as far as
Now on the B report.
B report is concerned, my lord, I am non-suited only on the ground of locus.
Yes.
The order accepting the B report says this is a dispute in personam. When we send, my lord, file the application, the issues which were touching upon the mortgaging of these lands without the permission, zero investigation on that aspect. As far as locus is concerned, my lord, please have one decision.
That's all I want.
Please have
Judgment
some
on
decisions,
locus.
my lord. Yes, my lord. Please have, my lord. In fact, when a B report was filed and closure was ordered, the Madras High Court reversed that on ED's application, which was affirmed by the Supreme Court, and our case was permitted to be revived. My lord, may please have that. This is, my lord, volume 1, if my colleague may hand it over, volume 1. And across the country, multiple constitutional courts have held that ED has a stake and is a necessary party in the closure of the predicate offense. In any prayer for closure of the predicate offense, my lord, may I have page 113 for a moment. Volume 1, 113, my lord. Does she have?
It's already part of the report.
The other document compilation quote, I will not be visible.
Volume 1. I'm not sure, my lord, if. No.
ನಿಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
They gave a soft copy.
ಕೊಡಿ ಮೇಡಮ್.
It is filed on. Already.
ಅನುಪರ್ಣ ಹತ್ರ ತಗೊಳ್ಳಿ.
Straight away, I may say, my lord, if it's only on locus.
Only locus.
It's only on locus.
I will first hear on locus. If I find locus, then we'll go into the merits of the matter.
Locus. In this case, probably, my lords, in my respectful submission, I will not even canvass locus.
They have locus.
The reason, my lords, for the reason.
He may not canvass, but the trial court says ED has no locus and dismisses.
If they want to continue on that, my lords, on locus, my lords, the Bombay High Court took a view that ED does not have locus to file a protest. That in the SLP was rejected, ED's. Subsequently, the division bench, my lords, of Madras High Court has taken a view that they have locus. Now, in my case, my lords, even without locus, I will be able to show how the impugned order is sustainable.
So we'll not get into locus.
I think in this case, it's not necessary, is my respectful submission. Despite that, if they want to argue on locus, let them argue on locus.
I have a slightly different view because my learned friend cannot step into the shoes of the trial court and change the order because I've been non-suited only on locus. The trial judge says I will not look at anything you're presenting.
Impugned order says, my lords, in the meanwhile, the Directorate of Enforcement represented by the Assistant Director has filed the present petition seeking leave of this court. Answering it, my lords, at page 44, the Directorate of Enforcement has already initiated proceedings against the accused person or has an efficacious remedy to initiate separate proceedings. That is the finding given, and they had initiated separate proceedings. Now that covers the issue. Despite that, my lords, if they want to argue on locus, it's fine.
No, you're only on locus.
My lord, if the finding on locus is set aside, the trial court would be obliged to look at the material that we have filed before him. He non-suits me only on locus. Please see, my lord, the findings at page.
Then, according to you, we are not arguing on locus. If the trial court has rendered only on locus, it has to go back.
Not only on locus.
Yes, it has
my
to
lords,
go back.
I will point out in the present petition which they are arguing, it has to be dismissed on the ground of suppression of material facts. I will point that
Suppression by ED.
By ED. They don't, my lords, ED does not bring to the notice of this honorable court that they had given information under 66(2) to the concerned police station. They don't even inform this court that a second FIR was registered on the basis of information given. They don't tell this court that an ECR they have filed on the basis of the second information. three material facts suppressed, and they want to argue this on locus, my lords. I will point that out.
All these
Now,
facts are
whatever
there before this
information they've
honorable
given
court.
has resulted in a second FIR, has resulted in an ECIR. You suppress that and you say that first FIR, keep it open. Now, if that is their argument, my lords, then the second FIR will have to go on the ground of doctrine
No,
of
no.
sameness if they want the first FIR alive.
My learned friend doesn't permit me to open my case, applies doctrine of sameness on completely different FIRs, completely different events.
That's all
I
right.
certainly can't. I can't
We'll take
match
it
my
on
learned
Monday.
friend's speed. Monday,
This
Mulot,
matter
Monday.
is reserved.
Please.
This locus matter only will take it on Monday.
On Monday, my lord, as my lord
Monday.
pleases.
Monday, same time,
Same time, oblige my lord.
15 minutes.
15 minutes, my lord, not more
Yes.
than that.
Yes.
Now I'm getting used to the pace of the court, my lord. I'll be able to.
Appearances, Barcode error. Write it and give properly. Yes.
Oblige, oblige, my lord.
E kade also. This I think not a problem. ಬೇರೆ further ಏನ್ ಕರೆದು ಬಿಡಿ. ರವಿಶಂಕರ್ ಸರ್ ಯಾವ್ದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ದಾರೆ? Further hearing, I'll call.
Which is the other number? Let's even 3447 can be reserved. Probably.
Yeah, except this big
Yes,
B
because,
report
my
thing,
lord,
everything else is reserved.
3447 is the second ECIR.
Arguments are same. Yes.
Same.
Except this B report thing with Sandesh Chota sir is appearing at Matra. Only that will be listed on Monday. The remaining is reserved.
Two matters are on B report and two, my lord, are which are reserved, my lord.
Two matters
Only
on
one
B
matter.
report. Which is two matters on B report?
One matter which ED has challenged.
Only
Hey, you
ED.
have challenged, that's all.
Yes, and first is the challenge to our ECIR, my lord. First ECIR.
You made submissions on everything now.
No, my lord, that is the
first
first
ECIR, my
ECIR
lord,
which is connected with the B report.
If the B report is accepted,
Oh,
the first
B-
ECIR goes.
Which is that?
My lords, that is number
16675, my lord.
Mahesh, which are reserved now? You tell me which is that.
Last two are reserved, my lord.
And 3447.
Yes.
That's right. 101 and 3447 are reserved, my lord.
All right.
That's right.
Yes.
Deeply obliged.
that will go on that now.
Further hearing. Correct.
Further hearing. Number 50.
Please, my lord, the offense, my lord, under section, my lord, 28, 22 and 27, my lord. Covered by lordship judgment, my lord, in
Yavudu sir? 50?
The Santosh Hospital.
Santosh Healthcare. my lord.
Santosh Hospital.
Yes, my lord.
Suraj, ನಿಮ್ದು ಯಾವ್ದು ಅದೇನಾ?
Same.
I'm for A1 and A2, he's for A5.
ಸಂತೋಷ. Yes.
No Santosha.
Which is my judgment? Where is it?
Please.
Last later ಕೊಟ್ಟಿರಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ, ಸರಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
The memo on the last.
ಕವರ್ಡ್ ಅಂತ ತಗೊಳ್ಳಿ, ಮೆಮೋ ಜೊತೆ. Both co-accused. Same order.
Please.
Fifty-one.
Casablanca. We'll take it Tuesday. Tuesday or Wednesday. 21st.
52.
ಓ ಇದು ಸರ್ಫೇಸ್.
39 ಎಕರೆ.
ಎಸ್ ಸರ್. ಎಲ್ಲಿ ಅಫಿಡವಿಟ್?
ನಂದು.
ಅಲ್ಲ ಏನು ಬರ್ದಿದ್ನಲ್ಲ ಆರ್ಡರ್. ವ್ಯಾಲ್ಯೂರ್ ಯಾರು?
I'm appearing for the valuer, my lord.
Yes, sir.
Number 3. My lord, I'm tendering an unconditional apology.
Apology for what, sir?
ಇದೇ ಹೋಯ್ತಾ ಹಾಗಾದ್ರೆ?
Apology.
ಬ್ಯಾಂಕ್ ನವ್ರು ಹಿಡ್ದಾಕಬೇಕಷ್ಟೇ ಇನ್ನು.
Unconditional apology. ಕಾರಣ?
My lord, I'm a valuer of immovable properties.
But you have valued these properties also.
ಅಲ್ಲ, ನಾನು earlier affidavit ಅಲ್ಲಿ I've mentioned as entitled to value agriculture properties and plantation. But I'm a valuer of immovable
Sir,
properties only.
So you are not entitled to value movable properties.
I am
ಅಲ್ಲ, agriculture coffee plantation ಇಲ್ಲ.
ಅಲ್ಲ, ಈ ಪ್ರಾಪರ್ಟಿನ valued as a dry land. I'll take you to my
ಪ್ಲಾಂಟೇಶನ್ ಅಗ್ರಿಕಲ್ಚರ್ ಎರಡೂ ಮಾಡಂಗಿಲ್ಲ
ಮಾಡಂಗಿಲ್ಲ.
ಹೌದಾ? ಡ್ರೈ ಲ್ಯಾಂಡ್ ಏನಾದ್ರು ನಿಮ್ಗೇನು?
My lord, ಅದರಲ್ಲಿ ಪ್ಲಾಂಟೇಶನ್ಸ್ ಏನು ಇರ್ಲಿಲ್ಲ. It was in a depleted state. I valued it as a dry land.
Who permitted you to value, sir?
My lord, I am a valuer empaneled under Sarfasi Act.
Correct, sir. You are empaneled for particular purpose.
I am.
And why did you file an affidavit that you had? No, you can't get away with an apology like this. You are before filing it before a court of law.
My lord,
Nothing. Straight away perjury proceedings.
My lord, my father was on deathbed.
ಅಯ್ಯೋ ಅದಕ್ಕೆ ಸುಳ್ಳು ಹೇಳ್ಬೇಕು ಅಂತಿದ್ಯಾ?
ಅಲ್ಲ, affidavit ಅಲ್ಲಿ it was by mistake.
By mistake. ಈಗ ಅಲ್ಲಿ get into the issue. ಯಾವ ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ ಮಾಡಿದಿರ ಅವೆಲ್ಲ ಇಲ್ಲಿವರೆಗೆ?
ಇದನ್ನ ಹೇಳ್ಬಿಡ್ತೀನಿ. ಈಗ ಅವ್ರು ಬಂದಿರೋದ್ರಿಂದ ಹೇಳ್ತೀನಿ. ಇದು ಈ ವಿಚಾರ ಆದ್ಮೇಲೆ ದ ಮ್ಯಾಟರ್ ಅಪಿಯರ್ಸ್ ಟು ಹ್ಯಾವ್ ಕಮ್ ಅಪ್ ಇನ್ ಸಮ್ ಲೋಕಲ್ ಪೇಪರ್ಸ್. ಅವಾಗ ಕೆಲವರೆಲ್ಲ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಇವ್ರನ್ನೆಲ್ಲ ಕ್ಲೈಂಟ್ಸ್ ನ. ಪಕ್ಕದ 100 ಎಕರೆ ಇದು 39 ಎಕರೆ 2 ಕೋಟಿ ರೂಪಾಯಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಅದೇ ಆಥರೈಸ್ಡ್ ಆಫೀಸರ್, ಅದೇ ವ್ಯಾಲ್ಯೂಯರ್, ಅದೇ ಪರ್ಚೇಸರ್.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ that's the best thing.
ಸೇಮ್ ವ್ಯಾಲ್ಯೂಯರ್, ಸೇಮ್ ಆಥರೈಸ್ಡ್ ಆಫೀಸರ್, ಸೇಮ್ ಪರ್ಚೇಸರ್. ಇದು ನಾ ಹೇಳ್ತಾರೆ
ಬ್ಯಾಂಕ್ ದ ಸ್ಟಾಕ್ ಪರ್ಚೇಸರ್. ಬ್ಯಾಂಕ್ ಆಫೀಸರ್ಸ್ ಆಲ್ಸೋ ಐ ಆಮ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಲೀವ್. No, sir. I have you file whatever you want, sir. I'm going to write on the bank officials how they connive with these people and trouble all these people. Bank loan ತಗೊಂಡ್ಬಿಟ್ರೆ ಆಯ್ತು, finish. No problem, Vignesh. We have seen many of these things. Don't worry. This is a classic illustration of all fraud played by the bank. We'll see.
Conduct has to see.
Conduct ನಿಮ್ದು ನೋಡೋಣ ಸರ್, ನಿಮ್ದು ನೋಡೋಣ. 30 ಎಷ್ಟು ಎಕರೆ ಇದು? 39 ಎಕರೆ ಸೇಲ್ ಮಾಡಿರೋದು ಎಷ್ಟಕ್ಕೆ?
91 lakhs.
39 ಎಕರೆ 91 ಲಕ್ಷಕ್ಕೆ 3 ಲಕ್ಷ ಎಕರೆ.
There is no road, 24 kilometers, my lord. He walked and my lord, he given a valuation.
I'm producing a video photos ಹಾಕಿದೀನಿ, my lord. The
ತೊಂದರೆ ಇಲ್ಲ. We'll ask a crime to be registered and investigation to be done.
Yes.
Of what all the fraud that has taken place.
But the valuer is present.
What should I do with the valuer? The perjury proceedings ಅಷ್ಟೇ. Apology will not take away, sir.
My lord, unintentionally.
No, unintentionally.
My lord, I am a valuer of immovable.
Correct, sir. ಈಗ ಪಕ್ಕದ 100 ಎಕರೆ ಏನೋ ಮಾಡಿದಿರಲ್ಲ, ಅದ್ಯಾವುದು? ಅದು ಡ್ರೈ ಲ್ಯಾಂಡ್?
ಅದು Millards, both, it's a consolidated, like a one consolidated unit of 139 acres.
ಈಗ we will ask the production of all the valuations done by this man.
Collecting it.
Canara Bank.
Yes.
All valuations.
They're particularly.
Sir, no problem. We will dig into everything, sir, now.
This point out, my lord, in respect of my lord, my senior counsel is making mention in one matter. That issue, my lord, came before the Sonnet Court. Writ petition got dismissed. Writ appeal also, my lord, confirmed the order.
No problem, sir.
Now he can't connect, my lord.
ಏನು ತೊಂದರೆ ಇಲ್ಲ, sir. We'll connect everything, sir.
This matter, my lord, I have some submissions.
You please make your submission. I'm not stopping you at all.
Have it some other day.
ಯಾವತ್ತಾರು ಮಾಡಿ, ತೊಂದರೆನೇ ಇಲ್ಲ. ಯಾವತ್ ಬೇಕಾದ್ರೆ submission ಮಾಡಿ. Officials of Canara Bank will face the music, definitely.
My valuation report may be per
No, sir. You have uttered a falsehood by an affidavit before the court that you are eligible to value these plantation properties. How did you value without eligibility? And why did you file a false affidavit here?
My lord, affidavit ಹಾಕಿದಾಗ I was in distress, my lord. My father was not well. He was on deathbed. He has expired, my lord. Same month. I was in.
ಆಗಲ್ಲ ಸರ್, ಅವೆಲ್ಲ ಖಂಡಿತ ಆಗಲ್ಲ. ಫಾಲ್ಸ್ ಅಫಿಡವಿಟ್ ಅಂದ್ರೆ ಅದು ಕಂಟೆಂಪ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗ್ಲೇಬೇಕು. ಪರ್ಜರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ರೈಟ್.
My lord, apology may be accepted.
Apology will not be accepted.
2 paras of the
No,
affidavit.
sir, will not be accepted at all.
Beg, my lord.
ಏನಿದು ಕೋರ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಇದು ಯಾವ್ದು ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಅನ್ಕೊಂಡ್ರ ಅಪಾಲಜಿ ಹಾಕಕ್ಕೆ? ನಥಿಂಗ್. How can you support such people?
I'm not supporting, my lord. I'm supporting, my lord. My lord, the thing is, my lord, bank, my lord, there are 2 kinds of property we have. One is, my lord, surface wherein, my lord, movable and, my lord, land and building. One is, my lord, agriculture property. They have a separate value. In view of the, my lord, Ramesh judgment, in the plantation also, my lord, can be, my lord, sold under Surface Act. Therefore, my lord, I treated him as a surface, my lord, valuer.
ಅವ್ರಿಗೆ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇಲ್ಲ ಅದು ಮಾಡಕ್ಕೆ. They is not authorized to do that. How did you? How many properties have you got valued like this plantation, agriculture ಎಲ್ಲ? ಇವ್ರ ಹತ್ರ ಎಷ್ಟು ಮಾಡಿಸಿದೀರಾ? Get all the info. Produce everything that he has valued till now in Canara Bank. Agriculture and plantation. All right? We'll pass that
May-
order.
may-
I'll pass that order now.
I'll-
Produce
may-
everything,
may
sir.
make only one submission, my lord.
ಯಾವ್ದು ಕ್ಲೋಸ್ ಆಗಿದ್ರು ಪರವಾಗಿಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಎವ್ರಿಥಿಂಗ್. ಎಷ್ಟು ಜನಕ್ಕೆ ಅನ್ಯಾಯ ಮಾಡ್ತೀರಾ?
ಮೊನ್ನೆ ಆಗಿಲ್ಲ, my lord,
ಯಾಕೆ ಅನ್ಯಾಯ
no, no,
ಮಾಡ್ತೀರಾ?
my lord, my lord,
ಬ್ಯಾಂಕ್
219
ಸಾಲ
account-
ತಗೊಂಡಿದ್ದಾರೆ ಅಂದ ತಕ್ಷಣ 40 ಎಕರೆನ ಯಾರಾದ್ರೂ 80-90 ಲಕ್ಷಕ್ಕೆ ಮಾರಕ್ಕಾಗುತ್ತಾ?
This remote area, my lord. we are
What
not in the-
remote
we
area?
put up- Earlier also we put the property for auction very same price. We are not able to get the
ಏನು
buyer.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿದ್ಯಾರು 60 ಲಕ್ಷಕ್ಕೆ
Very same, my lord. value.
ಅಲ್ವಾ? 30-40 ಎಕರೆನ 60 ಲಕ್ಷಕ್ಕೆ ವ್ಯಾಲ್ಯೂ ಮಾಡಿದ್ರೆ ದಿಸ್ ಮ್ಯಾನ್ ಅಂಡ್ ಯು ಸೆಲ್ ಇಟ್ 30 ಲಕ್ಷ ಜಾಸ್ತಿ ಮಾರಿದೀವಿ ಅಂತ 90 ಲಕ್ಷಕ್ಕೆ ಮಾರ್ತೀರಾ?
You see, my lord, no fault can be found from the bank. The reason-
All fault will be found. No fault ಅಲ್ಲ.
My lord, video lo
No, sir, you produce everything before the contempt court. Perjury proceedings we will initiate.
My apologies.
No apology, sir. No apology. ಏನಿದು ಆಟ ಆಡ್ತಿದ್ದೀರಾ? ಸುಳ್ಳು ಹೇಳ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಏನೋ ಮೆಮೋ ಹಾಕಿದ್ರೆ ಬೇರೆ, ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಸುಳ್ಳು ಹೇಳ್ಬಿಟ್ಟು ಈಗ ಅಪಾಲಜಿನ.
Health issues also, my lord.
ನೋ, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Issues.
ಅಲ್ಲ, may request, my
All
lord.
that will not, ಈಗ ಎಷ್ಟು ಯಾವ್ದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಇವರು ಎಲ್ಲ ತೆಗಿಸ್ತೀನಿ ಈಗ. Everything will be removed. Plantation, agriculture. Give it, sir. ನೀವೇ ಹಾಕಿರೋದೆಲ್ಲ. You are approved valuer. All right?
My lord, lot of, my lord, the water flow.
Why, sir?
Some of the matters where they gone before the DRT.
Oh, you forget about this, sir.
No, my lord.
Now that he, one ನಿಮಿಷ, now that he is not qualified is an admitted fact to plantation and agriculture. ಇಲ್ಲಿವರೆಗೂ ಕೆನರಾ ಬ್ಯಾಂಕ್ ಎಷ್ಟು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿಸಿದೀರಾ? ಅಗ್ರಿಕಲ್ಚರ್ ಅಂಡ್ ಪ್ಲಾಂಟೇಶನ್, ಪ್ಲೀಸ್ ಪ್ಲೇಸ್ ಇಟ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. Place it before the court. How have you sold every person's property for a song or a stock purchaser is available, you sell it to him only? ಅದು ಯಾವುದು ಅಂತ ನೀವಲ್ಲ ಸರ್,
I'm sorry,
ನೀವಲ್ಲ,
Lord.
not you.
Yes.
Why are you?
No,
ನಿಮ್ಗೆ
for-
ಹೇಳ್ತಾ ಇಲ್ಲ
for a stock purchase, sir.
ಅಲ್ಲ, ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು. ಅದು ಬ್ಯಾಂಕ್ ಹ್ಯಾಸ್, ಯು ಆಸ್ಕ್ ಹಿಮ್. ಸ್ಟಾಕ್ ಪರ್ಚೇಸ್ ಹೇಳ್ತಾರೆ, ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತಾರೆ ಇವ್ರೆ,
Maybe
ಇದು
not
ಸೇಲ್ಗೆ
in this
ಆಗ್ತಾ
case,
ಇದೀವಿ, ಏನಾದ್ರು ಇದೆ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಅಂತ. ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡ್ಲಿ ಅವರು.
My lord,
ಇದು ತುಂಬಾ ಪಾಲಿಶ್ಡ್ ವೇ ಆಫ್ ಸೇಯಿಂಗ್. ಸೇಲಿಗೆ ಬರಕ್ ಮುಂಚೆನೆ ಫಿಕ್ಸ್ ಆಗೋಗಿರೋ
ಮತ್ತೆ ಎಲ್ಲ ಸುಮ್ನೆ ಸೇಲ್ ಅಷ್ಟೇ.
ಸೇಲ್ ಅಷ್ಟೇ.
ನೀವ್ ಹೇಳ್ಬಿಡಿ ಇಲ್ಲ ಅಂತ. Sir.
ಅಲ್ಲ, my lord, otherwise, my lord, how, my lord, it's a public money, it has to come back. The money which gone 2019
ಹೌದು ಸರ್,
SPA,
ಪಬ್ಲಿಕ್,
how to-
I'll tell you one thing, public money has to come back, not squeezing the blood of a private citizen. Not like that, public money should be taken, it should be taken true, to give the true value. Get the true value done. ನೀವು 10 ಕೋಟಿ ಪ್ರಾಪರ್ಟಿನ 4 ಕೋಟಿಗೆ ಮಾರ್ಬಿಟ್ಟು ಇಟ್ಸ್ ಟೇಕಿಂಗ್ ಅವೇ ಇಸ್ ಬ್ಲಡ್, ನಾಟ್ ಪಬ್ಲಿಕ್ ಮನಿ. That's why now Supreme Court has come heavily down upon
Particularly with reference
those
to
days are
valuation.
over now. They're not maintainable, not entertainable. I am in this jurisdiction, let me come there. Yes. Avaga, I will tell you.
My lords, one statement which the Supreme Court said with reference to Order 21, Rule 64, of course.
No, that
Said-
is auction ಆಯ್ತು.
Yes.
Even 8, 9 and interpret ಮಾಡಿ ಮೊನ್ನೆ ಬರ್ದಿದಾರಲ್ಲ.
That's true, my lords.
That
That is
you should entertain ಅಂತ.
Basumati's case. Justice
Yes.
Deepankar Datta's one judgment and the other judgment is.
ಅದಕ್ಕೆ
This,
ಏನ್ ಎಂಟರ್ಟೈನ್ ಮಾಡದೆ ನೀವು
ಅದೇ.
ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Lords, there, the Supreme Court used one phrase when the auction is being conducted in respect of a property belonging to the judgment debtor. Don't put the distressed person in further distress.
But that is what they do.
Essentially, what the
And
Supreme
this
Court
case
said.
is a classic illustration of that. 40 ಎಕರೆ ಕಾಫಿ ತೋಟನ 60 ಲಕ್ಷಕ್ಕೆ ವ್ಯಾಲ್ಯೂ ಮಾಡ್ತಾರೆ, ಈಗ 90 ಲಕ್ಷಕ್ಕೆ ಮಾರ್ತಾರೆ.
The neighboring 100 acres purchased by the same purchaser.
ಓ ಸೇಮ್, ಇವ್ರು ನೀವೇನಾ?
Same purchaser.
Two separate auctions, and may I only say this, my lord.
2
because this-
crores.
No, I'm sorry, my lord. This is,
100 acres 2 crores.
Crores.
lords, may I only say this, my lord, because some impression is sought to be created. Even in this auction, which is now under consideration by your lordship, there was a reserve price 65 lakhs, my lord.
That's correct. You are not at fault, sir.
My lord,
You are an auction purchaser. Reserve price is 65 lakhs. ಯಾಕೆ ಅಂದ್ರೆ because of this valuer who put it at 63 lakhs.
Now, my lord, that some impression is sought to be created. I'm compelled to say that there were 5 competing bidders. There were continuous
No,
bidding.
not the
and there
impression is not on the auction purchaser. ಆ 2 crores ಇವರೇ ವ್ಯಾಲ್ಯೂ ಮಾಡ್ರದ?
Same valuer. ಅದನ್ನೇ ಹೇಳಿದ್ದು. Same valuer, same authorized officer. And same auction purchaser. Only in this case. Remaining cases, there may be other auction purchasers.
No, but
Investigation
in
ಆದ್ರೆ ಅದೆಲ್ಲ
this
links
case, my lord,
ಬಂದ್ಬಿಡುತ್ತೆ
let
ಹೊರಗಡೆ.
there not be an impression sought to be created.
No, not for you. Will direct some kind of investigation to be done.
Make only one second, but we will have it on Monday. There is instruction for me to engage some senior counsel.
Oh, please, you should, sir.
ಅಲ್ಲ, ನನ್ಗೆ
ನಿಮ್ಮ ಮೇಲೆ ಯಾಕೆ ತಗೊಂತೀರಾ? ಕರ್ಕೊಂಬನ್ನಿ.
Kind of have it on Monday or Tuesday, my lord, whichever.
ಹಾ.
Take our submissions, my lord, we'll place all the, my lord, on the record, my lord.
Absolutely.
ಇವತ್ತೇನು ಆರ್ಡರ್ ಬೇಡ. Have it on Monday or Tuesday, my lord. We'll make
ಅಲ್ಲ
our
ಅದು
submissions.
ಇವ್ರು ವ್ಯಾಲ್ಯೂ ಮಾಡಿರೋದೆಲ್ಲ ಬೇಕಲ್ಲ ಮತ್ತೆ. Everything is needed. Yes, we'll record what he has done at least. ನೀವು ಎಂಗೇಜ್ ಮಾಡಿ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂದ್ರೆ.
ಇದರಲ್ಲಿ ಒಂದ್ ಬಹಳ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಅವರು ಇವ್ರು ಹೇಳಿದ್ರಲ್ಲ ನಮ್ಮ ಅರ್ಜುನ್ ಅವರು, ಅವ್ರ ಗಮನಕ್ಕೆ ತಂದ್ಬಿಡ್ತೀನಿ ಮುಂದಿನ ಸಲಿಗೆ. They passed a resolution at page number 23.
Who resolution?
The resolution of the purchaser. On 3rd January 2024, they passed a resolution saying that the company has purchased 39 acres of coffee cardamom so and so and authorized to sign all necessary documents to register the same anta madidru. The sale notice dated 19/12/23 fixed the auction on 24/1/2024.
ಅದಕ್ಕೆ ಮುಂಚೆನೆ ರೆಸಲ್ಯೂಷನ್
ಮಾಡಿ ಪರ್ಚೇಸ್ ಮಾಡಿ ಆಗೋಗಿದೆ ಅವ್ರು ಆಗ್ಲೇ.
I'll answer that.
Yes, you have to.
It is nothing.
That is why stock.
My lord, I will only say this, my lord. It is nothing but a typographical error. In fact, it is submitted to the bank. That's how my learned seniors client has it. It is submitted to the bank. I don't think, my lord, anybody intended to.
ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಕರೆಕ್ಟ್ ಮಾಡಿದಿರಾ ಆಮೇಲೆ?
My lord, I'll check, my lord. But the only
So
reason.
now we are in 2026.
No, and therefore my next submission that whatever my learned senior says now, there is not a single pleading, let alone even a letter.
So forget about the pleading, sir. We are.
My lord, there is nothing in the
don't worry about
petition about this, my lord. I don't have an opportunity to respond on affidavit.
No pleading.
Now to impute some meaning to some document.
Pleading ildene we should not hear. Pleading ildene we should not hear. Those days are over.
My lord, I am only saying this. They have produced a document which
Law
clearly
of,
they have
law
got from
of
the bank
pleadings
record.
itself is diluted by the apex court that ಎಲ್ಲಾ plead ಮಾಡಬೇಕಾಗಿಲ್ಲ.
I am not on that, my lord. I am not on that. I am on, my lord, whether if they just say this, will I have a fair opportunity to respond to it, my lord?
Of course, who said no? You always have an opportunity. Illandar bank has an opportunity. You have an opportunity. His opportunity is over that he has filed apology now.
It is a typographical error, my lord.
All right,
Somebody
sir.
want, my lord,
Correct,
ultimately
sir.
it's a-
Typographical error should
it's
be
a foreign
correct.
language.
It is now it is 2 years. You have not corrected that
I'll
typographical.
check, my lord, they would, but I will only say this, my lord. Somebody wants to participate in an auction. Company wants to participate. Now, my lord, some human being has to sign those documents. Some board resolution is required.
Resolution ಬೇಕೇ
Bank will
ಬೇಕಲ್ಲ.
expect. Something is required, my lord.
But
Now,
why did you say purchased?
my lord, it's a typographical error, my lord. These things happen. That's my respectful submission, my lord. Now to impute, my lord, something far more.
No, that's okay.
Without
We
anything else
are
than
not
this.
bothered about you. Leave it.
Under, my lord, no malice can.
Then I'll
So
leave
the
it at
reason is
that,
this: there are 5 bidder, 220 bid to place.
No
I will
problems.
permitted to place before this honorable court. My lord, no.
This court heard so and so like. This court on 17/6/2026 had passed the following order. It was clearly indicated that the registered valuer would was granted 3 weeks time to file his reply as to why proceedings for perjury should not be initiated against him. Now the registered valuer has filed an affidavit of unconditional apology. The unconditional apology reads as follows. The unconditional apology itself is indicative of the fact that he has, without qualification, valued property of the petitioner, which is a coffee plantation, and valued a 40-acre property at rupees 63 lakhs. And the reserve price was fixed by the bank on the said specious valuation at 65 lakhs, and the purchaser buys it at 90 lakhs. Therefore, the 90 lakhs. The affidavit was filed in a proceeding in the year 2024. After the said order on 17/6/2026, it appears that the valuer has realized that he did not have qualification to value the plantation that he has already valued for, and the bank having sold it for a song. Therefore, the affidavit of apology cannot be considered, and appropriate orders would be passed on the next date on the said apology. The learned counsel for the petitioner, learned senior counsel submits that the adjacent land of 100 acres was also the subject matter of acquisition, subject matter of auction, and the very same valuer had valued it at 2 crores, and the bank has sold it for 2 crores for the same purchaser. While at present nothing can be attributed to the purchaser, but the valuer who has valued 100 crores also at 2 crores has a lot to answer. The bank shall therefore place on record all the valuation done by this valuer of the properties that have been sold by Canara Bank of the borrowers, properties would be coffee plant, the plantation and agriculture properties by the next date of hearing. In Yavat Bek, sir?
Milord, have it, Milord, next week.
Sir. List on 17th.
Please, note that valuation was 1.5 crores, not 2 crores.
1.5 crores for 100 acres,
100
1.5.
acres.
Yes.
I understand they corrected it also, my lord, in the records. They
Parallel.
just said
So
that they
that's why I've
corrected
said
it.
nothing can be attributed to you now. We'll see. Yes.
My lord, my humble submission, I value it as dry land.
ಆಯ್ತು ನೀವೇನ್ ವ್ಯಾಲ್ಯೂ ಮಾಡಿದಿರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡುವ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡುವ ನೀವು ಎಷ್ಟು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಗೊತ್ತಲ್ವಾ ಅದನ್ನ ಹಾಕ್ಬೇಕಾಗಿತ್ತು
I wanted to say this, Milords. We did not have any materials to know what kind of valuer he was. Lordships directed to produce or directed the bank to say whether he is a qualified valuer or not. What the bank did, they called him and asked him to file an affidavit. He filed an affidavit saying that I am authorized to value the plantation land, so on and so forth. After he filed the affidavit, we applied under RTI to the
Correct.
wealth tax
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೋಟ್ ಮಾಡಿದಿಲ್ಲ
to take, because his affidavit was on the premise that we will not know anything about his qualification. After we placed his qualification before the court, he wants to now do a volte-face.
My lord, one humble submission, my lord. ಅವರು RTI ಹಾಕಿದಾಗ ನನಗೆ ಕನ್ಸೆಂಟ್ ಗೆ IT ಡಿಪಾರ್ಟ್ಮೆಂಟ್ has sent a letter to me for my consent and I've consented to sharing of my
ಆಯ್ತು
details
ನೋಡಿ
with
ನೆಕ್ಸ್ಟ್
them.
ವೀಕ್ ನೋಡೋಣ
Not did anything.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡೋಣ
I've been very honest and I've given my consent.
ಆಯ್ತು ತೊಂದರೆ ಇಲ್ಲ
In fact, Milord, it's a matter of
ನೀವು
fact.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಸರ್
It's a matter of fact. When I'm selling this property, Milord, when I put the property for second time, my officer, Milord, is Milord, approximately 20 kilometer, Milord, they walked and Milord, they're able to take this Milord valuation of the property through this valuer. In fact, I'll file an affidavit on that effect. So we took a lot of effort to sell this property.
ನನಗೆ
It's a
ಅದಲ್ಲ ಆಲ್ ರೈಟ್ ನೋ ಪ್ರಾಬ್ಲಮ್ ವೆನ್ ಯು ಗ್ರಾಂಟೆಡ್ ಲೋನ್ ವೈ ಡಿಡ್ ಯು ಅಸೆಸ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ at 3.5 crores why
that time, it was Milord well-maintained plantation. It's a fact. It's a fact. In fact,
Right.
my previous
Sari.
value.
ಅವಾಗ ರೋಡ್ ಇತ್ತು ಅವಾಗ ಅವ್ರಿಗೆ.
ಅವಾಗ irrigation.
ಅವಾಗ ರೋಡ್ ಇತ್ತಾ
ಅವಾಗ road, Milord, they, Milord, now.
ಅಲ್ಲ ಅವಾಗ್ಲೂ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡದೆ ಕೊಟ್ಬಿಟ್ರ ದುಡ್ಡು
Milord, I stated in my affidavit.
Diminished by 5 times, five times it is diminished. By divided by 5.
Milord,
$3.5 ಕೋಟಿ 2016ರಲ್ಲಿ ಇರೋ ವ್ಯಾಲ್ಯೂಯೇಷನ್
ಅವಾಗ plantation, Milord, it is well-maintained plantation. Irrigation is proper agi, Milord, there drip irrigation was there. That is the reason, Milord, my valuer assessed that value and given the valuation. No, nothing is there, abandoned. They taken a loan, Milord, they're not repaid, they're invested somewhere else, Milord, they abandoned the property.
No, that's all right. It's public money, I can know. But this is not the way to sell those properties.
But when there is plantation, the SR rate is 3.25 lakhs per acre. When it is dry, it is 1.5 lakhs.
ಯಾವಾಗ ಸರ್
ನಾನು ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದಾಗ
ಯಾವಾಗ ಸರ್ 3.25 per acre
SR rate ಅಲ್ಲಿ 3.25 ಅಂತ ಇದೆ ಸರ್ ಗವರ್ನಮೆಂಟ್
If it's a plantation.
if it is plantation cardamom plantation ಆದ್ರೆ ಕಾಫಿ ಆದ್ರೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ
ಅಲ್ಲಿ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ
ಏನು ಇಲ್ಲ
ಬಟ್ ಎನಿವೆ ನೀವು ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇಲ್ಲದೆ ಮಾಡಬಾರ್ದಾಗಿತ್ತು
ಅದಕ್ಕೆ ನಾನು ಡ್ರೈ ಲ್ಯಾಂಡ್ ಅಂತ
ಏನ್ ಡ್ರೈ ಲ್ಯಾಂಡ್ ಅಂದ್ರೆ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಬಂದ್ಬಿಡುತ್ತಾ
ಐ ಆಮ್ ಕ್ವಾಲಿಫೈಡ್
ಈಗ ಹೆಂಗೆ ಅಂದ್ರೆ ಅವ್ರದ್ದು ನನ್ಗೀಗ ಅವ್ರಿಗೆ ಏನ್ ಹೇಳ್ತಿದಾರೆ ಅರ್ಥ ಆಯ್ತು. ಈ ಪ್ಲಾಂಟೇಶನ್ ಇರ್ಲಿ ಏನಾದ್ರು ಇರ್ಲಿ ಅವ್ರು ಹೋಗಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿದ್ರೆ ಡ್ರೈ ಲ್ಯಾಂಡ್ ಅಷ್ಟೇ. ಚೆನ್ನಾಗಿದೆ ಇದು ಒಂಥರ
ಲೇಬರ್ ಲೈನ್ಸ್ ಆಲ್ಸೋ ಆರ್
ಎಸ್ ಎಸ್
ರೆಡಿ.
ಯಾರು ಲೇಬರ್ ಇಲ್ಲ
ಆಯ್ತು ಯಾವತ್ತು ಬೇಕು ವಿಘ್ನೇಶ್
Any date, next week, any date.
17th or we'll take it on 20th.
Please.
List on 20th.
Great.
Great.
Oh, that will continue.
Passed or matter? 26 is 2.
Manoj, may I request on
also for respondent number
ಪಾಸ್ ಓವರ್ ಯಾಕಾಗಿತ್ತು
my lordship, he said he will get senior.
ಸೀನಿಯರ್ ಬರ್ತಾರೆ ಅಂತ ಪಾಸ್ ಓವರ್
ಸೀನಿಯರ್ ಬರ್ತಾ ಇದ್ದಾರಾ 5:30 ಆಯ್ತು ಎಲ್ಲಿದೆ ವಿಲ್ ಅಲೋ ದ ಪಿಟಿಷನ್ ದೆನ್ ಏನಿದೆ
My lordship,
406.
406, 420, my lord, offense
Hmm.
registered. Now, my lord, that they should have filed a civil suit, my lordship. They have not yet filed any civil suit.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ
My lordship, there is no entry order.
there is
ಅದ್ರಲ್ಲಿದೆ
26.1
please.
in the light of the interim order subsisting in the companion petition, there shall be an interim order in the case at hand as well, solely on the score that the respondent complainant has not made his submissions. Yes.
Much obliged.
Next.
30 more, BB Ravi Shankar.
ಇನ್ನೊಂದು ಇದೆಯಾ
proceedings under 138 of the NI Act. Lordships may kindly turn to page 30. The check-in controversy was for rupees 4 lakhs, my lords. The check-in controversy, my lordships would find at page number 30. It is for 4 lakhs. Now, my lords, during pendency of the case, lordships may kindly turn to page number 47. There was a settlement which was arrived upon between the complainant and the accused. The matter was agreed to be settled for 4 lakhs at page 47, my lords. That is an agreement, my lords, entered into by the complainant.
You
and
are the accused?
I am the accused, my lords.
Settlement ಏನಾಯ್ತು?
My lords, 4 lakh rupees I have paid 3 lakhs, my lords. I could not contest the matter because of my age. I thought better I will settle the matter and I entered into an agreement. Lordships would find
ಈಗ
the
convict ಆಗಿದ್ದೀರಾ?
transfer of rupees 3
Convict
lakhs.
ಆಗಿದ್ದೀರಾ ಈಗ?
Convict ಆಗಿದೆ
ಹಾ.
solely on the ground that the documentary evidence is unchallenged.
So that's all right. ಈಗ
My lords, now I have filed an appeal. There is a
20%.
20% deposit.
ಮತ್ತೆ?
My lords, I've already paid 3 lakhs. Out of settlement of 4 lakhs, my lords, I've already paid 3 lakhs, my lords. I've already paid 3 lakhs. I've produced the
Petitioner to
bank
serve on
account
the
statement.
counselor represents the respondent in the appeal proceedings. Further proceedings before the concerned court shall remain stayed till the next date. List the matter on 22nd.
I'm grateful.
Yes.
Two matters, my lord, I have given a memo.
ಯಾವುದು?
The direction by the coordination bench to register an FIR. Even then.
ನಾನು ಸ್ಟೇ ಮಾಡಿದ್ದೀನ?
ಅಲ್ಲ, ತಾವಲ್ಲ. ಇನ್ನೊಂದು coordinate bench has stated. I have given a memo.
ಮಂಡೇ ಆಗ್ಬೋದಾ?
Tuesday, Wednesday.
Tuesday or pending matters. Oh, stay under pending matters. Tuesday or Wednesday.
Fresh matter.
Fresh matter.
My apologies, my lords.
ಈ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ ರೀಕಾಲ್
Hand delivery of the copy.
ಆಯ್ತಾಯ್ತು. ಬೆಳಗ್ಗೆ ಇಸ್ಕೊಳ್ಳಿ.
I'm grateful.
ನಿಮ್ದು ಯಾವುದು?
40, serial number 40, list number 1.
2 weeks ಆಯ್ತು.
ಬೆಳಗ್ಗೆ ಇರ್ಲಿಲ್ವಲ್ಲ ನೀವು? ಓ ಇದ್ರು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ 2 weeks ಡೇಟ್ 2 weeks ಬಿಟ್ಟು ಹಾಕಿದ್ದೀನಿ. ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಇದೇನ್ ರೀಕಾಲ್ ಮೇಡಮ್ ಇದೆಲ್ಲ? ಅಲ್ಲ, ಒಂದು ಏನಾದ್ರು ಮಾಡೆಲ್ ಆರ್ಡರ್ ಇದೆಯಾ ರೀಕಾಲ್ ಮಾಡಿರೋದು? The subject petition comes to be disposed on 18 September 2025. The revenue has filed an application seeking a recalling of the order. In the light of the judgment rendered by the apex court, alva? Judgment rendered by the apex court. The request to consolidate all matters before a particular bench. In that light, the order dated so and so stands recalled in all these cases. The matters be placed before the bench having roster. You're then 40. And respective dates ಹಾಕಕ್ಕೆ ಹೇಳ್ಬಿಡಿ. ಶ್ರೀ ಕೃಷ್ಣಮೂರ್ತಿ ನೀವೇನಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಂದು ಸರ್ವ್ ಆಗ್ಲಿ. ಅಲ್ಲಲ್ಲ, ಅಪಿಯರ್ ಆಗ್ಲಿ ಅಂತ ಅಡ್ಜನ್ ಮಾಡಿತ್ತು. ಸಣ್ಣ ಪ್ರೇಯರ?
To call for entire records in criminal petition 103 of 2020 on the file of additional city civil sessions judge CH-14.
ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ. ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ.
Sir, to call for entire records in criminal petition 103 of 2020 on the file of additional city civil and sessions judge CH-53 at Bangalore, and to call for entire records in PCR number 19018 of 2012 on the file.
ಇರ್ಲಿ, ಏನ್ ಬೇಕು ಈಗ ಅದಕ್ಕೆ?
ಅದೇನಂದ್ರೆ ನಾನು ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟರಿ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನೋ ಅದರಲ್ಲಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಿಸೋದಕ್ಕೆ ಅಷ್ಟೇ.
ಆಯ್ತು, ನೋಡುವ. ಈಗ ಬರ್ಲಿ ಅವ್ರು, ಒಂದು ಚಾನ್ಸ್ ಕೊಡುವ. 2 ವಾರ ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ. 3 weeks. 30ನೇ ತಾರೀಕು ಬನ್ನಿ. ಅದು SPP ಅವ್ರು ಹೇಳಿದ್ದು ಯಾವ್ದು? ಟ್ಯೂಸ್ಡೇ ವೆನ್ಸ್ಡೇ. ಟ್ಯೂಸ್ಡೇ ಬೇಡ, ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿ.